You're muted. All right, guys. I don't know what's going on that side, but um, I am going to.
There we
Looks
are.
like we're starting with court stuff. I think.
Yes, we're starting with court stuff. The first video we're gonna do is something that we've already kind of seen. We started, I think, like maybe last week or maybe wait, today's Saturday, so it could even have been earlier this week. I don't remember, but we had watched it and it was like only like a 15-minute video and it cut off. It was complete clickbait because we didn't get to hear anything that happened at, like, we didn't get to hear the ruling,
Oh,
the
that's right.
the
Yeah.
title of the video that we had before. We didn't even get to like to that climax of the why the video was called what it was called.
Right.
But lo and behold, because I add stuff to this playlist religiously, we actually have the same court case just prepared by a different YouTuber. So, and this one, of course, too, has a different title, which is probably why I didn't even catch on to that it was the same people. But we're gonna start with that. And so the previous video was basically saying that the father got custody, and this one is the judge doesn't buy mom's fake friend story, which from the video we watched, that only seemed like a part of it because she wanted that this so-called friend to be part of supervised visitation, which just seems really fucked
Doesn't
up,
make
to
any
be honest
sense.
with you. Yeah, just, and it's also someone that the dad doesn't like really know like that. So it's super weird to want a male friend, quote unquote, to do your visitation. And if I'm not mistaken, this is a young child too, right? It wasn't this is not like a 3 or 4 or 5 year old or something. I think it's like an infant, or not infant, but within a year. Is that an infant, a baby, whatever. So anyway, yeah. So we're gonna start off with this video, and then um, I was gonna say, like Jingle All the Way, Court All the Way. We'll see. We're trying to knock out some of these court videos, so because we have a lot of them.
Yeah, we have a lot going on.
You are watching a
A lot
master.
of court stuff going on. So yeah,
We would
we've
just want to get
collected a
through
lot.
them.
You
So
I
we'll
only
try to
found out today.
get some of these finished.
Like I said, knock them out. Just we don't, we just don't know what we're gonna get with these sometimes. We don't know
And we
how
never do, guys. We never do.
exciting they might be or dull. And we only skip or change videos like if it's absolutely necessary.
Right.
So, all right. All right. So, let's get this stuff. And I like that it's in the proper Zoom format cuz that last person did not have it in the proper Zoom format and it drove me crazy. Let's see. And maybe we'll miss something we didn't hear the first time. Fun
Right.
times.
That I am the father of the child.
Who is your friend?
Christopher Whitley.
Your partner?
No.
Uh,
It's a family friend, yes. He insinuated the paternity of the child, and from there,
This is a fully contested petition to establish the parent-child relationship. So I'm going to call Miss Mayfield again. Miss Mayfield, can you state the name and age of your child?
Baslima Mayfield, she's 6 months.
And who is the father of this child?
Charles Jones.
And were you ordered to take DNA test?
Yes.
Your Honor, may I share my screen?
Yes, ma'am.
Miss Mayfield, do you see this DNA test?
Yes.
Do you see your name?
Yes.
And do you see your child's name?
Yes.
And Mr. Charles Jones' name?
Yes.
And you see here where it says the probability of paternity is 99.99.
Yes, ma'am.
Your Honor, may I stop sharing my screen?
Yes.
This was recent.
State would like to offer this paternity test as state's Exhibit A.
States of A is admitted.
Thank you. Ms. Mayfield, how's your child covered for insurance?
She's covered through Medicaid.
Ma'am, are you asking to be named sole managing conservator?
Yes.
Why are you not in agreement to be named joint managing conservators with the father?
Because since my pregnancy was confirmed, Charles Jones has not been involved emotionally, physically, or financially, up until this present day.
Do you two communicate amicably?
No, the last conversation that we had was when he insinuated the paternity of the child, and from there, I was blocked on his social medias. So we haven't had any contact at all.
Are you in agreement to designate the child's primary residence in the Dallas and contiguous counties?
Yes.
Okay. Are you in agreement for the father to have the state standard possession?
Can you clarify what that means?
Are you in agreement for Mr. Jones to have visitation with the child first, third, and fifth weekends of the month from Friday 6 p.m. to Sunday 6 p.m.?
Only after supervised visitation is occurred, yes.
After supervised visitation has occurred,
Yes.
do you have safety concerns with Mr. Jones?
It's just for the betterment of the child because they don't have a relationship at all, and she's still so young. So I would want that consistency to be established first before, after the visitation on his own.
How old is your child?
She's 6 months.
So you're wanting to have step-up visitation for some period before Mr. Jones can have the state standard?
Yes.
Okay, for the visitation, who would you like to supervise the visitation?
It could be myself or my friend if
I'm sorry, not to be funny, but if you're saying that you don't get along with this person and that they've not been around since you've told them that you were pregnant, why would you want to be the supervisor of the visitation so that you can
That's a good question.
have conflict and argue or fight in front of the kid?
Right.
Or to have another man supervise? Like, do you want, it's like, are you looking for a conflict? And if I'm not mistaken, she asked for like a ridiculous like amount of time for the visits to be supervised.
Right.
If there was no court proceeding, right, a father would have access to a 6-month-old.
Yeah.
So why would it need to be supervised? That just doesn't, and she's young, so she isn't going to know what's even going on to some extent, except for, I guess that forming that parental bond with her dad. But
Right.
she's not going to remember it
No.
or remember like that process. So why is it for the betterment of the child? Like, it would seem to be more betterment for the child to form a bond with the dad.
Yeah.
It just that part didn't make sense to me last time. It just seems so weird
Yeah.
and manipulative, but a different type of manipulative. She looks like a sly manipulative person.
Mm-hmm.
I didn't need to be there, so it could be either one of us.
Who is your friend?
Christopher Whitley.
Your partner?
No. It's a family friend. Yes.
Is this someone that Mr. Jones is familiar with?
They've met before, but this is also someone who is kind of in the parallel of how much time I spend with her. They spend that just as much time with her, and they pick her up from daycare, all those things. So they pretty much know her routine and everything.
Do you have someone else like a parent or another competent adult that Mr. Jones is more familiar with?
No, that's been the only person that he's let set eyes on that he's familiar with or aware of.
So Mr. Jones doesn't know your parents or any siblings of yours?
No.
And
Okay.
that's weird too.
And for this supervised visits, would you be in agreement to do maybe Saturdays from 12 to 2 for a month?
Mm,
He said a month. How we go from a month to
can we
years?
extend the time frame?
Okay. Can you explain what you're envisioning then?
Because I'm really going in blind, so I don't really know how consistent or not that Charles Jones would be. So I would feel more comfortable at minimum to a year or 2 years.
Going in blind.
You want him to have visitation Saturdays 12 to 2 for 2 years?
Yeah.
That's a long time.
And supervised by your friend. What's your friend's name?
Christopher spelled ChristopherPher.
You can kind of tell her the wheels are spinning.
Willie.
2 years. I think that's why she keeps asking, like in different ways.
Yeah.
And where would you like for this visitation to occur?
It can be any neutral place, like a park or Katy Trail, wherever. It doesn't have to be like one set place every single time, just a neutral place.
Is there a place by your house, like a park, that you would be comfortable with?
I live near the Katy Trail. That's like the closest thing I can think of.
Katy Trail Park.
Mhm.
Okay. Would you be an objection after the child turns a year for Mr. Jones to have an overnight visit?
Not if consistency is shown, no.
Has there been acts of family violence between you and Mr. Jones
No,
in the last 2 years?
no.
Do you have any safety concerns if Mr. Jones has your address or phone number in today's court records?
No, not anymore. I don't know if he still has it at his disposal or not, but no.
Okay, so your main issue with Mr. Jones having possession and access is you'd like for Mr. Jones to get to know your daughter more.
Yes, because
And it's not because,
I'm sorry, go ahead.
and it's not because you have safety concerns.
No, it's just simply establishing that because the last that I was made aware of by him was that he wanted absolutely nothing at all to do with her. So
Okay, so-
I was just, yeah.
So just to be clear, you're just wanting to establish a routine, and then after a routine is established, then you would be in agreement to the state standard possession.
Yes.
Okay. Are you in agreement to a change of last name to Jones for the child?
I'm okay with a hyphenated last name.
Wow.
So you would be in agreement to do Mayfield Jones?
Yes.
The father currently works at $8.25 an hour, and the state calculated his gross income to be $1,430. State's asking to set child support at $236 a month beginning September 1st, 2025. Are you in agreement to that?
Yes, that's fine.
And the state's asking to set cash medical at $129 a month, beginning November 1st, 2025. Are you in agreement to that?
Yes.
You're asking for retroactive child support for 7 months, is that correct?
Yes.
7 months.
The state calculated that to be $1,652 to be repaid at $60 a month beginning November 1st, 2025. Are you in agreement to that? Are you in agreement to a repayment of $60 a month?
Yes.
Got locked up.
Okay. Pass the witness.
He don't make that much money.
Mr. Charles, can you please state your full name?
Charles Jones.
Mr. Jones, did you see the DNA test that I showed earlier?
Yes.
And you saw the probability of paternity was 99.99%?
Yes.
Sir, are you in agreement for the child's name to be changed to Mayfield hyphenate, a hyphenated last name Mayfield Jones?
Yes.
So you're currently working at $8.25.
That's why.
Yes.
Do you have access to reasonably affordable health care at your current job?
No.
Okay. And so you're in agreement for the child to be continued on the government medical plan?
Yes, for now.
Interesting.
Are you in
8.25
agreement
an
for
hour.
cash medical to be repaid at $129 a month, beginning November 1st, 2025?
Yes.
Are you in agreement to pay child support in the amount of $236 a month, beginning November 1st, 2025?
If he works a 40-hour week, he only makes $330 a week.
That we have to connect Gen AI customers.
And that's
we
like, I'm
basically
guessing
need to
before
put more
taxes
optical
and everything
capacity.
withdrawn. Isn't that crazy?
Yeah, he doesn't make that much.
Yes.
Okay.
How's he going to survive?
7 months of retroactive child support was calculated at $1,652 to be repaid at $60 a month beginning November 1st, 2025. Are you in agreement to that?
No.
Have you given the mother money towards the child in the last 7 months?
No.
And why are you not in agreement to pay retroactive child support?
I only found out today that I am the father of the child. I have had no contact with Ms. Mayfield since the start of her pregnancy.
That's a fair.
And
Year and a half. Huh?
seeing that I just found out that I am the father, I will do my job. But also, I was going through the process with the Attorney General's office, only to just now find out that I am the father when I asked many months ago to get that done.
Mr. Jones, when Miss Mayfield became pregnant, did she notify you?
Yes, she did.
Okay. Is there any reason that you did not get a paternity test yourself?
Did you see his income?
Probably couldn't afford it.
No.
Just so we're clear, did you make any attempts on your own to obtain a paternity test?
No.
Okay.
This was the earliest.
Okay. The mother's asking to be named sole managing conservator. Are you in agreement to that?
Can you please explain what that means?
So managing conservatorship would mean that Miss Mayfield would make the decisions for the child. by herself?
No, I would like joint.
You would like to be named joint managing conservators?
Yes.
If I'm paying for it, I'm
Okay.
helping it.
Yeah, I mean,
Since
that
your
makes
child
sense.
was
I mean,
born, have you been making decisions already with Miss Mayfield?
No.
Because he didn't know it was his kid.
Do you interact with the child before today?
He's never
No.
seen her.
Do you feel that you're able to communicate effectively with Miss Mayfield?
Yes.
You are? Do you
Yes.
currently communicate with her?
No.
fair enough.
He just found out that he's the
Are you
father.
in
Like,
agreement to have supervised visitation
See,
with the 6-month-old?
hold up. Can you pause
No.
a second? Okay. So, in my opinion, right, if he's just
mm-hmm,
now finding out that he's a father, right, the rest of the
mm-hmm.
questioning is irrelevant.
I'm assuming she's asking on for. I agree with you, but I'm assuming she's asking for things to be on sort of on the record to show that, like, you know, um, that nothing was done before, you
I
know.
mean, I
But
understand it. Which,
understandably, but like women can say that somebody's the father of their child all day, every day, but when you have someone, first of all, that does not make that much money to begin with, and believe it or not, even though um the cost of living in Texas is different than, let's say New York and California,
right,
um I can say that $1,300, give or take, a month is not a lot of money.
no,
Like, I I was living off of my student refunds, which was not giving me money per month, but a larger chunk. And my rent was like $800.
yeah,
So imagine if he's spending like $800 on rent and has to commute to work.
right,
Like, but let's not even forget that you have to pay a water bill even if you live in an apartment in Texas.
yeah,
Luckily, I don't have to pay water bill here. Um, and electricity bill. Like, he probably has nothing left over from his checks every month.
no,
So who's paying for a paternity test? And he said that he asked for one months ago. They just now did it.
yeah,
Like, I think it's completely irrelevant for her to ask all those questions. And you know what? If he blocked her, he had every right to probably block her. She was probably being belligerent and acting stupid. And I'm starting to think there wasn't even a relationship. She
right,
just got knocked up.
right,
Because somebody that's in a relationship with you is not going to block you on Facebook,
no.
right? Unless you get in like some big
Unless you're
ass fight
being
or
belligerent
whatever.
to them, but I
I
mean,
don't know.
yeah,
I guess we're gonna see, huh? We want to see how more irrelevant this gets. Are you ready?
I was ready. I'm gonna get.
Uh-oh. Did we lose game? Game.
I'm here. I'm.
Game.
Hello.
Hello. Did your camera freeze or
Check.
game? Hello.
One moment.
There we go. Welcome back.
I've been here the whole time. I've been responding. Can you hear me?
I was about to call you.
Can you hear
Because
me?
the way I can hear you, the way that that it was frozen, like literally scared the shit out of me. I was like, did he pass out?
No, I'm fine.
I know. I'm saying the screen, I think, froze, and so the way that you were like on the screen freaked me out. Like I had my phone in my hand, and I was literally about to call you.
Yeah. Sorry about that, guys. We had a technical issue. Got that corrected. Don't know what was going on.
It's all right. It wouldn't be us if there wasn't an issue, right? All right, let's get back to this.
You're asking to have the state standard possession?
Could you please explain what the state standard possession is?
You're asking to have possession of the child the first, third, and fifth weekends of the month from Friday, 6 p.m. to Sunday, 6 p.m.
Yes.
Are you familiar with the child currently?
No.
Have you spent time with the child?
No.
Do you know anything about the child's routines?
No. I do not
Okay.
know anything, as I have not
Okay.
had contact with Ms. Mayfield in over a year.
Okay. Would you be in agreement for a step-up gradual visitation and then leading into the state standard possession?
Yes, for 1 month.
Smart man.
You want okay. Would you be in agreement for supervised visits from, let's say, 12 to 2 for about a month?
What does he need
Yes.
supervised for?
Okay.
Whatever.
Do you have someone that you feel comfortable to supervise these visits?
Yes.
And who would that person be?
Due to a security issue, I would like to ask that this be done offline, as this person, their information is private.
Offline as in private between me and you?
Yes.
So you don't want to state the person's name publicly for safety purposes?
Yes, not publicly.
You can't do that, sir. We're in a public hearing here.
Would you be in agreement for Christopher Willie to supervise the visitation?
I do not know that individual. I met him in passing one time.
All right, would you be willing to have your visitation at the Katy Trail Park?
No.
Where would you like to conduct your visitation?
Either in the home of Mrs. Mayfield or my home.
Okay. You would be in agreement to do supervised visits at her home with her for a month on Saturdays, 12 to 2, before you go to the state standard possession. Is that correct?
Yes.
Okay.
Okay, if there's one AI site builder you need to meet,
That's
this is
crazy
Dope Tech
that
from
you
Wix.
you can't get protection to not use somebody's name.
Not in a public hearing, no.
Also, just some clarification for my supervisor or individual that I would like supervised. She is a federal employee, which is why I'm asking for the privacy and security of it not being public. I'm sorry, not federal, county employee.
Sir, would you be in agreement to communicate with Ms. Mayfield using App Close?
No.
Why? What do you not know what that is? I don't think he knows what that is, lady. Explain it.
Okay. I passed the witness, Your Honor. I'm sorry. Today's court costs are billed to you today. Are you in agreement?
Yes.
Oh,
I
God.
pass the witness, Your Honor.
With what money?
Okay.
I'm sorry, y'all.
All right. We're established
No,
with attorney.
I was gonna
There's
ask
no
the same question.
private
I was
health
gonna blurt
insurance
out the
available to
same
either one of
thing.
you at a reasonable cost
With
at this
what money?
time. We're doing government medical insurance for the child. Y'all reported there's been no family violence in the last 2 years. Neither one of you requested a non-disclosure of your address. We're doing a name change to Mayfield-Jones. One of you will need to take a step after this. Either one of you will need to take a copy of this order to the birth certificate office for them to change the child's name. It won't be done automatically, but this will authorize them to do it. So you'll need to do that. You might need to get a certified copy. I don't know. It's up to them.
Which means
But
the
you have to
dad's gonna
take the
do
extra
it.
step. And that third step would be you need to go to the Social Security office after they change the name and give you a new birth certificate. Then you will need to change Social Security information as well. As far as medical support, it's going to be $129 a month. And child support is going to be $236 a month.
God damn.
The child was born, what, 6, 7 months ago, not today. So I understand you may not have known the results, but today's not the child's birthday. So you're responsible for the time from when the child was born through now. I understand you wanted to wait till you want to do DNA test and get the results, but you were the father when the child was born, not today. So you're responsible for any back child support that's due and owing. You have a judgment of $1,652 payable
Yeah,
at $60 a month until paid in full. Y'all got to figure out how to way to communicate better than you have before. I understand you had some issues, and obviously, Mr. Jones wasn't sure if he was a dad, so that's part of the issues. The wife had communication issues. Y'all have got to work out how to communicate with each other better. Now that we know who the dad is and that y'all are going to share responsibilities of raising this child together. Because there hasn't been any, I'm appointing Ms. Mayfield as a sole managing conservator. Other than the unfamiliarity with the child and the father, I don't see a reason for there to be supervised visits. I know it's a young child, so we're gonna kind of do a phase-in visits, primarily because of the age of the child, not because of anything else. And it needs to be very frequent, because the child is young as well. Doing it every other week, doing it with a supervisor is probably not gonna help. It's not gonna help the child being familiar with Mr. Jones. So, what I'm ordering is some small phased-in visits before we get into the whole weekend visitation. Again, it's not supervised. Okay, so beginning this weekend, October 18th, which is Saturday, these are going to be Saturdays here. October 18th, October 25th, and November 1st, Mr. Jones will have the right to pick up the child from 12 and have the child until 4 p.m. So be 4 hours of visitation, or 3 visits. 3 visits have to be completed until you move to the next step. Hopefully, you'll be doing it here in these 3 dates. Uh, Mr. Jones needs to know where you live, Ms. Mayfield. He'll be picking up the child. I understand the child will probably cry when the child leaves because the child's young and doesn't know him, but the only way we can make this happen is for him to be there, for him to have alone time with his child. So it's either those 3 dates or 3 visits. So if you miss a date, you got to make it up another day. Then after the 3 visits are completed, it's going to be November 15th, 22nd, and 29th. And it'll be for 8 hours from 12 to 8 p.m. And that'll also be for 3 visits. So either these 3 dates or 3 visits. As I said, I want you to try to do it consecutively so that we can make this child aware of who their father is and be comfortable. After those visits are completed, then we're going on starting the standard visitation on December 5th. The standard visitation is from Friday at 6 until Sunday at 6 every other weekend. Then the holidays are split up in the order as well. Um, Very important, like I said, that you visit as often as possible. Mr. Jones, you need to make sure you step up now. Now that you know you're the dad and you got responsibilities for this child, I want you to be visiting often. And that's the only way we can get this child to be comfortable with you. I'm not gonna, like I said, I'm not doing supervision. Um, because supervision is basically be like Mr. Jones would be a guest with somebody that the child knows. That's not really visitation alone with Mr. Jones. I don't know why I don't know each other's families. Usually, what we do is maybe have a parent or a sister or somebody like that be a supervisor if that's the case. But I guess y'all didn't get that far into that. But I don't, I mean, if Mr. Jones there haven't been any family violence issues. Y'all just haven't known who the father was for sure. As far as Mr. Jones was concerned, maybe that was the major issue. We got to move to the next step now. Now we know for sure. And I think I hear Mr. Jones wanting to visit. So let's make that happen.
I understand.
This holiday
I understand
season,
Mr. Jones' spot though.
Sugar artist.
Yeah, same
I
here.
do. But I understand the
Make
judge's
sure my
point
notes
too.
if I did everything.
The child wasn't born
Yeah.
Yeah.
now. The child was
Um,
born 7 months ago. So makes sense to me.
I kind of like how she is not getting what she wants.
At all.
But that other video was clearly clickbait because it said that the father got custody. It's not that he got custody. It's more of, she just didn't get to strong arm the situation and he
Nope.
get, like why would you even want your child to have 2 years of visitation for 2 hours? What, 2 hours every other week? Like, how is the child supposed to bond with somebody for 2 hours every other week? That doesn't make sense.
Yeah.
cost bill to Mr. Jones. All right, the Attorney General's office is going to draft this order. I'm not sure if they're going to get it to you, hopefully by Saturday, but just understand this Saturday is going to be from 12 to 4. That's all you really need to know for now. And then y'all need to open up your lines of communication. So unblock each other from your phone numbers, get each other's email addresses. I don't care if you have social media. If you want to block the other person from your social media, that's fine with me. That's not what I'm talking about. But you should have each other's phone number. You should know each other's addresses. You should know each other's email address. Those 3 things aren't that difficult for us to know. Mr. Jones, do you already know that information now?
No, I do not.
Okay. Ms. Mayfield, you want to put it in the chat to Mr. Jones instead of me have you read it out in court? You can just put on chat and then just pick him as the only recipient and put your address in there. And then Mr. Jones, do the same just to be, why don't you do both at the same time and then we can both be done. Your address and your phone number, put it in a private chat to each other and then we'll write that down before you leave.
I don't see his name as an option to
You can pick
select.
somebody. Let me walk you through, Paula. On there, it'll say new chat with a plus sign. Do you see that?
No.
Your Honor, I'm also happy to take them into a breakout room together to exchange the information if you would like.
Let me see if this works first. Y'all see where it says, did y'all click on chat on the Zoom?
Mm-hmm. And it's still showing me the same thing.
Did you hit, does it say everyone in new chat as an option?
Just like, look, let me
No,
teach these
it
young
just says
kids.
everyone.
Okay,
It's a drop down menu, lady.
It is
Drop
drop
down
down.
menu.
Yep.
okay. You're the same thing, Mr. Jones? You don't see it either?
I don't see it either, sir.
Okay. All right, well, hang around just for a minute after we get done here. Let me finish up the court hearing, and then we can do that because you need to know that for this week. All right, so the Attorney General.
Oh, so they ended it right there. All right, so I mean, we got at least something right out of it. We got something more than we did last time.
Right. So.
All right, so we are going to. Okay, so we're gonna just start from the top.
Yes. Yeah.
The first one is gonna be kind of hefty because I'm assuming it's gonna have multiple hearings. And then the next one is long, and then there's a bunch of short ones, couple of short ones. So
Okay.
we'll see how this goes.
Chex Party Mix.
I wanna just like
Sharing
explain
that holiday
something else.
feeling never gets old.
Oh God, we're gonna get stuck with Christmas commercials. I
It
just
is that
kind of
time
want
of
to
year.
add that for this first case, which was added a very, very, very long time ago. So it's just kind of a coincidence. But one of the last times that we did he did a stream, I did a recording. We saw a a commissioner that looked super familiar. And I had said that I was gonna like look it up later on, which I did. The minute that we ended, I did my research, and it just so happens that this commissioner is actually a family court attorney also. We didn't know that you could be in both roles, and looking at like the dates, it seems like she was a commissioner, I think, and an attorney at least in the same year.
Right.
I don't understand how that works, how you can sort of be like, I guess, like a judge and an attorney. Well, I know judges are usually were attorneys first, but I was definitely not familiar with them being in that role at the same time. So it just so happens that, and we've seen, like I said, we've seen cases with this commissioner slash attorney before. So it just coincidental, I guess, that we have like another case with the same woman. And I think Game would agree, she is a really good attorney.
Yeah.
And now we know why. It's because she's a
And
judge.
yep, because she was
She
a
she
a commissioner and a judge and yeah.
she knows clearly with that type of knowledge, she knows what what is needed
Yep.
and what's okay and not okay. And
Right.
she's very on top of her shit.
Right.
I think that's the best way to put it. Also too, from the ones that we've seen her, she usually defends. We've seen her represent the father. I don't know if she's representing the father in this. Actually, I'm just, you know what? We can gather from this title she is representing the father, because the title is Attorney Baldwin accuses mom of unhinged and manipulative behavior, abusive use of conflict. So, um, she represents the men. It looks like I don't know if she ever represents females, but everything that we've seen so far, she's been on the father's side. So
And we like
I'm,
we
I'm
like this particular welcome to legal stuff. Legal stuff is the
yeah,
name of the people dealing with the little happy faces and stuff. We
because
do
they're very
try to
thorough.
read them during the case, but sometimes we miss one or two. If we miss one or two, feel free to
Well,
read them yourselves,
sometimes
please.
yeah. Well, sometimes sometimes they're on screen long enough for me to pause and read it, but sometimes they're also it's sometimes it's short too.
Yeah.
That's that's what I do, and I don't know if you realize that. I read the long ones, but I sometimes skip the short ones because they flash on the screen, and it's not that hard
Right.
to read. And people can rewind my video, and they can pause your stream,
Right.
so if they want
So
to read
yeah,
it.
feel free
Maybe
to
we should
yeah.
maybe we should like kind of like hesitate on pausing to read them sometimes, because they're there unless we are trying to read it, because sometimes they go by too fast for us too. So
Yeah, and I'm
um
just saying they're available for everyone to read if you like.
plus this is also a 4 hour long
Yeah.
video, so we
It's
don't want
going
to
it's going to take
stretch
a
it out
minute.
way too. Then we don't want to like stretch it out way, like, we want to get in as many videos as we can today, because we're trying to get this list cut down. But it keeps growing. So, all right, let's get this party started.
We have a video problem. Just saying.
You have a video problem? What happened?
No, I just said we have a video problem. They keep growing.
It's my fault. I take full responsibility. Here we go.
Welcome to Looking at Legal Stuff. Today we have 13 hearings in a case of an extremely high conflict couple, where we join the case as they're finalizing a temporary parenting plan. But 9 months after that finalization, Dad returns to motion the court for adequate cause to change that parenting plan, and this time he brought a lawyer. He has a laundry list of claims against Mom that include that she has a boyfriend who's committed DV and who doesn't like children, that she's told her child that it'll be his fault if her boyfriend leaves, that she's pulled the child out of school to travel, that
Wait,
she's shown up in
I
Dad's
already have to pause. I'm sorry. What did she just say?
Domestic violence.
What?
And
No. I got that part. It was something. Um, a boyfriend who has committed DV and who doesn't like children. And what? I'm sorry. Opinion, unsolicited opinion here, but I don't have no respect for a woman that puts a man before their child. I can't.
Dunk. No.
I can't do it. You should never put anyone above your child.
No.
Nobody.
No.
Under any circumstance, there's no excuse to put anybody above your child. And not to be vulgar, I'm sorry, I don't want to be vulgar, but I'm gonna say it. There's no dick good enough to replace a child. I'm sorry. I would take having a child over dick any day. I can do without it, but I can't do without a child that came out of my body. Like,
Right.
I will never understand, just in general, women who blatantly do things to harm their children and then lose parental rights. I just can't get, and that's I should really be careful on what I say, because I do work with like CPS patients. I've worked with CPS patients in the past, and I am all about helping them and doing whatever they need to get their children back and keep their children. But in the same, if you're doing something blatantly to not have your child, but so much I can do, right? I can't help you if you don't want to help yourself.
Right.
Oh my God. Okay. I'm sorry. When I heard that was a trigger for me. I can't. Okay. This is gonna be interesting. Hopefully this is not like, a screamer. Well, they don't really have screamers in court cases. But I'm hoping it's not cringe. We get some cringy ones.
Sometimes we can get a little cringy.
Yeah, I don't like the cringy ones. But okay, I'm sorry about the pause.
bedroom in the middle of the night and scared his girlfriend, who has a restraining order against Mom, and many other accusations I don't have time to share. Dad's lawyer accuses Mom of abusive use of conflict. What does Mom and her lawyer have to say about his accusations? Let's find out.
All right. Yes, I have parenting plans that have been provided by both parties. We're looking at temporary family law order, parenting plan, and child support. So I guess I'll give each party a minute or two if there's any additional information.
This is Dad.
Otherwise, I'm ready to just make a ruling.
Okay. I can just note for the court that I did receive an email from Mr. Clough, and I don't want to speak on his behalf, so he can confirm if I'm incorrect. But the email that I received from him indicated that he was agreeable to the majority of the holidays, with the main points of contention obviously still being summer, spring break, Thanksgiving, Christmas, and the child's birthday. Your Honor's well prepared for purposes of today's hearing, so I won't belabor the point. However, I would just note, and Your Honor likely saw in the most recent.
As we begin the case, they seem to be finalizing their parenting plan, but this won't be the end of their conflicts. Sorry, I got siren.
Sorry, and the previous Smiley said, if you enjoyed Miss Baldwin in the past, you will really enjoy this one.
This attorney is talking so fast that it's like nails on a chalkboard at the moment.
I'm like, what?
She's talking like really fast. And is it a little weird that the mother's not there? Maybe? Maybe she's not on camera. Oh, okay. Back to it. Love the smiley with the judges thing, by the way. Too cute.
Declaration. There's been some conflicts with transportation. Therefore, my clients request that a neutral location site of either the Castle Rock Police Department or the Park and Ride be utilized at this time, just given those conflicts between my client and the girlfriend of Mr. Klopp. But otherwise, I'll defer to the court if you've already reviewed all of the pleadings. I won't belabor it any further.
All right, thank you. Mr. Klopp, any comments?
We're also familiar with the judge too.
Yes.
Judge Fassett.
Yes, she is correct with the spring break, winter break, summer, and Brody's birthday, and then also the transportation. That I disagree with. I don't think that we should change up what we have going, other than to change it to pick up after school on days that he does go to school, and then to pick up at 7 p.m. at each other's houses. The only issues that we have been having have been caused by Lacey, overstepping boundaries and disrespecting our privacy. So if she could just remain in her truck, I feel like those issues could go away. Just like yesterday, everything was fine because she remained in her truck and she respected my privacy, and everything was fine. So that I feel like that could be avoided if she just would respect our privacy.
You were asking for a different pickup and drop off time.
Yes.
I think you said 7 and she was suggesting 6. Is that correct?
Yes, Your Honor.
Okay. And is 6 a problem with your work schedule or anything of that nature, or?
No, just our family dinners and stuff. It just seems like I get off work at 5 p.m. and by the time I either pick Brody up or my other children, it's almost like 5:30 already. And then if we have dinner already at home, it just doesn't really give us a whole lot of time to eat dinner as a family.
He's not wrong.
Rushing him out the door with food in his mouth a lot of the times. So I just asked for an extra little hour, but.
All right, so here's what I'm going to do. I'm adopting, and I'm working off of Miss Bliss's paperwork solely because some of the language that's in there is language I'm going to adopt. So I have a temporary family law order. I'm adopting that as proposed, which is I think the same as what Mr. Klopp proposed. In the parenting plans, joint decision making across the board. At this point, given the concern between mediation and court, I'm going to have the any dispute resolution go to court at this point. If there's an agreement to change that later, that's great. I am going to have the exchanges every Monday. I'm going to make that 7 p.m. Or otherwise agreed upon.
Enough time for dinner.
Adopt the request as far as summer. So each parent, excuse me, each parent can have 5 days with the child during summer, and that'll to be scheduled with the other parent no later than May 15th each year. Given the child's age, I am going to adopt the spring break schedule for on a temporary basis that is proposed by mom. So half a week to each parent. Just want to make sure I hit on all the areas of contention here. There was a concern over
Thanksgiving, I think, is the next holiday on my list.
Proposal from Miss Bliss Wednesdays. I'm going to just change from 6 p.m. to Wednesday after school to Friday at 9 a.m.
Was that for Thanksgiving, Your Honor?
Yes.
Okay, thank you.
For winter break, Christmas break, I'm going to change, what's been put forward. I think exchanging on the 23rd, the 24th, the 24th, and the 25th. I think that's just a lot of exchanges for a young guy. So I'm going to change that to even years to the father from date school is out to noon on Christmas Day, with mother from then until school resumes. Odd years would be the opposite. What I do foresee is that may impact the week on, week off schedule somewhat. So if that resets it and somebody gets a day or two extra time, I think that's something that we just need to understand may occur, and hopefully it won't become an issue. And then the last one is the child's birthday. And I'm going to adopt the recommendation of Miss Bliss at this point. So father will have him 8 to 4, mother will have him 4 to 8 the following day, and then that'll reverse. So each party will get an opportunity to be with him on his birthday. For transportation arrangements at school, this should go without saying, but any outside influences on exchanges, any non-parent involvement in exchanges should be courteous, kind, respectful of the young person that's present, and respectful of the other parent that's there. So exchanges will be at school, and or the home of the party. I'm not going to do the park and ride at this point.
Go ahead and continue. I'll be back in a few minutes.
Okay. Taking a quick break.
Oops.
Welcome back.
We are back. Sorry. That took a little longer than expected.
All right.
We are here.
I finally put my stuff in the dryer.
Oh, good.
After washing it a third time.
Does help if I change the screen, doesn't it? My bad.
All right, here goes.
Your Honor, my only concern with that is Mr. Klopp's girlfriend has just recently sought a protection order, which obviously would prohibit my client from going to her home, which she also shares with Mr. Klopp.
Your current girlfriend has a protection order against your ex-wife. That sounds messy.
Little bit.
It does.
Little bit.
So assuming that goes forward, I mean, I don't know what her intentions are, if she plans on dismissing it or moving forward, but assuming if that moves forward and for whatever reason is granted, then obviously that would impair the ability to have the exchanges at the home of Mr. Klopp.
Well, that does throw a wrench into it, so I will.
I guess Mom could stay in the car, but I have a feeling it would end badly.
Back then to the park and ride, and that's the Castle Rock Park and Ride, is that correct?
That is what I have in there, yes, Your Honor.
Sorry, I already whited it out.
No worse places than a park and
Your
ride.
Your Honor, can I say something on that?
Probably the
If
safest
there's an
option.
active no contact order, then I can't do anything about that. That was your girlfriend's choice to file that. That protects your home, and she can't come within a certain distance of your home unless that order's gone. So Castle Rock Park and Ride it is, or the school.
Okay. Thank you.
I don't believe there were really any other issues with the remainder of that, so I'll sign that order.
What about child support, Your Honor? Or were you just...
I'm getting to that right now.
Oh, okay. Thank you.
So, obviously, this is the area where there was the most disparity. There was a significant difference in the petitioner's wages, depending on whose worksheet you looked at.
Yeah, you probably know these TD moves. Touchdown! But guess what? There's an...
As far as the order, what I didn't see, Miss Bliss, was any kind of deviation as far as for essentially a 50-50 schedule. And I indicated, or you indicated, that no party asked for that. And I think in the initial response, there was a request for a deviation for the parenting time. So I guess if either party wants to make any comments regarding that,
I'd be happy to, Your Honor. Obviously, it's my client's position that Mr. earns a substantially higher wage than she does. As Your Honor's aware from my client's declaration, she has been diagnosed with fibromyalgia, is incapable of working full-time wages. She does have a job where she's working $30 per hour, but it's only at 26 hours per week. So I think that's the largest contention with our worksheets is Mr. Klopp has indicated that she should be imputed at 40 hours. Obviously, there's nothing to reference, and even in his declaration supports that historically she's never worked full-time wages. So it's our contention that my worksheets are appropriate. As for deviation,
not to be funny, but even with her working at 26 hours a week at $30 an hour, she still makes more a week, or double, almost triple what the last case person makes.
Yeah. I mean, that's really good money. That's
for 26 hours for part-time? Hell yeah. She makes it part-time what people don't make full-time.
Yeah, that's what I was gonna say. I don't make $30 an hour. I make 35 cents an hour. I mean,
when the court is determining whether or not to apply a residential credit, you have to look at the incomes of both parties, the homes of both parties. My client provides for the court that without child support, that she doesn't have sufficient funds to support this child. As Your Honor can see from the child support worksheets, he earns drastically higher wages than she does. He did provide
that sounds like a her problem.
I saw in his responsive declaration, but it doesn't take into consideration his girlfriend's income, which he acknowledges she lives with him, assists with the bills and the paying with the rent and utilities and the like. So
his girlfriend's his girlfriend's income should not be considered in his child support calculation.
No, because the girlfriend, that's not her child.
And if she pays for bills, technically she's already paying child support too.
Technically,
Because child
yes.
support is not just food; it's room and board and all the those type of
Yes.
expenses. So she's already contributing.
Right.
Why do you need to? Whatever. This attorney, she's if that's I'm assuming this is an attorney.
Yeah.
I don't know. Maybe she's one of them people that's on another planet too.
This time we're asking court not to order a deviation. If Your Honor is inclined to order a deviation, I don't believe a zero transfer payment is appropriate in this case, just given.
If mom has a partner or roommate, their income shouldn't be considered either.
Correct.
Well, now that's an interesting thing.
No, because
he makes because he makes so much money, and his girlfriend also makes money and contributes to the household. They want that considered for his child support. But the wife has a boyfriend. Shouldn't his money be helping with the child too?
No.
If his girlfriend's money is helping.
See, I don't think that's right in either situation, because
no.
Because they're not. The kids don't belong to them. Sure, they contribute to the house, but they're not responsible for that.
No, they're not, but that's the point. Like, you can't want to base how much child support he pays because he has another person in the household helping, but want to potentially give the mother child support when she has a person living in the house too.
Right.
That could be helping her.
Right.
So you can't, it's like a double standard. Honestly, he shouldn't have to pay child support if she has a whole nother adult living in her house too.
That's really hard to say.
Make sense.
Because I agree with what you're saying, but the child is left out here. So I don't know.
No, I mean, here's the thing. Either you look at both partners as contributors to the household, or you look at neither partner. Is what I'm saying. Don't look at a partner for one household, but not consider that a partner for the other household.
Right.
Because the reality of it is that his girlfriend seems to be more willing to contribute to the household, which is the betterment of the child.
Right.
And this other, the wife's boyfriend, from what we've already been told, doesn't like kids. And could potentially leave her because of her child.
True.
So that's also not fair to put that consideration on him and his girlfriend when the wife's boyfriend is refusing to contribute.
True.
Because it's not his kid.
True.
So
good point.
That's my issue.
Yeah.
Don't consider either
the incomes of the parties. So depending on what Your Honor decides to do with that ruling, I can rerun a deviation or prepare another order.
Can I respond to that, Your Honor?
Yes.
Okay, to start with, Lacey has worked full-time in the past. She was working at Happy Kids Dentistry when we first got divorced. I supported her until she got that job, financially and fully. And then she has had a few other jobs in between since Happy Kids, Jamie's, and some other jobs. And then if she is fully disabled for that, how come she hasn't provided any paperwork for being disabled? I feel like that should be provided if she's fully, oh my goodness, disabled.
Fair statement.
And the Brooke, she does work, but she only works maybe one day a week, not even. Sometimes she only works once a month. Sometimes it's once a week. Sometimes it's once, twice a week. And
he needs a lawyer to speak on his behalf. Fortunately, he will have one very soon. Oh shit.
She goes to school full time for nursing school, which is super expensive.
What if you were prepared for all those interview curveballs?
this
you know,
lawyer
Lacey.
in particular. Those that haven't seen this lawyer in particular, she doesn't play around.
No, and she is like T's crossed, I's dotted, everything.
Yeah.
You never hear her client not getting something done. So, but he seems to be. I mean, for pro se, he at least seems to be standing up for himself and, has his information straight. He's just not articulate. Sorry, no offense, Steven. You're just not articulate. But he might even also maybe, people get nervous when they're talking to people of authority.
Oh, yeah. That's why.
Fails to mention that she has a working boyfriend.
Sorry.
Oh, I said that's why it's meant for lawyers.
And he's shutting his attorney down too. Don't talk about my girlfriend's income when she works less than my ex-wife and goes to school, which is an expense.
True.
This lady. I don't know. I'm wondering, is this attorney going to be around the rest of these hearings? Because that's going to be a back and forth.
I think that's why
From home too as well. So I think if we're going to consider Lacey's income, I believe that we should consider Lacey's boyfriend's income as well, who lives there full time. Yeah. So and then I also have a 7-month-old daughter that I take care of full time too, financially.
I mean, he's not wrong.
Nope.
All right.
It's basically what I said. If
Here's what I'm going to do. I'm
you
going to
consider the girlfriend, consider the boyfriend.
I am going to order at this point that there be a transfer payment given the circumstances. I am going to deviate from the calculation, both calculations. I think there was one party landed at 824, one party landed at 879, something like that, without the deviation. And then I think Mr. Klopp's suggestion with the deviation would be a minimal transfer of, I don't know, $100 or so a month. This is child support. This isn't spousal support. I'm gonna, and I think we were sitting at $300 a month. Was that what the previous amount was?
Yes, ma'am.
All right.
300. Okay.
I'm gonna set support in this temporary order at $500 a month, and that'll I'm gonna have that start March instead of February.
I'm sorry, why is she getting spousal support when she lives with a whole nother man?
Eliminate that on my order.
Yes.
Or did you want me to compare new? Okay.
I won't enter the worksheet, but I'll enter the support order based on that.
Did you say you weren't going to enter my worksheet? Sorry, I just want to make sure.
Yes, correct. Just
Okay,
the,
did you want me
just
to
the
prepare?
order. If you want to prepare,
new worksheets?
please, and then I will happily sign those ex parte and enter them to, or send them to the clerks.
Were you adopting either one of our incomes for the other party, just so I know which numbers to put in where? Or do you want to adopt my worksheet and then I can prepare a deviation and submit
Sure,
that?
let's do it that way. That'll probably be the
Okay.
easiest.
Okay, I can do that.
All right, good luck, thank you. All right, and Klopp and Klopp, 19-300-36108. All right, so this is, excuse me, Ms. Bliss and Mr. Klopp. There was a request for clarification. There was also a request for reconsideration, but they were largely similar. So I'm assuming that the clarification is really what's being sought here. And the main issue is the two different paragraphs within the parenting plan that say.
I just want to check something because I didn't do what we did last time and like pay attention to dates and things. So if this was April 4th, right? Then the first hearing was March 14th.
Right.
So, wow, They get into like 2024 on this one. Most of their stuff is in 2024. So I'm assuming shit hit the fan. Something stopped working.
Here we go.
This is pretty like short because this is not even a whole month before they needed to request clarification. And then what happens? And then look at the. I'm assuming this is an adjournment. The December 26th to January 2nd. Why would they do a hearing the day after Christmas, and then the day after New Year's? And it looks like there might be a couple of adjournments in here actually, because the dates are super close. All right, I'm sorry. I just I had to see like, because I'm like, when was the first case? Just to see that it was only like 3 weeks prior. Like, I don't know why the clarification. Who was confused?
PM exchange, and then after school, or when school is in session, after school. So I reviewed everything, and the order very specifically on page 3. Section 8B1, the exchange is at 7 p.m. So it's not after school every Monday. It's at 7 p.m. every Monday. So I don't know that the order needs to be changed to rule to, but that's what it is. I understand the concern and the confusion because the section 12 states they'll be exchanged at school when in session or Castle Rock Park and Ride. So there are times in the parenting plan where school is the point of pickup and drop off, and that's namely in some holidays that are covered here. But as far as the regular week on, week off schedule, 7 p.m. Mondays at the Castle Rock Park and Ride. Okay. Is there anything else that we need to clarify so we make sure we don't have any issues? Go ahead, Bob.
Oh, sorry. Yes, there is, Your Honor. To start with that, there's no way you could reconsider that to be picked up after school. Or is that just out of the
I thought you wanted 7 p.m. so you could have dinner. That was for non-school days, sir. Sorry.
Picture? Changing that to after school.
4 reasons why Green Chef makes eating clean easy for me. 1, my meals support my evolved.
Rather than 7 p.m. Dude, just to limit all interactions if we could. Just because of the restraining order that's in place for 1, and then for 2, just so we don't have to do as little as interaction as possible.
Ms. Bliss?
And Your Honor, as contained in my client's declaration, it was specifically anticipated a protection order was already in place or was going to be in place. Your Honor still ordered that the park and ride was to occur consistent with that. There were specific discussions during that initial hearing that Mr. Klopp had requested the exchanges occur at 7 instead of 6 is to not interfere with dinner time. So it was fully anticipated that the interactions would occur at 7, which is essentially status quo. It's an hour different than what the parties have been used to. There's no basis to make that request currently. I understand that he brought a reconsideration, which I think the court is aware this isn't the real proper venue for that, as those are typically done on the pleadings. But nevertheless, there's no change of circumstances between the last hearing and today. There's no real basis to switch that at this point. And so we would ask that it remain as it is, as it was fully anticipated and fully considered at the first hearing.
So, and I'm reviewing, Mr. Klopp, your initial request when we went into that hearing a couple weeks ago, and your request, initially it was 6 and it was 7. You specifically asked for it to be later so dinner could be concluded when the exchange happened, there was never a request in my notes or in the court record.
Maybe
for
something
after-school,
changed.
Exchanges. Frankly, I have no idea what that restraining order is about, why it was filed. There should never be an issue with exchanges between parents, step-parents. It should be civil. There's a child present, so I don't know what the issue is, but
Just,
that's, so I'm not gonna change the 7 o'clock. It was what was contemplated and requested by, frankly, by both parties, so I'm gonna leave that at
thank
7.
you.
Anything else, Mr. Klopp?
Yes, and then the New Year's Eve schedule, I feel like also kind of interacts with the winter break schedule. I feel like that, let's see here, sorry, it's so. Winter break. Oh yeah, so the spring break will roll over, or the spring break day, or sorry, not spring break, oh my goodness, New Year's Eve. Isn't that's still in the winter break? Is that how that works?
Generally, yes. So are you confused or concerned about essentially an added exchange in the
Yeah,
middle
so
of
there
the
would
second?
be another exchange in there on my year or her years. That, so if it was like my winter break for the last part of the winter break, Lacey would be getting him again on New Year's Day. Yeah. Are you seeing what I'm saying?
I am seeing what you're saying.
Okay.
Ms. Bliss?
Sure.
And Your Honor, I didn't really take a position on this. Your Honor made the change as to the Christmas Eve and day schedule, providing essentially for a Christmas break split schedule. It's not uncommon that we celebrate Christmas or New Year's, even with the inclusion of a winter break. I don't think there's a real basis to make a request to make a change, but I'll defer to Your Honor.
Is this the concern just the exchanges?
Yeah, just the fact that, yeah, like he would be, like if it was my winter break still, he would go back with his mom for one day for New Year's Day. So if we could swap the years, that would change it, or the wording to where I could just have him the full winter break, which is, can we add like the, New Year's as part of the winter break? I guess is the easiest way to put it, rather than having to swap.
Right?
I'm sorry, say that again.
I said he gets until the kids go back to school on even years, odd years.
Yeah, but it looks like there's a conflict of with the holiday, or there's some type of conflict where he would have the kid would go back with the mother for a day and then come back to the father. So I'm guessing that's what it is, with whatever their exchange is.
Okay.
That it would just add like he's basically saying it would add an additional exchange that's not necessary because it's just for a day. It must be like the way that the day falls, it falls in between his time when he has the break, the winter break. Because remember, kids don't go back to school until after New Year's.
Right.
So if he has 1 year, he has the child for winter break, but the mother's supposed to get him for a specific holiday. Because I think they're supposed to rotate on holidays or something. Because New Year's, I guess, is considered a holiday, right? So I'm assuming it does it for her years too, where there's like this 1 day that is in the middle of their parenting time.
Okay.
So he's wanting them to include New Year's, I guess, as part of the winter break and not as its own separate holiday.
Okay.
Ms. Bliss, does your client have a strong position on that? Like New Year's Eve isn't like a big family, okay. Because to me, the easiest thing to do would potentially be just on the New Year's Eve portion, just in odd numbered years with father, even numbered years with mother, because then it would essentially be consistent with, or it can just be struck. So I'm fine taking that out if neither party has any strong feelings about New Year's Eve. So Miss Bliss, I know you're leaving soon, but I guess I would ask if you think it would be easier to just strike the New Year's Eve portion.
You do that.
And then the best way to do that, to keep a good record, do you want me to do a bench order, or do you want to present something ex parte?
I think it might be cleaner to just strike it from the parenting plan and just submit an amended temporary parenting plan. So that way we can just refer to one parenting plan instead of a parenting plan, a bench order. I think it's just cleaner and less confusing that way.
All right, well, I would hope that since all we're doing is printing and omitting, we can get a signed order, an agreed order from the parties, and I will sign it. And
not to be funny, but now looking at the dates of these hearings, is it not strange that the next hearing in this case is the day after fucking Christmas?
Well, I mean,
and it's wait, hold on, and it's an odd year, which means that it's the father's parent winter break time. So I think it's hilarious that on his year to have winter break with the kid, that there's a hearing the day after Christmas and the day after New Year's. Like, why?
Interesting.
File it as soon as I receive it. So, Mr. Klopp, can you work with Ms. Bliss's office on getting your signature on the order that will just omit the New Year's Eve language?
Yes, ma'am. Yep.
All right. And then once I receive it, I will file that.
Cool. Awesome.
Anything else?
Yes, and then my biggest one also was the first right of refusal. So on days that I do work, Lacey still hasn't given me a schedule of her work. So I have an issue with giving him to Ms. Dahlman when I'm at work, because I don't know if she's at work or not. I feel that it's not beneficial to Brody for him to go to his mom's house while she's at work. I know she works from home, but I still feel like he just gets stuck having to play video games or do things that aren't very proactive for him when she's working. And I don't know what days or what times she works, because there's never been a schedule given me. She knows my work schedule. I've worked the same work schedule for 8 years. Hasn't changed. I can leave work anytime I want. My work is amazing.
I had a crazy idea. We were surprised that no one had done it before.
Can you tell us where you work so we can get jobs there too?
I just feel like the first right of refusal, I feel like if he has the opportunity to go to a grandparent's house or have my fiance watch him with his other siblings, I feel like that should be an option rather than have to go sit with his mom while she works. I don't feel like it's very proactive for him or good for him to have to do that. On days that she's not working, that's fine. I understand, but I have yet to see a work schedule.
Ms. Bliss?
Your Honor, as my client has testified in numerous declarations, she does work remotely. She works when the child is in school or otherwise not in her care. It's my understanding there is no issue with her working. If he needs a work schedule be provided to him, I don't think she has any objection to that. Although it's not the order of the court, the order of right of first refusal simply states if a parent is unable to do so or is working there to afford the other person the opportunity to watch the child, not I need to give you my work schedule, you need to give me your work schedule, and then we'll coordinate. That's just not typically how it works, and that's not what the order is. If that's what Your Honor is going to order today, my client has no objection to that.
I'm not going to order that. I think it's beneficial to share that information. I'm not going to change the right of first refusal. I appreciate other generational family members being involved in these kids' life. I think that's very important. But it's a relatively common ask, and even with the concerns with the exchanges, I'm going to leave it in there. And I would just hope that if she's willing to provide her work schedule, that that's something that they can find some mutual grounds on. I agree that, I think the orders is over 4 hours. Is that right? I think it's over 4 hours. If they both agree.
Hmm.
To me, that's not hard. That would be common sense. If you're
What,
working,
to provide her
of
schedule?
that time. Hello. Right?
I'm slightly, well,
Right?
and this is where we have where our separate life experiences kind of like have an impact on what we're seeing. You're familiar with the, two-parent household.
Right.
I'm not. So I don't really, I mean, I can have an opinion about it, but I can't say that it's my opinion's coming from experience. I don't necessarily. I guess I would understand to some extent to know her work schedule, so hey, when the exchange is happening, that she'll be working, right?
Right.
So maybe on days that she's still working, it does make sense. Oh well, maybe we can take some time to see a grandparent, or go see your cousins, or spend a little extra time, with your siblings or something.
Right.
That makes kind of sense. But you would hope that something like that wouldn't have to be in an order. Like, that should be something that they should agree upon. She should be able to call him and be like, hey, I was supposed to be done at work at 3 o'clock, but I need an extra 2 hours.
I'm gonna I'm gonna say that I agree with you, and then I don't agree with you, and here's why. Let's say there's a toxic person, right? A toxic person, they don't want to give up their free time or whatever the case may be, right? They don't want to give you a schedule. They don't want they don't want anything to do with you. They don't. You know what I mean? So
Well, that seems to be
I
an
understand his
issue.
point of view.
I guess I'm looking at it as I could understand him not wanting the kid to have like dead time just sitting doing nothing.
Of course.
When that time could be, you know, used for other productive things.
Right. And that's what I'm saying. Like, you know, if it were common, right, that the parents would get along, that wouldn't be a problem. Right? But do parents get along with their exes? No.
But see, then the other thing is too is like, why is it any of his concern what the child is doing during her parenting time? Also,
True.
so
there, there's a couple different factors here. Do I agree with you? Absolutely. But that would be, what a normal person would expect, right?
I think people just get super vindictive and controlling, and like to use their children as pawns.
They do.
when this type of thing happens, and
They
it's
totally
like,
do.
but this is a person you were married to. This is a person that you had children with. Why is it now all of a sudden so difficult?
Yeah. No.
It shouldn't have to be this difficult, because this is somebody at some point you loved and made a family with. Like in this case, like this is someone he was married to.
Right.
Let's see what the judge says.
That, okay, it's going to be 4.5 here and there, and it's okay to be with grandpa or whatever. That's fine. But I'm not going to change the order as it is. That doesn't mean that
so she didn't
you can't
change
work
it.
with each other on figuring out how to best approach that for your child.
Okay, so just contact her and figure out if, hey, can you go spend the day with so-and-so, or I guess.
I think communication is important, and so, I mean, she has a right to say, I want to take him for that.
Ooh.
5 hours that you're not available because of the order. But if you speak with her, and she also has a right to say, no, it's okay, you can take him to grandpa's, or you can, so my hope would be that you'll learn to work together for the best interests of the child.
Okay.
All right. Thank you for
Yeah,
raising these issues. If you, it's good to get clarification when you need it. So
Right.
hopefully this helps moving forward.
Awesome. Thank you so much. Appreciate it.
All right. Good luck.
Thank you.
Mr. Clough, I will send that to you after court this afternoon with that removal of the New Year's Eve language. So if you could just review that and give me your signature, and I'll submit that to the court.
Will do. Awesome. Do I need to bring it to your office? Sign it and bring it to your office? Or?
No, and I can send it to you via electronic signature. We'll put that in the email as well. So if that's easier for you, that's fine.
Awesome. Thank you so much. Appreciate it.
All right.
Thank you, Judge.
9 months later.
Or set over.
Yes, Your Honor. At request for continuance, Aaron Winkles appearing on behalf of Jennifer Jocelyn and Klopp v. Klopp. I know it's contested though, and that's 19-3-00361-08.
Teaching attorneys.
Yes. All right. And I did see, I did receive the declaration from.
Okay, including the amazing attorney Baldwin. So we're not the only ones who appreciate her abilities.
Nope.
And attorney Winkles is filling in. Okay. Why does she look like her hair is wet?
Because it looks that way.
Okay, I'm sorry. I don't know. I'm hoping that she didn't like downgrade in attorneys or something. And I think it's weird that the mom is not showing up. So I'm wondering if we're going to see her. This YouTuber hasn't mentioned that.
No.
Which they normally do mention, but I guess we'll see.
Jocelyn, Miss Baldwin.
Thank you. So in this matter, we've already waited for 3 weeks for the hearing today. My client does want to move forward. The concerns here are that there's a very clear adequate cause. We have 2 restraining orders that have been entered within the last year against the petitioner. And then my client details the violence in the mother's home.
Okay, sorry. Okay. But the girlfriend got one against mom in May. Then 10 days later, mom got her own against the girlfriend.
Okay. And then the previous Smiley, the previous Smiley just said couldn't find any restraining orders against dad.
Well, the ex-wife clearly did her RO in retaliation. Oh, Lord.
With direct screenshots associated with that domestic violence in the home, putting the child at really direct risk. Similarly, child witnessing this behavior, witnessing the behavior that resulted in the restraining orders, significant instability on the part of the petitioner, and just kind of glazing over the surface of those arguments. There is a reason in this case to go forward and protect this child. What we would recommend, instead of just straight continuing it, is instead based on the materials provided, is to grant adequate cause, to adopt our order as an interim order, and not to deal with child support at this time, and to set it over only for the purposes of entry of a full temporary order. Both sides can then argue what that temporary should look like, appoint a guardian ad litem, but that we should take steps to protect this child now, given some of the very concerning aspects regarding domestic violence in that household, and the 2 restraining orders that were taken out and entered by the court against the petitioner. And this is a case where the child's at risk.
Sounds like Attorney Baldwin is claiming there is DV in mom's home. Okay, yeah, that was kind of clear.
We've already waited 3 weeks. Waiting 6 weeks just isn't reasonable. Putting the child at risk for another week isn't reasonable.
So hold on a second. So the first hearing was... Sorry. This is why I should keep to writing dates. So we know that in March 14th, his girlfriend already had a restraining order. Or had applied for one. So I guess it's to be assumed that it was accepted in May?
Correct.
And then it says 10 days later the ex-wife did one.
Correct.
So, okay.
And nothing was done on those. Sounds like.
Well, I'm assuming the restraining orders were granted. Or the girlfriend's was granted. I don't know. Okay. I'm assuming it'll come up again.
Yeah.
Okay, Ms. Winkles. Thank you.
Yes, Your Honor. The fact is that they've waited almost a year. And the reason I say this is because there have been a number of opportunities, if they were really concerned about this, to do it at the time of the first protection order, at the time of the second protection order. There have been so many opportunities to bring up this issue that to then wait and say, we're going to give you the 3 weeks, but there's no counsel in Cowlitz County that are taking new cases. So the counsel that took this case, who I'm stepping in for, Jennifer Jocelyn, is in Clark County now at my office, came in on the 20th. So to grant adequate cause without any sort of ability to defend oneself when we don't know if there is adequate cause is strategic. And the problem is that this should have been dealt with in any of those protection orders if there was an issue. Why were those protection orders updated and amended, but nothing was referenced about mom? It makes sense. Miss Jocelyn is not asking for a significant set over. She's asking for 2 weeks. The child, in the last 3 weeks, there have been no police reports. There have been no issues. There have been, the child's safety has not been an issue in the last 3 weeks. To have another 2 weeks when the child's been in the mom's home repeatedly over the last year without incident seems to be a problem. Additionally, it needs to be noted that he filed for modification in October. And court for that was in March, and it was not brought up at that time. So why are we doing it now? It seems strategic. It's right around Christmas time. It's right after the holidays. There are no attorneys. So, Your Honor, I would ask for an extension for Ms. Jocelyn, and I know nothing about this case, minus what I just read about 5 minutes ago. Allow Ms. Jocelyn the ability to get a declaration from her client, again, hired immediately before Christmas. 2 weeks is sufficient as long as she's given a week to get that declaration. We can make it shorter, but I'm not sure how that would be possible unless there was no reply or the reply was due only a day before.
So this is good, but this has to do with, I'm assuming an incident happened maybe after the restraining orders in the household?
What's true can easily be.
And maybe he had to wait till he got an attorney?
What parenting plan are we currently operating under? Because I'm looking, excuse me, and I see one from April 12th, 2023. Is that the only plan that's in place?
There's one in March.
Yes.
And yes, so there's one in early spring 2023. So it's a 50-50 plan currently.
And that was the modification that was done in October. And
so the parties always had a 50-50 plan. The modification was a minor mod to, they had a sort of a pro se 50-50 plan with lots of loosey-goosey language. The initial minor mod was to set some really firm boundaries, and that's what the spring 2023 plan did. It didn't create a 50-50 plan. It just sort of made things really clear about who was to transfer.
All right.
And at that time, just so your honor's aware, he requested the 50-50 plan continue. But when you look at the declaration now, we go well into the past. We're not just talking about March and forward. And yet in March, he requested as well the 50-50 plan continue.
Well, he didn't have an attorney back then, lady.
The restraining orders all happened subsequently.
But some of the issues involved appear to be before March. Maybe again, I know very little of this case. She's in the adoption docket.
So I was able to read most of this, not all of this. Not everything got into Odyssey before I was out of the office last week. I had a little bit of time after my docket this morning before today, and I had bench copies waiting for me. I was able to go through a lot of it, not all of it. And I saw the declaration. I do understand that there is a shortage of attorneys, and especially at this time of year, that can be difficult.
I've not read the declarations, so I would have absolutely no ability to argue this whatsoever.
So what the fuck are you there for?
The declaration I'm
Sorry.
referring to is
She's covering.
your Miss Jocelyn's declaration.
I know, but
I haven't read that either.
And I understand the concern.
Whether you're covering or not, you should be if you're covering, then you should be asking automatically for an adjournment, which is normally what. Well, I don't know about how family court works, but I know that this is how like it works with like in civil court. Like if my attorney is not available, and this has happened to me, I've had to physically go to court, sit for a calendar call, and when my case is called in, I've had to ask a judge or tell the judge that we want an adjournment. And then they adjourn it, and they either direct us to do a stipulation between parties, whatever, to agree to the adjournment, and then it's adjourned to whatever date we select or whatever.
Right.
That's it. But she's sitting here talking about the case. If you don't know anything about it and didn't take the time to fill yourself in on what's going on, then just ask for an adjournment, and then there not be any further discussion, because you don't know anything.
Right.
And it seems that's what's going to end up happening anyway. So like, why keep having an opinion, lady? You have an opinion on something you know nothing about. She wants to keep bringing up that, this is like they're making it like it's a new issue on old information.
Right.
What does that have to do with you? You haven't read anything.
Right. Exactly.
Can't say with certainty, based on some of this information, there is question about dates and how old or new some of these allegations are. There's a lot of photographs that were provided of concerning images of the child, but no, I don't have dates for when that was. Obviously I have concerns, but I do think it's appropriate to allow time to respond. If it took time to get Miss Jocelyn on board, I can definitely understand that. So I'll probably do something that makes nobody happy. I'm going to give a continuance, but it's only going to be until the 2nd. There's enough.
I wonder why mom switched attorneys. Maybe Miss Bliss was too busy.
The information that has been received by the court that I think it does need to be addressed sooner rather than later. And so we'll set the.
Actually, what I'm thinking is that when they had their hearing in April, they thought everything was said and done and over, and there would have been no need to ever go back to court kind of situation. So her necessity for that attorney was completed, and then this came up, and the attorney either probably didn't want to have nothing to do with her anymore, or didn't want to be involved, or had their case. Honestly, you would think that if an attorney had you before, it wouldn't matter what their caseload is, whether they take you or not.
You would think.
So there must have been a reason, or maybe she wasn't happy with what happened with the attorney and wanted a new one. But
who knows?
If her new attorney is any foreshadowing, or I should say, if this attorney is a foreshadowing of what her new attorney is going to be, I don't know how long she's going to keep that attorney either then.
Yeah.
Because who comes to court unprepared? Even if you're sending a representative. So looks like Attorney Baldwin is about to railroad some people going forward. Because I don't know how long she's been his attorney, but
as I said,
she came prepared.
As I smile brightly,
she came prepared.
She always comes prepared.
And I don't think it should matter when the domestic violence situation happened. He did not have an attorney at the time. He probably didn't know what an attorney at guardian ad litem is, to even say that one needed to be appointed. And I wouldn't be surprised if it was a new incident. We didn't even get to all the allegations
No.
and things that were said in the intro to this case.
No.
Like all that stuff about the partner and the things the mother's doing were not brought in the first two cases. And
No.
I think that this dad, if all those things were happening, he would have mentioned it.
Correct.
If it was a concern about his visitation or the visitation situation.
I mean, that's what I would have
he would've
done.
left it
I would have
out.
mentioned it.
I think if it was something for him to mention, he would have mentioned. But
Yeah.
I've also noticed it depends on the judges sometimes. But if it has nothing to do with why they're there, they usually don't want to hear it. So, you know, if you're like, what is it? If you're gonna make a motion, you have to stick to what's in the motion. You can't say you're making a motion about the sky being blue, but you want to talk about the brown grass on the floor.
True. Very true.
So
So.
that's why this other attorney is like kind of annoying to me.
Wow.
Because you weren't at the other hearing, so you don't know what was said and not said. Like I said, I think it's a new incident. The domestic violence in the home situation. Well, and who knows, maybe his son didn't tell him right away. Kids don't, especially if kids feel like something is supposed to be a secret. And they never discussed why the girlfriend had a protection order either. So I'm thinking that the domestic violence in the home might be a new thing. Because the needing a protection order in front of the kid situation wouldn't necessarily affect, well, it does affect the kid.
Right.
But if there's abuse in the home, that's a completely different situation.
True.
Oh, I guess we'll see. We'll see. I'm sorry. We'll see.
This over 1 week to the second. I'm assuming based on that, the responses can be late from Ms. Joslyn, and those can be served as bench copies to the court in whatever manner she feels is appropriate. And I'll just make sure the next judicial officer is aware of that because of the timing, but I think we need to address it sooner than later.
Can we make her response due Thursday by like midnight? She's just e-serving it. That gives me a single day to essentially get out a reply because Monday is a holiday.
Oh, I think that will be fine.
Let's shoot for that.
Okay.
Thursday by midnight.
And I appreciate, I know I'm putting everybody under the wire there with that order, but I think resolution quicker than not is appropriate given the allegations.
Thank you, Your Honor.
Very good.
All right. Thank you.
I appreciate they even have an attorney
Club 19
that he still shows up.
361-08.
Oh yeah, we do have a new attorney.
And just for procedural, so this was on last
Oh,
week.
Miss Powers, we know her too.
Timely. The court set it over a single week to allow the non-moving party.
Wait a sec. Oh, tell me this is not funny. The Zoom name for her previous attorney is there.
Yeah, I do see it.
That's kind of funny. And we have a gal. So, I don't think we know this gal. But every time I see Powers, you know that's child support lady.
Dun 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 dun. Oh.
And I think this is a new judge for us. Actually.
Yes, I don't recognize this judge at all.
We've never seen her before. Yeah. All right, so this is going to be interesting, I think. I do like that the dad keeps showing up, even though he has an attorney now.
I mean, I would.
I mean, I want to know everything.
Yeah,
even if I can't talk, I want to know. If I don't have to have someone necessarily, I want someone to talk for me from a professional standpoint, but I still want to be there in case I have to say something.
Right, exactly.
I don't know. I saw his name, but I don't know if he's going to appear on the screen. And I'm really kind of wondering why we haven't seen the mother. And what was this hearing? This is hearing 4? We're only 40 minutes in. This is crazy.
Yeah.
Okay, I gotta stop pausing.
To respond, but gave them essentially till Thursday at midnight. My pleadings then were Friday. We did, looks like there was some confusion with the email copy, but we did provide a hard copy as well to the court. Did the court receive our reply documentation?
This is why I gotta stop pausing. The damn commercials.
Right.
I received your hard copies. I just did not receive the others, unfortunately, but I did not that's fine. I finally found the email. I'm sure it was just the holidays, but because I worked yesterday, I didn't have anybody to ask to see where they were. So it was solved. I was
that's
just
no
more
excuse.
concerned I didn't find them.
Okay, very good.
Right.
So with that, for the record, I'm Chelsea Baldwin. I represent Stephen Klopp. This is our motion for adequate cause as well as temporary orders. I'll note again, just procedurally, there was a previous minor modification where adequate cause was found for that approximately a year ago. The conditions have significantly deteriorated, resulting in us filing for a full adequate cause for a full modification. There was some objections filed to pleadings. I'll note that the objections filed to my pleading are a misunderstanding of the local court rule by opposing counsel. She read the rule to mean that you could only have your client's declaration and 4 single sheets of paper in addition to that for the witness declarations, instead of your client's declaration and up to 3 additional declarations of 4 pages each. And so while I have one declaration that runs over by a single page, I didn't then produce a 3rd declaration. So essentially I'm well under my total page limit. Counsel then used sort of that single page, and again, under the limit to file 13 additional pages of her client's declaration and about 70 pages of documents attached to those. She did those with a statement on parenting plan and then a supplemental declaration. I don't think the court should consider those. Additionally, I made evidentiary objections as to the declarations of Jackson and I think it's Remus, just lack of foundation. Neither of those people say they have any personal knowledge as to the specific sections that I called out. That being said, I'll just leave it to your honor to sort of make
she's there.
Make your internal judgments about what you reviewed and what you didn't. So in this case, we are asking the court to find adequate cause, and we're asking the court to place the child primarily in my client's home. It's currently a 50-50 parenting plan. The biggest risk to the child at this point is domestic violence that's occurring in the petitioner's home. The petitioner has a live-in boyfriend. He has a criminal record that includes assault history. And really concerningly, we have Miss Dahlman or Klopp, the petitioner calling out to the boyfriend's sister. So she's calling someone that's a relative to the boyfriend, saying she's scared of him, that he's throwing empty liquor bottles around the house, that he's putting the child in a locked room and locking the child into a room. That when he gets mad and angry, he's breaking things in the home. Again, when he's angry, clear signs of domestic violence. And we also have threats of violence, and we have these directly in text messages. And these are not, they're not unclear. The threat is, I'm going to put you and the child in a cardboard box. And it's very clear how the petitioner took that threat, that was a direct physical threat. She's trying to twist that into something else now, essentially using, and we know this because it's in her text messages that she submitted. So this isn't a he said, she said. We have it in the materials that the petitioner submits, where there's an acknowledgement by her and boyfriend that this was said. So again, huge concerns here, especially when you have the level of domestic violence where things are being thrown around the house. We have him breaking things in the house. And the conditions were deteriorated to the point where the petitioner called my client and his household 37 times
within just a few days reaching out for help. My client's like, of course I answered the phone. Of course we called her back and we missed those calls because she had the child. And in a week on, week off situation, you're not going to ignore that when she's reporting violence in her home. So my client is, of course, answering the phone, trying to problem solve, but without an order for him to be able to do much about it. All he can do is offer solutions. And ultimately, the petitioner doesn't take any of those solutions. She decides to remain in that abusive relationship. Again, really significant concerns that we see marks on the child that are unexplained or where the explanation shifts over time. And that happens even in her statements to the court here in her pleadings. Marks that just don't make any sense and the explanation's not making any sense. Bruises, black eyes, things that don't really match normal injuries to a child. Bruises on shins and knees, I don't think I have any concerns. When you see bruises and marks on somebody's neck and face and black eyes, those don't match normal childhood injuries. And the explanations don't match. Again, when they shift, that's a huge red flag that this child is suffering in this home. Again, my client reports he knows the boyfriend, that the boyfriend does not like children, and that is adamant that he does not like children, and he does not write a declaration here. Her main partner, petitioner's main partner, main live-in person, writes no declaration otherwise, does not dispute any of the allegations that are made, nothing. And the lack of evidence here is a statement. And I would say a number of the things that were presented by my client are really not denied. There's some attempts to sort of excuse them away, or gee, child really likes this person. Again, children are not going to bite the hand that feeds them. They don't have, especially young children, do not have a lot of options in a household like this. They have to put up a good front because they know the consequences when they don't. So children like this, I'm going to stay in my locked room. I'm going to be quiet. I'm going to avoid getting hurt. And so there's not a lot of choices children this age have. It's notable that in the text messages submitted by a petitioner, she states unequivocally that she told child that essentially if her and boyfriend break up, that it's child's fault. That I wouldn't blame him if he left us. So these are words she's telling my client, hey, I told child this. I'm blaming child, putting this full weight of my adult relationship on this grade school age child, which is incredible. And again, she admits this in the text messages she submits. So again, we have this incredibly toxic and abusive relationship, but we also have a parent that's putting that level of weight on this very young child. My client reports child having some behavioral issues, some difficulties, and that's not surprising given the environment in mom's household and the struggles the child's having there. So the very first thing we have here is a significant, very real safety threat. That's followed by evidence of really extreme imbalance on the part of the petitioner that's resulted in not one, but two protective orders within this last year. So we see the original protective order that was entered in March of 2023 due to the petitioner's behaviors of just harassing, stalking, repeated behaviors that just were not abated by the normal, please stop, please stay away, couldn't get her to do that. So district court enters an order that says stay away. But that does not solve the problem, sadly. We see subsequently to that, so get an order, all of the things that my client sort of spends the majority of his declaration and his significant other's declaration happened after this March order. And those are things like entering my client's home uninvited, so just walking right in, opening the door, but going so far as to do this at night when my client and his spouse are sleeping in their bed. They wake up to her hovering over them as they slept. I can't imagine how unnerving that was for my client to wake up and here she is in their bedroom. So she made it through not one, but at least two doors at night. So again, these are really...
What the hell, lady? What are you doing in their bedroom in the middle of the night? The fact that she's sitting there... Actually, I think we should all take note of the people's facial expressions. He's, I think, super stoic because he's like, you know what, my attorney's talking for me now, and she's good at it. I don't need to say a word. The ex-wife does not look phased at all. But why does her attorney look like she's like, oh?
Her attorney's
she
like,
doesn't know what the.
Really?
I mean, I might have paused it at a. Even the judge, the judge's face too.
The judge
like,
looks confused. Like she's like, what? She's kind of doing the same thing I'm doing. Like, really?
The facial expressions are like, I don't know. I just paused it at the right spot. What the hell? But I don't know why, but I'm getting like there's something about this. The fact that this other attorney for the mother is in this session, because clearly she's not on the case. I'm assuming she's not on the case anymore, right? So the fact that and I'm assuming she's in the Zoom because, they have, other cases for the day.
Right.
But the fact that her former attorney is in this thing and is potentially listening to this, to me, is hilarious. Because it's like, lady, what were you doing? Do you see your former client has spiraled? Like, what is going on?
Well, I'm just going to go, Kapoomy.
Maybe we need to start, having people mentally tested before we get into relationships now. Not just medical, I need to see your level of crazy before you move in with me. I need to see your level of crazy before I get married. I need to know everything. I need to know if you have any crazy situations with your exes that I need to worry about.
Right.
Because that right there, I don't think I want to be in a relationship with someone who I'm sleeping and I open my eyes and they're staring at me. Yeah. That's crazy. That's cray-cray. That's a whole other level of crazy.
That's why I went creepy.
I'm starting to wonder if there's something wrong with her because she's literally. I mean, at least she's not hysterical, but she's not denying anything. It's funny to see sometimes these well-behaved people in court because their good behavior is also sometimes seems a little sketchy. If she had to have done it, because if she hadn't done it, we would be seeing her making faces and be like, no, that didn't happen, because people can't help themselves but be animated. Okay, let's get back to it.
Extreme behaviors. We have the petitioner throwing things at my client's significant other. Again, entering their home multiple times to the point of, walking. My client says we were in the backyard. She walks all the way through the whole house and enters the backyard. And, we're all of a sudden shocked to find her there. Evidence of stalking where, again, it's a week on, week off parenting plan. And she's there at the child's school when it's not her time, essentially just watching the pickup. Driving by my client's place of employment repeatedly, driving by stepmom repeatedly, over and over again. And these are often with child. In fact, the majority of these actions are with child in tow. These actions are so significant and so repeated and ongoing that the order gets moved to Superior Court and an additional protective order is entered. That happens in November of 2023. And not only is it a more restrictive order entered, but it's expanded in time to last longer because, again, these issues are not abated. And unfortunately, my client and its significant other report, it's still not abated. There's an order that is essentially at these exchanges, you can't come to the house anymore. We have to do them in a parking lot, stay with your vehicle. And instead of staying with the vehicle, it's, okay, now I'm going to walk all around and kind of play this, well, so long as I'm not, within 30 feet, I can't get in trouble. But the problem is kids in tow for all of this. Child's watching all of this and all of this behavior that's really unhealthy and unhinged. It doesn't make any sense in the context of what's going on, other than for it to be a continuing level of this harassment and just creating conflict where none needs to exist. I'll note there's indications that the petitioner herself is just unstable, and that's the underlying issue. Really, is an instability that's resulted in all of this behavior that's been ongoing for at this point more than a year. We see multiple job changes, her getting fired, her quitting in lieu of getting fired. There's a whole number of issues that sort of, my client reports some of the symptoms, but you see also some of the outflow of that in petitioners' regular daily living. So again, huge concerns there. My client also reports that the child was with him more than the scheduled time, which is important, that even though it was a week on, week off plan, that my client or my client's family had the child every Thursday and every Friday for an extended period of time. Mom then realized she wasn't getting that she had the child maybe only about 40% of the time. So then said, well, I'm going to take that away and create a cost and put child in daycare instead of allowing my client to have child during this time off and for a family member to care for the child, even though that had been going on for an extended period of time. And again, what we see, there's just that abusive use of conflict of, I'm going to create conflict because what I want isn't happening. There are issues with neglect. We see some issues with medical neglect. Again, child at this point, he's not the 99th percentile for weight, he's over that. So he's past the chart where the chart is going to graph him. They just don't go to 100%. It just stops at more than 99. She tries to sort of clean this up saying, hey, he's always been a stout kid. The previous record is one from about 4 or 5 years ago. It shows the child's at the 90th percentile, but that's tracking relatively close to height. And now we see that's jumped up more than 10 percentiles, and child's no longer tracking. My client reports child having difficulty eating sort of normal everyday foods because mother's household doesn't eat those foods, eats foods that are essentially entirely fast food. That might be, while not healthy, might be fine in a normal context. It's not fine when a child's into the obese category and isn't healthy. And has the manifestations of that. Child's huffing and puffing when he's exercising, when he's playing, when he's doing normal childhood activities, he's suffering for this. And that's not appropriate nor fair to a child this age who doesn't have control over their diet. Children that are grade school age children, they're really almost entirely reliant on their parents to make choices for them. A child 50% of the time is being forced into very poor choices. Notably, my client wants to involve the child in activities, continue things. Last year, the child's involved in wrestling. It's physically active, it's healthy. By some of the witness declarations, he enjoyed it and had a great time. Mom says no. And I'll just say no, it's I'm going to wait. I'm going to not answer. And she said, well, my lawyer answered in 2 weeks. It took 2 weeks to get that answer. And so again, I'm not going to answer Dad. My attorney is I'm going to wait to answer my lawyer. This is not an issue where the lawyer isn't communicating that. I don't believe that. I'm going to wait. And again, it's that abusive use of conflict. I'm going to have child sort of forfeit being able to participate by just not responding. Similarly, child's facing educational neglect in mom's household. In a 50-50 parenting plan, we see this child who both sides of it has some struggles with reading, and yet mom pulls child from school at least 2 times for some 2 very substantial periods of time for the child to travel for reasons that don't make any sense. One, and again, not denied, was to help petitioner's mother in her divorce. So grandmother's getting a divorce and child's forced to go along and miss school. And my client very clearly says, don't do this. You can go, but don't do this. Child's missing school when he needs to be there. And mom says, I'm doing it anyway. A similar instance where child then travels to Colorado and mom sort of just blows it off. But when we have a child that's struggling, we don't take them out of school and cause them to miss school when they desperately need to be there. There are concerns about mother's mental health. And again, that really goes into the instability. Mother sort of denies depression and anxiety, but out of the other side of her mouth, a page later in her declaration, admits to sobbing in front of the child and says, and her quote is, insane levels of stress. Those are indications that she's not doing well. When you're crying in front of your child and your child is distressed, that is a problem. So in this case, there's plenty of factors that warrant the adequate cause, and there are plenty of safety factors that clearly warrant change of the current parenting plan from the 50-50 to what my client has proposed. He's proposed a plan that minimizes conflict, and that's really one of the main goals here, is to minimize conflict, minimize mother's opportunity for abuse of conflict as much as possible. When it comes to child support, we provided my client's wage stub, and that he makes essentially $6,800 per month net. We didn't have any information from others, so it's hard to create a child support worksheet from nothing. Subsequently, she provided documentation that she's making $30 per hour. We just asked that the court impute her at $30 per hour full time. That would put her at just about $5,000 per month. That's gross. I haven't figured out the net yet. Normal taxes should be applied to that. Mother does appear to have a second job. So she's got a primary job, and then it looks like she's got a secondary job that's it looks to be sort of like a travel agent, that they're selling travel packages. That should be at an additional $500 per month, again, gross, based on what they've put her at or what they've provided in their documentation. So that would make her a total of $5,500 per month, again, gross, not net. Child support should be based on those figures. So again, at this point, we're asking the court to find adequate cause, given these facts, including so many of them essentially admitted by the petitioner. The court should place the child primarily with my client, about my client's proposed parenting plan, or child support, as we've proposed, and appoint a guardian ad litem.
Wow.
Response?
Yes, Your Honor. Thank you. In regards to the objection that we filed,
right.
It is our understanding, as through various brown bags, that the local rule states 4 pages in length total for declarations, which is what we went off of. But if Your Honor is stating that it is 4 pages per the 3 declarations, we understand there is still over the limit. They went 6 pages on Brooks' declaration, so we are objecting to that, asking it that it be stricken. In regards to everything that opposing counsel has brought up, I don't want to spend the court's time sort of rehashing this, but the vast majority, if not everything, has been brought up prior. All of these things about 50-50 time and all of these allegations about the boyfriend, have all been brought up prior. This is all raised judicata. They're now trying to raise it again, trying to get a punch in. We have the parties who entered a final parenting plan on April 24th, 2020, a temporary one on March 14th of this year, and an amended one on April 12th of this year. None of these final plans had any 191 factors in them. None of father's proposed parenting plans up until the current one filed in December even had a proposed 191. And with that, on father's proposed, there's no domestic violence. There is abusive use of litigation and mental health. There is no other indications such as addiction. So this DV, this addiction, all these things that they're saying, 1, it's already been adjudicated, and 2, father didn't even put it in a proposed parenting plan or raise it. If father really thought there was all of these issues, why would he sign off on a parenting plan with everything? Each of these parenting plans, no 191s and a 50-50. Nothing that they have submitted in their declaration or said today.
Sorry. Oh, I gotta rewind a little bit. I missed. I'm pretty sure Attorney Baldwin said most of this stuff has happened since the last parenting plan was entered, which is what I said earlier. Like, I'm thinking some of these things happened after. We're not talking about the protection orders. We're talking about the the abuse that's happening in the house, which she indicated. I'm assuming that he would have brought that stuff up had it happened back then.
Yeah, and we discussed that earlier. We discussed that real briefly earlier. This would have already been brought up.
I mean, we might be giving the dad the benefit of the doubt here, but
so far, I'm just gonna say that dad is shining like a gold watch right now, honestly. But I mean, That's my opinion.
I just feel like he would have, if that stuff happened back then, he would have said it.
Oh yeah.
So her attorney is gripping at straws here.
A little bit.
Nothing that they have submitted in their declaration or said today has occurred after the parenting plan of April 12th, 2023. This was all prior to this. It really, at this point, just appears to be gamesmanship and strategy on
Well,
their
she said it's
point, when all my client
deteriorating.
is trying to do is do what's in the best interest of their child. She just wants a resolution. There are a bunch of allegations and sort of general statements listed in Stephen's declaration and Brooks' declaration that don't have any timeframes. They're just these general allegations. So it's really hard for my client to defend and really state when equivocally this allegedly occurred or didn't. But I think it's important to touch on some of them, especially as opposing counsel brought them up today. One of the ones is the boyfriend. The boyfriend, Mitchell and Stephen, had a long-standing friendship. The assault that was here was 10 years ago, prior to the final parenting plan that he signed off on. This was never an issue with Stephen. This was never brought up. He allowed Brody to be around Mitchell the entire time that Brody was alive. It only became an issue suddenly right now in December of 2023. We have a declaration that states it's likely that Mitchell was not the aggressor, that Mitchell had been hit before by the prior girlfriend. The child and Mitchell have a very close relationship. They do a lot of things together, the hunting, doing cars, walks, all of that kind of stuff. This is not the child who is scared of their abuser situation, as opposing counsel states. It's a child who truly loves his stepdad and calls him stepdad. He's not pretending he likes it to survive in a home. The allegation that Stephen had the minor child more than 50% of the time, again, this is an allegation from 2020 that's already been adjudicated. But since they brought it up again, that's not correct. My client had the child every day up until they separated. She went to work. Then the child went one day to Stephen's, one day to his mom's. And that when the child got older, my client wanted to integrate the child into daycare to do the normal things, socialization, all of those things, not because she was trying to have abusive litigation. It was just the normal sort of how a child goes. My client, yes, has she been upset? Of course, but crying once doesn't mean let's take her child away. My client's been battling opposing party and his fiance for a year, from allegation after allegation after allegation. It's not unheard of that someone's gonna get upset. She's not sitting down the child and then all of a sudden turning on the waterworks to make the child uncomfortable. The child is a very sensitive child who, if he sees anybody upset or cry, is gonna ask what's wrong. We have opposing party who's accused my client of lying, who's accused her of lying the entire time, but she's proven every step of the way that she's not. Stephen says, oh, my client doesn't have fibromyalgia. She made this up. We've submitted her health records to show that she does. He's accused my client of neglecting his health when he's the one who basically called the child obese in front of the child at the last doctor's appointment. I think it was November 29th. All of the records show that he's been 90% or more percentile for weight. We submitted the declaration documents that show the last 3 years he's been 99% plus. It's not my client all of a sudden, let's feed him candy and snacks all day. It's something that's ever since he's been one has had an issue with it. My client's the one who raises health issues when we have opposing party who doesn't. At that doctor's appointment, my client was the one who raised the hearing issue, not opposing party. My client brought that up to the doctor's appointment and got those tests set up.
I want to know your deepest desire.
This attorney is crazy. It doesn't even matter when this stuff is happening. It's the fact that it's happening. And one of the things that his attorney said was that the things are deteriorating, meaning that they're getting worse. So even if it did happen prior to these other hearings, things have gotten worse, and need to be evaluated, and that's why they're asking for the guardian ad litem. So that there's a supposed to be a non-biased person to evaluate what's going on.
Yeah.
Party who just recently last month had a doctor's or a dentist appointment set for the child. My client was waiting at the dentist asking where you were, and he's like, oh, oops, I forgot, he's not even off the bus yet, and then had to reschedule it because Stephen forgot about the doctor's appointment. She doesn't badger or harass the child for information. She engages in normal dialogue that one would engage with their child. How is your day? How is school, etc. My client doesn't drink. My client doesn't use drugs. They submitted a TikTok video about lottery tickets from 3 years ago that she got as a gift, trying to demonstrate she has a gambling addiction. I got lottery tickets for Christmas. It doesn't mean I have a gambling addiction.
Nobody said anything about gambling.
My client received the pleadings. She went and independently took a hair follicle test. We submitted those records to the court to show that I don't use drugs. It was negative on everything they tested for. Regarding like the reading, my client is an avid participation with the child. Her concerns are when the child is at Stephen's house, the child can't progress to the next step or the next book until he achieves.
Now, why are we bringing up a bunch of crap that doesn't make any sense? Okay, of course. There's nobody said anything about gambling. Nobody said anything about the dad causing problems so far. Am I until now? What the hell?
I don't remember there being any mention of gambling.
No.
So I don't know why that's being brought up out of nowhere.
Or drugs or alcohol.
No, well, I think it was brought up about her boyfriend drinking and throwing bottles
during the same hearing, right?
Yeah, but they didn't say anything about the ex-wife drinking and throwing bottles.
Right.
It was about the boyfriend doing it. So
I'm confused here.
She's gripping at straws here too on that.
And the gambling thing is like way in left field.
Yeah, that wasn't even brought up. So now she's airing out her own client's issues.
Perfection. The child has expressed to my client that he is scared about doing the reading at dad's house because he has to be perfect. And if he's not perfect, he's scared of that. My client has tried to address the reading issue, rebuffed by dad. My client tries to address school issues, rebuffed by dad. We've submitted those text messages. The majority of these issues stem from this protection order that is between Stephen's fiance and my client. And what dad's trying to do is make it appear like this is his protection order, that he's on the protection order. Brooke never asked for Stephen or Brody to be on the protection order, and Stephen and Brody are not on the protection order. Additionally, when they went to the modification hearing on May 31st, Judge Hayes indicated that a protection order should not have even been issued as it significantly was going to impact my client's joint custody. My client obtained
that's her fault
to state that things are now all of a sudden getting worse, which again is just blanket allegations. There's no dates, there's no times. So it's not like on this date she did this. So there's nothing showing that anything has happened since April 12th. It's just that, it's just stating it. One thing they're saying is my client is crazy and walks around the car at exchanges and she's not supposed to. But again, this protection order is not about Brody or Stephen, it's about Brooke. And she only has to stay in the car when Brooke's at a protection, or when Brooke's at the exchange. Brooke's been at one exchange. She's allowed to get out of her car at all the other exchanges. My client has not been to their home since March of this year. My client's never gone into their bedroom and stood and leered over them at night. And my client's not used any firearms or been violent with her. And again, we have to do a general denial of these because we don't have any corroborating evidence or any dates to do anything else. There are times that my client can't avoid driving by Stephen's work, but again, there is no protection order against Stephen. You know, it's a very small town. Her family owns a business. She wants to go to a certain grocery store. She can't help but drive by it. But again, there's nothing saying that she can't. My client only calls the police when Brooke has violated her own protection order. Regarding a few other allegations raised by Brooke, again, you look at the first two things that Brooks raises in her declaration. It's an allegation from 2019 and 2021. Again, issues that have already been addressed and decided upon prior to these orders being entered. Regarding the wrestling, and she doesn't want the child to be involved in wrestling. Of course she does. This protection order has put a kink in how my client can bring the child for practice, go to practices and games. So there takes a little bit more. So she definitely wants the child involved, but it might involve having to amend a protection order. So my client.
Muted.
It's not violating this every other week for games and practices. The child is not behind in school. There is an email from the teacher saying that he's good. He's ahead in the class. Regarding child support, opposing party didn't provide sufficient information to determine if there should be modification. He's provided one pay stub that is a month old when the RCW requires current pay stubs, more than one, in the last 2 years of tax returns, which he didn't do. They also didn't do a child support worksheet. They certainly could have done one based on minimum wage or whatever else they think that she makes. We did a financial summary. We took exactly what she makes, ran it through a year to date. Her average is $3,080.
Minimum wage. He knows she makes $30 an hour. Why would he only give her credit for minimum wage?
Good point.
Two, we did the same thing with opposing party, and we did his average of what his average is, and it's not $6,000 a month. His average gross is $94.53. I think actually Ms. Baldwin said that was net. And a side income, I have no idea where Ms. Baldwin gets $500, but we presented her pay for this year, and it shows for the travel that she made $373.92. That's $31.16 a month. So our request is that we deny the motion for adequate cause, leave the current parenting plan in place, deny the request for a GAL, but if the court does appoint one, and it, with all of these allegations back and forth, it makes sense. We ask that Stephen, based on his income, pay 100%. We also ask that the parties utilize Our Family Wizard, deny the request to modify child support, their request for fees, and we're requesting a $3,000 contribution. Thank you.
Rebuttal.
Thank you. Well, first, when you look, the first allegation is essentially, hey, none of this happened in 2023. Ignore all of this. It's all been resolved. But when you look at the declaration of Brooke Adams, she states, there have been instances where I discovered Lacey in my bedroom and my children and I have awakened to the unsettling sight of her watching us while we slept. This happened several times in 2023. So this idea that this is all old information, not accurate. The original filing for the modification was October of 2022. So that filing wouldn't have included any information from 2023 in that original filing. So again, we have instance after instance after instance that occurred in 2023 to the point where it required the entry of a protection order and then the increase and modification of that protection order. What they've provided from district court is in no way a transcript. And two, even if you read what they wrote, it's essentially the court saying, hey, this involves Superior Court matters. I'm going to send it to Superior Court because they have the right to do that. That's not saying that the order shouldn't have been entered. And then Superior Court entered an order, strengthened it, and extended it. So this idea of, oh, it should have not have been put in place, it's just false. It rings false and it is false. As to, hey, again, nothing's happened. There are multiple incidences, multiple protection orders had to be put in place. Ms. Adams, my client's fiance, can't include this child on the protection order. She's not a parent of this child. That would be inappropriate.
My client's trying to modify the parenting plan in part to create these boundaries. That was one of the reasons why he filed for the original modification, was to create boundaries in the hopes that that resolved some of these behaviors. It did.
I'm Peggy. The ancient cave whispered mysteries as my fingers brushed a weathered stone statue.
Didn't. Some of them have gotten significantly worse over the last year, necessitating a full modification. Again, counsel tries to undermine, saying, hey, my client really doesn't have mental health issues. Her own declaration belies this, though. She says the level of stress this year, not this one time, this year has been insane. These are her own words. The vast majority of this case is proven by the petitioner's own words and own texts that she submits. Again, the risks and the domestic violence in her household. When we look at things like the child being able to participate in a physical activity that he needs, it's essentially, unless you drop the protection order, child isn't going to get to go. Unless you do what I want, child isn't going to get to go. That's abusive use of conflict. It's and in no way do you see in any of the materials as, hey, here's how we can work out transportation. It's just, I'm not getting.
It does seem like she's keeping the child out of activities unless they drop the protection order. I find the claim that it's too difficult a bit hard to swallow.
What I want, so child will be the one to suffer. Which again isn't appropriate. When we look at her pulling child out of school, she pulled child out of school to do a 29-hour drive for her mother's divorce. That is illogical and not in this child's best interests in any realm of thinking. So again, we have serious issues with domestic violence. We have the petitioner's live-in boyfriend remaining completely silent. Which is a huge concern. We have protection order, an amended and increased protection order. We have child being pulled from school. We have child who has some pretty significant and increasing issues with weight and weight gain. And we have child with some behaviors that are markers of abuse and concern. And again, that child's being locked in a room. Anytime you're locking a child in a room, there's huge red flags. So given this, we believe our request is more than appropriate. Additionally, there's no question the court should appoint a guardian ad litem for this young child. And as far as child support goes, again, I can't guess at what the petitioner's income is now that we have it. $30 per hour at a full-time is how we got to the number I provided, plus $500. Again, that's what the gross number on that they provided is $498 and some cents. So $500 gross per month is reasonable for that second job. That's what you should base the child support figures off of. We're asking for that one.
So, Ms. Baldwin, I had one question in regard to, and I don't know if I missed it or what, and it has to do with the statements about the child and abuse, the black eye and those things. Is there a date somewhere?
I don't know that there's, if the photos are dated or not. I know there was photos of them, but I don't know if they had a date or if the text messages had a date that included the year.
I didn't see the text messages having a date. I found that a problem in a number of these things that were submitted by both sides, that there's no date on text messages.
Your Honor, the date for the black eye was 12/23/22.
Wow.
So
Okay.
that would have been after. So if it's 12/23/22, the original petition for modification was filed in October of 22.
Oh, so so that's what happened. He asked for a modification in October 2022, and Judge Fassett decided to adhere to what the mother had.
Right.
So his concern for changing the custody thing kind of just get washed out, like washed
It got
away.
washed. Yeah.
Yeah, so you can't say that he wasn't trying to address the situation. He was trying to, what would essentially be now over a year and a half ago, almost.
Right.
Well, a year ago.
The other question I had is,
which puts me back on my original point.
In March of 23.
Which puts me back on my original point that this was never addressed. This issue was never addressed. It wasn't addressed properly. So that makes sense for Miss Baldwin to go back and check it, go back through it.
Because she didn't have an attorney at the time, right. So she's, covering her bases.
She's...
yeah. Seeing as how she's a commissioner, she must know she can do it. Whether the judge, the other judge listens. That's the crux of it.
Yeah.
Child support had mom's net at $2,856 and dad's at $5,891.90. And I'm trying to, obviously, some time has passed here, but it seems like a significant, I'm hearing significantly different figures.
Our figures are about the same for dad. We had dad netting about 58.46 and mom netting 26.93. So ours are fairly similar to what, and we just used the actual pay stubs and did year-to-date calculations. So we're basically the same as prior.
Why is there child support if it's 50-50?
So my client's income is based off of his year-to-date. They're using a gross and I'm using a net. So I don't think that's my client is significantly different than it was previously. What they're doing for their client is she's making $30 per hour, but they're basically letting her work however much she wants. So they're dividing her year-to-date net or her year-to-date gross by 12, and I'm figuring her income by taking her hourly rate and multiplying by a full-time hourly rate. So I'm saying, hey, she makes $30 an hour times a 40-hour week times 4.23. That's her. That's what the court should impute as her gross. They're saying don't impute her at full time. She can work sort of however she can work part time. So they want to use sort of a part time amount of work for the child support figure. So I think that's the difference in the mother's income.
It's not actually, Your Honor, how we calculated it. It's divided by 12. We did a summary. We input it in. My client works 25 hours a week and goes to school full time. So she can't go to school full time and work full time.
Actually, people do that, but whatever.
In this date and this date, you made X, put it in the calculator, and it told us, which is only $200 off from what child support has done. So basically, our calculations are very similar to what child support's done.
We just don't have any information.
So Ms. Powers is present. They have filed an interest in child support. Ms. Powers?
Thanks, Your Honor. We actually just filed a declaration of state's interest in this case. The child is on state medical. So we'd ask whatever the court orders about child support that it include a provision identifying that the child is receiving public benefits through the mother.
No objection. We'll make sure that's included.
All right. So first off, I'm going to go through the objections. In regard to the objections by the respondent, the declaration of Brenda Jackson in consideration of that, I did not.
That's just It's your look, your rules. Disney Illy Forever, inspired by Minnie Mouse. What's your dream style?
As a professional surfer, I've been paid to wear clothing since I was a young kid. Seeing the negative impacts of
Consider it. I couldn't figure out or see, the affidavit does not define how the person comes by the information. It talks about a number of things, so that declaration will be stricken. Declaration of Sarah Remmers, page 2, line 13 is stricken as hearsay. The information for temporary parenting plan, the court does find the document to be additional information added by Ms. Klopp in violation of the length of affidavits allowed and will not consider the additional explanations, but solely the parts that are that of essentially a proposed parenting plan. In regard to Exhibit 7, the declaration of Lacey Klopp, this is essentially a declaration of a parent teacher that is not a sworn affidavit, will not be considered, although essentially the court is not going to consider this document already as stated. As to the objections by the petitioner, the affidavit of the respondent, it was 7 pages, but 7th page is the oath and signature. I've not counted that previously, will not count it here, so that affidavit stands. The affidavit of Brooke Adams is 6 pages. This does exceed the page limit, and I stopped reading at 4 pages. So the last 2 pages are not considered. The affidavit of the petitioner, this is 4 pages, so I'm not sure where there's an issue.
Say everything you need to in just 4 pages.
Even, further additional affidavit of the petitioner because of supposed length of respondents will not be allowed. And I don't know if I just twisted those. So all that said, about the timing of the petition, in looking at the modification of the parenting plan or decree under 2609-260, except as otherwise provided in 4, 5, 6, 8, and 10 of this section, the court shall not modify a prior custody decree or a parenting plan unless it finds upon the basis of facts that have arisen since the prior decree or plan or that were unknown to the court at the time of the prior decree or plan, that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child and is necessary to serve the best interests of the child. And then there's more in regard to military duty. But so my question, Ms. Baldwin, is you're going from the filing of the petition, and it appears that it seems that once that parenting plan was entered in April of 23, that would be the date. So I'm just curious what you're looking at.
No. So per statute, the date that you would look at is the last final parenting plan, and that was April of 2020. So all of the facts that have arisen since 2020 are relevant. Counsel repeatedly argues that hey, you shouldn't consider anything because essentially the case has gone quiet for the last year, so nothing's really all that bad. So that's why I was being clear, like, no, this is a situation where things are continuing to spiral out of control. But the statute's very clear. You go from the last final parenting plan, not the current temporary parenting plan. So my client sought.
Okay, I was mistaking something there. Okay,
no problem.
Apologize. Okay, Ms. Jocelyn.
Yes, Your Honor. The issue that we have with the parenting plan is that it should go from April 2023 forward. All of these things were considered in effect. Had they been raised or not considered, they would have been reflected in a plan. Why would Ms. Baldwin have a temporary plan entered in March and then April that said no 190?
They didn't have an attorney.
No restrictions, keeping both of these plans, the 20 plan and both of the 2023s at 50-50. We have to go with what has happened since April. If any of this was relevant or affected, it would have changed the plan in March. It would have changed the plan in April. You don't get to relitigate issues that were already brought up and decided because we had all of this plan. We have from 2020 until 2023. We took all that information and then in March 2023 had a new plan that was entered. So what we need to do is go from April 12th, 2023 forward.
So now that I have it clarified, for some reason I read it that a final had been entered and I didn't relook at it to verify. So I misread what had been stated. So with that, then it would go from what Ms. Baldwin has indicated. That said,
Ms. Baldwin is a sharp attorney. She rarely misses anything, and she really knows her stuff.
And she knows statute. Statute is law, unfortunately.
But here's the other thing.
For those that don't understand.
This other attorney was not on this case back in April or March.
No.
And neither was Ms. Baldwin. So, how is her attorney now saying, oh, well, Ms. Baldwin didn't bring this up back then? Because she wasn't on the case.
Correct.
He was pro se. Pro se means that you represent yourself, for anybody who doesn't know that. So, it's not necessarily the attorney relitigating something. It's my client had no representation.
Right.
And things have deteriorated since then.
Right.
Like, I don't know what part of deterioration this other lady is not understanding. And I also feel some type of way that the mother has turned off her camera. So is the stepfather beating her while she's listening to her court case? Or yelling at her?
The world may never know.
Are you drinking? Are you smoking? Like, why is your camera off, lady?
in regard to the overall and looking at this and weighing all the evidence, and to make it very clear, I did read everything other than what I indicated and reviewed the files and records. So although I may be short in what I ultimately state here, that I did review everything, and I want to make sure the parties are aware of that. I take it very seriously, and obviously this is about the best interests of a child and what's going to happen from here. In looking overall at what the court has significant concerns about has to do with the protection order and what occurred there. There's some pretty concerning behavior, and I agree with what Ms. Baldwin had indicated in regard to what had happened by the district court judge, is that they don't tend to like to handle things that impact and affect a superior court matter, so they transfer. It's not unusual. It's something we see on a regular basis because they know the impact of what they do is going to be significant on an effect on another case. But it's the behavior that's extremely concerning. One in which the court does question the mental health and does question the behavior of the mother and what's gone on there. So that's of significant concerns there. The child safety and domestic violence. Again, the court does find that significantly concerning and that it is within the time frame that we've been talking about, and one that brings the court great pause to try to figure out what it is that is going on in regard to that child. What
Your Honor,
hasn't
I apologize, Your Honor, and I understand you're going off that, but when we look at the RCW, it doesn't say final parenting plan, and this is significant whether we're looking at 2020 versus 2023. There's nothing in that RCW that says final. It says parenting plan.
It was temporary.
I wouldn't normally interrupt, Your Honor, but my concern is we're making a ruling off that when it's not final.
Grip, stability, precision. That's
so she's a little aggressive, huh?
Lawfin.
Wrong and strong. Like all these
I made my
commercials.
decision. I'm going on.
Was it not finalized though? Because I think I don't think the judge is going off that parenting plan. I think she's going off the one that's in
She's going off the information that's being presented to her, but if I'm not mistaken, this was all temporary. Like they've clearly been divorced for a while. So these changes are being made because something's happened.
Right.
I don't see why it even matters what parenting plan she's going off of, whatever decision that she's about to make. But I guess now that she's, politely interrupted the judge, let's see what happens.
Off of what Ms. Baldwin has indicated, please don't interrupt again. So in regard to the allegations and the statements that have been made, the court has significant concerns. And in regard to the criminal history, understanding that it is older and the content does give the court concern. So looking at the dates and that, and then weighing that with what else has occurred creates an issue of concern. Instability, there are lots of reasons people leave jobs. I'm not making that a big issue of concern as far as that goes. The neglect of child's health care, this appears to be something that's been an issue for some time. Is it another possible concern that needs to be addressed? Probably for the, not probably, but it should be for the best interest of the child. Do I weigh that as being the big factor here? No. Mental health, as I said, looking at what's gone on in regard to the restraining order and the basis for the restraining order, that is of significant concern, as I already indicated. Addiction, the court doesn't see significant basis in regard to that part of it. The hair follicle test was provided, and so no, there's nothing there that is supported as far as that part of it goes. Schooling, the court always has concerns when a child makes decisions to pull a child from school for this or that. Sometimes it's something that can happen and needs to happen, but there is concern that this is occurring as often as it is. The wrestling, when a flat-out denial is made, that's something that I think could be addressed one way or the other. And although it's a concern, it's not a major issue here. Overall, the major issues that I'm looking at are what the court finds of concern is the behavior as it relates to the basis for the restraining order and the mental health that comes with that, and the what appears to be, and the court can't make a finding at this point that it has to be I apologize, I didn't write his name down. The particular individual, but it's the overall looking at what's going on in mom's home that's of great concern. So at this point, the court does find there is adequate cause to proceed forward. This is an adequate cause hearing, so the court does find the basis to proceed forward. The showing has been made. And then in regard to what needs to occur pending a final decision of what may or may not happen. The court does believe that a guardian ad litem is appropriate and that the question, do I use these three same names or what do I? Okay.
Will be Amy Turnbull, Beth Fellows, and Karen Lawrence.
All right, so the three names are Amy Turnbull, Beth Fellows, and Karen Lawrence. Ms. Baldwin, do you strike any of those?
I'll strike Karen Lawrence.
Okay, Ms. Jocelyn, do you strike any of those?
We'll strike Ms. Fellows.
Wow, the lady who's there.
Amy Turnbull. Amy Turnbull will be.
So she made herself visible and then got stricken.
Appointed as the guardian ad litem.
Wait. I don't understand.
What I'm going to do.
Okay, so one of the gals has been sitting in this hearing the whole time.
Right.
Like I said, you know, they have a docket, right? So some people probably sit on Zoom the whole day.
Right.
So the judge gave three names. Baldwin striked one of them, and hilariously, the other attorney striked the woman who had just unmuted herself and put the camera on. So
okay.
The minute that she rejected her, the woman turned her camera off and muted again. I don't know if she thought, oh, if I'm sitting here, they'll pick me.
Right.
Maybe she didn't want her there because she knows that she's been listening in on the case. But, I mean, I don't know. I don't know how that works. Does it matter if the person has, like, I guess maybe it would matter. It's like having a witness in the courtroom before the witness testifies. Maybe you want someone who, you know, to be partial, or not partial, impartial. Someone who has no bias.
Yeah.
But if she's been watching the case already, she may have maybe had her opinion already based. I don't know. But I thought that was funny.
In regard to the guardian ad litem is in regard to, I'm going to make this 50-50 at this point. That can be reconsidered and re-looked at later on.
Why should he have to pay for the mother's abuse?
In regard to the pay at this point, understanding I will be looking at child support a little bit differently than I am in regard to the guardian ad litem. But in regard to the father, that will be private pay. In regard to the mother, I'm going to make that county pay. Once she was determined to receive state benefits, I think that's only appropriate.
Isn't it weird for in a custody situation that you have one parent who gets public assistance and then you get and the other parent doesn't have public assistance?
Right.
It's kind of, to some extent it's kind of weird, but then I think, like, in another sense, it maybe it's not fair to the parent who doesn't have it to have to make up for the cost for them to not have public assistance. Because that means that they would have to pay more, potentially, to maintain that other parent's household.
True.
And I don't know if that's fair.
Then the standard dates need to be included.
Does Your Honor want a 30-day? So you can include a 30-day check-in to make sure they pay their fees, but I don't find that necessary. Okay.
No. So pending a guardian ad litem report, the court is looking at currently a 50-50 plan. And a plan such as that is one where parties can communicate, parties can get along, and looking at the issues again that are great concern at this point that I have in regard to the mother, again, being the basis for the restraining order and the mental health of where mom is at this point, the concern as to the safety of the child. That based on that, I am going to be looking at what I would call more of a standard type of schedule at this point, where the child will live primarily with the father, and the mother will have the child the first, third, and alternating fifth weekends of the month.
Oh,
Fridays shall define the
Yeah, it flipped
weekend.
over.
No, it didn't flip. They were 50-50. So it was 1 week on, 1 week off. Now he
yeah.
has primary custody, and now she has like standard visitation. Whoa. That's an ouch.
Ms. Jocelyn, you indicated your client is going to school. Do you know what time on Fridays maybe she is available?
Wow. They're not playing when it comes to safety.
She's remote school, so anytime is fine, so she could do an after school.
Okay. Child's going to what school? Remind me.
I don't know the school. I know it's in Castle Rock School District.
Castle Rock Elementary
Castle
School.
Rock, okay. All right, so mom can pick up the child from school on her weekends. And then on Sundays, remind me where the exchange has been at this point.
They're doing the exchanges at the Park and Ride. It's in I believe it's in my proposed parenting plan.
Castle Rock Park and Ride.
All right, so that'll be where the exchange will be on Sundays at 5 p.m. For now, the father shall have sole decision-making. Any dispute will need to come to court. Standard holidays alternating. So really getting to a standard plan at this point until we have input from the guideline, with one condition is that I do not want the child to be unsupervised with Mr. Mitchell.
She's lucky that he's not being banned from the home.
A major concern in regard to.
It sounds like dad is getting most of the things he's requested. Primary custody and mom's BF has to be supervised. And we know she's not going to do that.
Drugs.
Yeah.
The mother shall not consume non-prescribed drugs. I don't think that's an issue. Is there anything else in regard to the parenting plan that you need to know?
I don't think so.
Right. In regard to child support, I'm not going to deviate a whole lot from what was just ordered as the figures for the parents' incomes. Do I think maybe it could change possibly? Yes, but at this time for temporary child support, it'll be refigured, but using the figures that I talked about of $2,856 for mom and $5,891 for dad.
So she's still getting child support for her alternate weekends.
And then the court will just have us keep everything else, essentially from that last support order in place, like tax return. Claiming the child, just maintain what's there.
Maintain what's there.
Okay.
Hmm.
I think that answers all my questions. Presentation in 2 weeks.
That's fine. Jocelyn, any questions? Anything else?
Yes.
No, Your Honor, the only thing we had asked for is the parties to utilize our family wizard.
No objection. Yeah, I would just ask each party pays their own fee, so it's kind of fair.
A parenting app is a fantastic idea with high conflict couples like this one.
No, I think that puts our presentation on the 16th.
All right. That concludes this matter. Clot v. Clot 19-3-00361-08, presentation of order.
Oh, we've seen this lady before too.
The state of Washington person.
Yeah.
Yeah. I mean, we're getting familiar with the court people. And the attorneys, and the judges, and the gals, and the custody lady. I mean, child support lady. Okay, so this was a short one. They're coming back in 2 weeks. I'm assuming the gal hasn't done anything by now, but
yeah,
I guess we'll see.
Present.
Thank you. I'm Lucy Baldwin. I represent Stephen Klopp, the respondent. So in this matter, my concern is that although we served and filed the orders timely, the objections were received yesterday on the holiday at 9 p.m. My guess is Your Honor doesn't have them. They certainly aren't in Odyssey. My guess is that they haven't even been filed since they were served to me on yesterday at 9 o'clock at night. So, has Your Honor had a chance to review those objections?
I have not, and I will tell you I'm not very happy about what's happened. I was here yesterday working on the files. Even if it had been filed yesterday, it would not have hit Odyssey. And so to get it at 9:15, I think is when it arrived in my email. There's no way I'm going to have the opportunity to see it, review it, and have this done for today, which I see that as a delayed tactic, and I don't appreciate it.
His tisk attorney
requested relief. I think it's either the court can just ignore the objections and enter the orders as is, or in lieu of that, I believe we don't have docket next week due to the judges being in a conference, if I'm correct. So that would take us to the 30th. The 30th is fine, but I'd ask for terms of an hour of my time, which we're basically at today for when I started logging on. My hourly rate's $5.25, so I would just ask for terms of an hour over, and then over to the next available docket. Or you can put us to a presentation docket, whatever's more convenient for Your Honor.
You know what?
And if we can,
$5.25 an hour, and she still gets hired, right? That's I clearly joined the wrong profession. I should have stayed on track to go to law school.
No,
really
they make good money. Lawyers make good money.
I know some psychologists can too, but it's more like in a private sector and like where you're taking cash and not insurance.
True.
But
I actually need a break, so I will be back, guys, and we'll get going after that. Be 3 minutes.
Okay, I'm clocking. I don't have a watch, but I'm clock. Oh wait, I do have a watch. I'm clocking. I'm clocking. He said 3 minutes. It is 1:25. Da 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 da. Mm-mm-mm. I really should have went to law school. Hindsight.
I'm back.
Wait, I gotta check the time. Oh, yeah, 3 minutes.
Hey, I made it. Hey.
All right, here. This I wanted to say, yeah, courts don't like it when you do shit at the last minute, and then they can sometimes, you can get kind of punished in a way. I remember my boss sent me. So I know it's kind of confusing because in your state, in your for me, I'm in New York, so in my borough, we do have like a Supreme Court and we have a civil court. The civil court is usually, like civil matters, like law, like suing each other or whatever. But in the Supreme Court is where you have like your negligence cases, your med malpractice cases, like those type of things, and probably other stuff. But I was only in dealing with personal injury law. So I had one day I had to go to the civil court building for a Supreme Court case, I think it was. And I had to go up to the judge to request an adjournment. And the judge was so pissed that my boss had sent me to request the adjournment that I think that they didn't grant it. Like they can do that kind of thing. So I don't think it was good on this attorney, Jocelyn. This is the third time we're seeing this attorney. Now, second time we're seeing her, but third time we're seeing somebody from her office. So the first time, her attorney was completely unprepared, but had an opinion. The second time, the attorney, this lady, tried to make light of everything that's being put before the court, and then also didn't address certain things, or just made it like, oh well, this happened in the past, so we shouldn't talk about it now, which is kind of like ignorant of her because she knows statutes too, or statute of limitations. And now here we are the third time dealing with her office, and they can't even file paperwork on time. And 9 times out of 10, that's not, well, attorneys can be procrastinators. I know that from experience. There's been many a times that I've had to type up motions and literally get them to the courthouse 5 minutes before 5 o'clock. So I know about procrastinating in last minute, and it's not on me. The procrastination's on my boss, not me. But something tells me that either either she's a procrastinating attorney, or her client did not get her the information that she needed in a timely manner, and that's why they were late. I think this whole too, like filing things, being able to send things via email, which back when I was working was not like really a thing. We didn't send stuff by email like that to other attorneys. Everything was always printed, enveloped, and mailed. And when you had it postmarked is what mattered. But this whole email situation and e-filing stuff is making people who already are procrastinators and do things at the last minute really hit,
That whole law
go through the
changed because of
wire.
COVID, I think.
Well, yeah, I understand that, and let me tell you, I wish that when I worked in a law office that we had some of the liberties that they have now to do filing, because
Yeah.
we didn't even. I think e-filing or not. I don't know e-filing. I don't even know if that was a thing back then. I know that we were able to like go on the court website and look at our like documents that had already been filed,
Right.
but it was like I would have loved if I could have like filed motions by just uploading it to the to like a an app or program or whatever. That would have made my life like
Right.
completely easy. You know how much copying I had to do?
Oh yeah, it's all done by old school paperwork.
But I did love it.
Printing and printing and printing, filling out
loved it.
forms for days. Yeah, I know.
Like I I would have no objection to working in an attorney's office again. I liked doing motions.
I
And
would
liked
love to
trial
send
prep.
information as fast as possible. I'm a digital guy. I like to do things as fast as I can. I don't like to procrastinate
Well, this
or
attorney
fill
might
out
not
10
be for you
forms to
then.
do one thing.
Yeah, I was highly proud of myself yesterday for seeing my patient, doing my progress note like right then and there after I got off with him, and uploading it into the system and sending it via email the way I was supposed to, and not having to even think about it.
That's what I do commonly. I get
Yeah,
all
but
my
I
work done.
procrastinate sometimes. Like I even had to I asked the client, I'm like, okay, you told me you have poor work ethic. Do I need to be concerned about you getting this stuff back to me before our next session? And he's like, no, I'm gonna do it like when we get off. I'm like, okay. I would like to have it by Wednesday.
Oh,
So
yeah.
but I felt good, and I think maybe it's because of my discussion I even had with him about like work ethic and stuff.
Mhm.
I felt so good having completed everything and not having it sit on my shoulder
Right.
that I had to do it. Because you remember when I had to cover the clients for a week, I ended up like doing all my progress notes in one day, which was a lot,
Mhm.
and uploading everything in one day. And it was just so much easier to have the one person and do it in the one. Like I don't even know how my mentor does it. Like back to back people, which probably explains why you can never read her progress notes. But that's neither here nor there. Her
I
handwriting is
mean,
horrible.
that would make sense to me.
Yeah, I kind of I miss handwriting my progress notes too. Even though doing it on the computer is neater.
I wrote a lot of stuff down. I'm just gonna tell you this. I wrote a lot of stuff down, even though I wasn't supposed to. And the reason I wrote it down was because it was much easier for me to just keep track of it. Just no other reason, just to keep track of it. What cases I need to work on, what things I needed to do. None of it made any sense. Like if you were to read it, it would make no sense at all. And I did that on purpose.
I used to like any instructions that I would get, things I needed to do, my sessions, I would write them on these like legal pads
Mhm.
to the point where I had like stacks of like just legal pads, not even fully used up legal pads, but just stuff with just like a couple of filled in like pages.
Yeah. Because,
Honestly, now I think about it, I don't even know where that shit is right now. I think I have it somewhere. Because some of the stuff is confidential.
right.
I know it's in my room somewhere, but I used to do that a lot, like just write everything down. But
And then
I do
if I
like
didn't need the note
convenience of
anymore,
doing.
I'd destroy it with the confidential paperwork destroyer. Because there was always a company that came in to do destroy paperwork.
Oh, well, I'm not in an
So,
office, so everything now has to be uploaded on the computer.
oh yeah, no,
But I'm not even talking about now. I'm talking about when I was physically in Texas
yeah,
and had it, was in the office. I would have just like and I kind of wish I would have. I did transition to a notebook, so I also have like notebooks because I had to keep track of my hours and stuff. But
yeah, I kept track of
like
all that by notes and stuff.
I do sometimes, though I see the convenience of typing up my notes and how neat it is, I do sometimes miss the handwriting stuff.
Yeah.
Because you can do the handwriting while you're in session,
Oh yeah.
whereas like I don't type my notes while people are talking to me. Well, no, I did do that for the trauma questionnaire. I started typing that at that point, but everything is like I'm very big on being efficient, at least to the best of my ability.
I learned to be like more efficient over time. Like I used to type down notes and stuff as people were talking. And I got rather good at it.
Coming from a legal background, I am always in a mindset to have details. I'm too detailed oriented, I think, sometimes.
Yeah, a little bit.
But for me, like I said, having the legal background, you have to be.
Right.
Because any detail that you leave out is like an omission of information.
True.
At least that's how I see it. Okay, we still got a ways to go on this one. There's still like a whole good 2 hours and 20 minutes left. Lord have mercy. And it's already been 3 hours. Oh, yeah. Okay. We got to get moving. But shame on this attorney.
You heard, Your Honor.
Just a minute. 29th and 30th is when we're not having dockets. So the 23rd is actually open.
Okay, very good. 23rd is fine.
Ms. Jocelyn?
Yes, Your Honor, this wasn't a delay tactic. We asked Ms. Baldwin twice if she wanted to set it over. She certainly could have said yes. Ms. Baldwin, knowing that there was a holiday, didn't give us any additional time. She served it to us Tuesday afternoon, which gave us less than 3 days to respond.
I kind of missed.
Struggling to find finance and accounting
I missed what was
talent? Join
written.
the growing number of companies
But
embracing outsourced
I'm not trying to
finance
be
and accounting.
funny, but
I made it for my mom. It was actually in honor of my
I'm gonna wait for this to go over.
Last year, I was able to
an hour of my
real quick. If this hearing was January 16th, I am making the assumption, because there's only like one holiday in January, right? That it was Martin Luther King Day.
Yeah.
Yes, that's a holiday. Yes, it's a federal holiday. But what extra time do you need for a Monday off, lady? Come on now. Get your shit in on Friday. That way you can enjoy your Monday off. Like, I had to work on those type of days.
Yeah.
I didn't get a day off.
I didn't either. Especially
when you work for an attorney, and it's not and I don't know if they work, if it's like a whole firm, you know, with like, you know, 15 attorneys and 30 legal staff kind of situation. Maybe they have different rules and regulations. But I worked for a sole practitioner where for at least half of the time I worked for him, I was his only employee. So there were no like days off.
Right.
I don't even think I never got like a week off. Like and he was Jewish. So, you know, he doesn't observe Christmas, right? Well, actually he was one of those flip-floppy ones. Not flip-floppy, I take that back. He would observe non-Jewish holidays too.
Right.
But I think I only got off for maybe maybe Christmas and maybe like the day or so after. I don't think I was ever like, I didn't get a week off. Right. I didn't get a substantial amount of time off. So her claiming the holiday is a load of crap, but I'm sorry. And I went back a little bit too far, but I needed to see what was on the screen.
My time, which we're basically at today for when I started logging on, my hourly rate's $5.25. So I would just ask for terms of an hour over and then over to the next available docket. Or you can put us to a presentation docket, whatever's more convenient for Your Honor.
And if we can be heard, Your Honor.
Just a minute. 29th and 30th is when we're not having dockets. So the 23rd is actually open.
Okay, very good. 23rd is fine.
Ms. Jocelyn?
Your Honor, this wasn't a delay tactic. We asked Ms. Baldwin twice if she wanted to set it over. She certainly could have said yes. Ms. Baldwin, knowing that there was a holiday.
Why should she have to? You're the one not ready. Okay. That's what I missed.
Yeah.
didn't give us any additional time. She served it to us Tuesday afternoon, which gave us less than 3 days to respond. We would have had to review it, respond, and had it done by Friday. And so had she done it sooner, we would have had more time. She had more than a week to do it. We did it as soon as we could. I was waiting for my client to review as well. It's not our intention to delay it, which is why we've asked twice if she wants to set it over. Ms. Baldwin certainly didn't have to sit here for the last hour. Again, to us, that is games played to trying to get attorney's fees. We're not trying to short side anybody, but she also should have served us the proposed
Give me a
sooner,
break.
knowing that there was a holiday. It's inequitable to allow her 7 days to prepare them and us less than 3.
A real quick thing. If you're there for 1 minute, if you're there for an hour, you should get
bill
paid
for an
your
hour.
hourly rate. Sorry.
Yeah, that's generally how it works. Like
Yep.
if I have a schedule a patient for 45 minutes or 60 minutes and I only see them for 40 minutes of it, I'm billing for 45 or I'm billing for 60.
Right.
Like that is what, like, the time it takes me to make my notes is part of their session.
Yeah.
So cry me a river, attorney. Cry us a river. And she needs to be on time. So it's still an hour. She's crazy. She's gonna bill her client an hour.
3 days to review them. So we're certainly fine with the set over. We said that in the email. We're not trying to delay any games. There was a bunch of things in the order that she changed that wasn't ruled upon, so that's why it was very lengthy.
Your Honor, I apologize, Your Honor, if I may address the court.
Go ahead.
On behalf of the state, we did not receive a copy of the orders, so we haven't had a chance to review them. I know that Ms. Powers had requested medical language, so we haven't had a chance to review to see whether that was entered in the child support order.
We sent our proposed changes to Ms. Powers. I did not see Ms. Baldwin send it to the state on the email that came over to us.
Ms. Powers is no longer with the state.
Right. And also, I don't see, I've looked for Ms. Jocelyn and the case name. I don't see any emails until the objection came across my desk. So, yeah. So that is what it is. Maybe it was sent from a different person or with a different case name put on it. But I'm not seeing that. Up to Your Honor. Again, we served them on Tuesday. There was plenty of time. We are where we are.
Less than 3 days when they had a week is not equitable.
You're repeating yourself, Ms. Jocelyn. All right. At this point, there was a holiday. I get that. I don't understand why 3 days wouldn't have been enough, but so be it. At this point, there's no way I'm going to get through it with the state not receiving anything for that reason and that reason only. I'm going to go ahead and set this over 1 week and make sure to get that to the state so that they can make their objections. I won't grant any terms at this point, but for future, please don't assume that we don't work on holidays. We do. So, okay.
That's just it's your look, your rules.
Exactly.
Disney forever. Inspired by Stitch. What's
Especially since things come in through email. She could have sent that shit on Saturday.
Yeah.
Very good, over 1 week. Thank you.
I just want to quickly address number 5 on the docket to make sure where we're at with this. Unfortunately, I had sent an email to the incorrect email from Ms. Baldwin, so I expect she may not have seen it. And
we got the lady again. Great.
So we're actually in a good place to go forward. Ms. Winkles and I were able to work together to resolve 99% of the problems. We have a couple issues to address on the parenting plan. That's it. And so you should have.
It makes you wonder, though, is this why is this other attorney stepping in? Is it because the judge doesn't like you? Like, she might have felt some type of way and was like, look, I don't want to go there again.
packet before you of orders. I just want to make sure that the cover sheet to the orders has today's date on it, because I did revise them, and then those are the orders that Ms. Looney signed off on as well.
Okay. Orders that were received January 10th, so that would not be, I have that's the amended objections.
No clients today.
Not sure how these got back here.
I think this is just
I think those went through the clerk. Let me look at
check-in
another
hearing.
file here.
Well, the last one was adjourned. I want to know what the guardian ad litem is going to add.
So I have another set of orders, and let's see.
And those might be my orders, so just make sure that they're, because we also sent in orders.
There are Miss Baldwin's orders.
The judge looks like Dennis the Menace.
But let me.
Wow.
Getting Dennis the Menace vibes.
Wow.
And the cover sheet would just have today's date for presentation.
These went through the clerk's office, and there's no cover sheet is the problem.
If you look at the order of child support,
That's what I'm getting to.
it would be it would have Ms. Looney's signature on it.
Alright. There we go. Yes, I have Miss Looney's signature.
And that's the right packet. All right.
And then do you also have our packet of proposed orders?
I do not in that file. When did you submit them?
That would have been when the ice melted around town. So it would have been Thursday or Friday, whenever the court was reopened that day.
I do not have.
It is Washington, they get snow.
Objection to proposed orders.
Okay, they were filed the same day.
Okay, they're not in my, I call my clerk file, which are the orders that would have been submitted, so I'm not sure where that is. Do you have any other orders?
I do not have any other orders. There were things.
The age of technology.
It would have been last week. I actually went to the court myself to do it.
Okay.
The proposed orders and the objections were filed on the 18th.
Okay, so if they were titled proposed orders, then they got filed.
And then I did another one directly to the court. So I had the proposed with the cover sheet that would have said, original on the cover sheet, and then there would have been a second copy below that said original on the actual.
I'm not questioning that you did that. Unfortunately, I don't have them.
And I still think we can go forward. I'm the moving party. It's my job to draft the orders. Ms. Winkles is the objecting party, so she makes her objections and we go from there. So when we look at the order of child support, which I presume is what's before you, we agree to make one change. If you look at page 2 of that order, Ms. Winkles is just asking that at section 5, did you just want that second box under net income just struck, Ms. Winkles?
So the box that says that none of this is overtime, that's it. Essentially saying that yes, overtime's included. That wasn't in the original order, so I'm just requesting that it say no, that overtime's not included in this order for either of them.
That's fine. You can either write no or strike that section entirely. It's a temporary order.
Okay, I want to make sure under parents' income, paragraph 5, page 2 of the order, I have net monthly income $58.91. This income is his parents' actual income.
No, but only as to mother.
And I would disagree with that because the original order, which I'm looking at right now.
I'm just trying to make sure I'm adding what you want in the correct place. And you want me to add does not include overtime, correct?
That's fine.
Yeah, under section 5 or paragraph 5, where it says, does this parent have income or overtime from a second job? In the original order, which is the exhibit B, I believe my amended objection says no. Both of them say no.
Okay. So I see this now. Does this parent have income from overtime or a second job? And no. Okay.
I think with that change, you can sign the order.
I think it's funny that these people are in their offices and still have their like background blurry.
Absolutely.
Because there might be multiple people in those offices.
I've never seen anybody in the background.
I put approved via Zoom, and I have signed off on the child support order.
And they would still be seen.
So I will also sign off on the worksheets.
Very good.
Okay.
So next,
I was just going to say the adequate cause order we have no objections to, and we're okay with signing via Zoom.
Oops.
Okay, signing that order, putting approved via Zoom.
I feel like she has that other name on her Zoom as a like a dig.
And we do, so in this case, we're appointing Ms. Turnbull, who is here. Ms. Winkles is asking for an interim review. The court didn't order that, but I'm not objecting to that. I don't know if Ms. Turnbull wants to chime in on kind of her thoughts on how much time she would like for that.
Oh, this is a new gal.
Turnbull?
Yes, not being familiar with the case, I'm not sure how much there is to investigate here. Perhaps you could give me some guidance, and I will take your advice.
I would, after reviewing all the pleadings and everything, I would say it would be appropriate.
In the end,
I don't feel like that. I don't know if that answered her question though.
What's true can easily
have a good time.
Okay, I will take that.
And we were thinking of somewhere in March. I believe May is the final review that we have. March would be about 60 days. That seems fair.
Okay. I will take your advice.
60 days.
And that's fine.
So I'll add prior, just above the final GAL report review, I'll put interim review.
I'm going to do the 26th for a date.
Of March?
Yes.
I'm out of town that week.
Oh, that's right.
For 2 weeks.
That's right. We had the same issue. Either 1 week before or 2 weeks after. Do you have a preference, Ms. Turnbull?
Either way works fine with me.
All right, let's do March 19th if that works for everyone else.
And that works for me.
Okay. Adding March 19, 2024. I'm changing, and I'm putting at 9 a.m.
Oh, and that should be at 1 a.m. Sorry.
Yeah.
Thank you.
And then May 14, 2024 at 9 a.m.
Thank you.
Okay, is that all that needs changed there?
That's my understanding, yes.
Yes, that's it.
Thank you, Ms. Turnbull.
Thank you.
Being approved via Zoom for Ms. Winkles.
And that's fine.
Okay, so that leaves the final, the amended temporary parenting plan.
That's correct. So I think the easiest way to go through that is to just look at page 2 of opposing counsel's objections and just kind of go through those one at a time. She kind of lays those out by section.
Since they're my objections, I'd actually like to go through the sections because there's additional language here added. If you look at page 1 of my objection.
Hold on just 1 second. I need to make sure I initial something that I did.
Lady, this judge already does not like your office.
Looking at temporary parenting plan 1A. Go ahead, Ms. Winkles.
Yeah, so we've got the first page, and under abandonment, it should say, obviously neither parent has any of these problems. Under B, obviously, it should be emotional, physical problem and neglect. Those were reserved pending the GAL report, as you stated. We've actually included the transcripts from that here, and we also bought the CD. They're rough transcripts. They've not been transcribed by somebody with skill to do that, but they are there just to assist us here. The issue we have are sections 4, 5, and 12, and I'll go through section 4. There's limitations imposed. Your Honor stated that you didn't have enough information, that you were concerned with mother's mental health, but that you were really wanting you wanted the GAL to be involved. You can't have limitations with having reserves under findings. So you don't get one and not the other. You can't have limitations if you have no findings. The findings are reserved. So we'd ask that any of the limitations under section 4 be stricken. That section should also be reserved. So section 3B should say reserved. Section 4 should say reserved. Under decision making, we should have school and healthcare. Those should be with dad, and everything else under there reserved. Reasons for limitations. Again,
let's go through this bit by bit so I can make changes as necessary. So under paragraph 4, Ms. Baldwin.
So 3B is reserved. Under section 4, the court can put in limits. In this case, the court said it does have serious concerns for the safety of the child, and these are orders that the court made, that she needed to abide by the anti-harassment order, and that the child was not to have unsupervised time with the mother's boyfriend who presented a domestic violence risk. The court specifically made that order. So to just say, I'll just strike that off, that's not appropriate. The court made that specific order for the safety of the child. This is an appropriate place to put it because, again, some of the concerns here warrant that, and the level of concern warrants putting it here. Does the court want to stop at just section 4?
Yeah, I do.
And this is better for section 14 in that the court stated, and you'll see again, the transcripts under my objections are there. The court stated they had concerns, but that they had no information. And this was the problem, to impose a limitation without information. It is a safety mechanism in the court, absolutely, to not have this person that hasn't been vetted by the GAL yet, to have these mental health allegations. The court will remember a lot of these.
Let's not re-argue. Okay. Hold on. We don't have time to re-argue. If we are going to do that, I'm going to stop. I'm going to take the other cases. And so I heard argument. I get it. I know what you talked about, and I agree that I don't necessarily say that you can't put limitations on a parent just because you don't make certain findings, but I don't have a problem, honestly, with either place. They are things that are supposed to be done, but I have no problem putting them under paragraph 14. They still apply. And I haven't made any basis, so those can get moved to paragraph 14. And then just put reserved under 4.
Okay. I don't think you need any.
I know about the religious upbringing part and the extra curricular activities. Let's address the religious upbringing part in regard to
okay, wait a minute.
I don't think if there's a history of domestic violence, I don't think that they should hold off, or not history, but if there's an allegation of domestic violence, I don't think they should hold off on doing something until they have proof of the domestic violence, because if there really is domestic violence, you're putting the child at risk.
That's my point.
So
like, why are you?
I understand that limitation.
Why is she challenging that?
Because that's what she's getting paid to do.
You're an idiot.
She's getting paid.
You're still an idiot.
if something she's being asked to do goes against her moral compass, then she would relieve herself as the attorney. They would relieve themselves as the attorney. So I don't know. My whole thing is that if even and it's not that the kid is being domestically violated, but the mother is, and the kid is witness to it.
Welcome in, Donnie.
You would think that they would want that investigated and the child removed from that type of circumstance. And to be honest, because the custody has changed, what is the big deal that your abusive significant other, I'm sorry, alleged abusive significant other is not allowed to be left alone with your child? He shouldn't be alone with your child anyway, because your visitation is only over the weekend, and you should be spending as much time with your child as you can. Like, I don't. You would. Here's the thing: if the tables were turned, and the ex-husband was with an abusive woman, she would be asking for the same thing. So, I will never understand the hypocrisy. I really don't get it, and I don't the judge is not buying this shit either. So I guess that's a good thing.
Oh, so the religious upbringing, this is just a constitutional statement, and honestly, Ms. Winkles has an almost identical statement in her section 14. This is immaterial.
Yeah, that one's not the concern. It's the healthcare part that was the concern.
The healthcare part is the vast majority of that mirrors the restraining order that is, although the court will have to dig deep into Odyssey. We did attach it to my client's declaration, but there's a huge section that is part of their restraining order that talks about a medical emergency is where a child's airway is observably. So like all of that pieces are there. So a big section of this is part of the restraining order already. So we just copied and pasted a big section of this. The father being authorized to make healthcare appointments is basically already stated because the father is the decision maker. We're essentially allowing and making it clear how the mother is going to be involved. We're including the mother in a reasonable way and kind of detailing how that's going to happen. That's not a bad thing. That's a good thing in a high conflict case to detail out how specifically that's going to happen. And this was in my proposed order. This is not new. This was in my proposed order.
I'm red.
A mesothelioma diagnosis changes everything. But with Weitz and Luxembourg at your side.
Ms. Winkles?
Yeah, my concern is this was never litigated in that last hearing. It was not talked about or argued by both sides. There is a current restraining order, which is in place for this very reason. We don't need that language copied, and the word majority of concerns me because it means it wasn't just copied word for word. We have additional words in here that weren't included in the restraining order. If the restraining order is in place, why does this need to be in this order at all, especially when it wasn't litigated? That order still controls, that order still.
I think Attorney Baldwin has a good point. Making sure everything is spelled out in the order is the best way to do this with high conflict couples.
In place, nobody's changed that order. Additionally, that order is between my client and wife or fiance. I can't remember Mr. Klopp. It's not between Mr. Klopp and my client. It's not between child and my client. The only one restrained is the wife, girlfriend of Mr. Klopp, or the protected, I should say. It doesn't make sense to put it back in here when it wasn't argued and it wasn't ordered.
So unfortunately, that's not true. A bunch of the other children that are my client's children are also protected parties. So those children are in the household, they're in the cars. And we also don't want situations where, oh, that restraining order fell off and now it's sort of a free for all.
So in regard to these paragraphs, understanding in looking at the conflict that was going on between these parties and determining what's in the best interest of the children or child, in regard to the healthcare part of it. The last place we want is for that conflict to be an issue. And so I am going to leave this in.
It's because it's detrimental
So
to your
moving
case.
to 8 then in that case, which was just essentially when it applies, yeah. The weekends should be defined by the Fridays in the month, not the first Friday. Just the amount of Fridays, I think it's just a word. It should be defined by Fridays in the month, not the first Friday of the month, if that makes sense.
And I adamantly disagree because the first Friday of the month is how you count. So if it's the first, third, and alternating fifth, then the first Friday is how you then count. So mom doesn't get to decide which one is the first. This is the first Friday, and that's how you count the Fridays.
Correct.
So I guess it is a distinction, but it has a difference. So it's just how you look at the calendaring.
So in regard to this, I've always gone off the first Friday of the month. It's defined by the first Friday of the month, so it will remain as I can't even find the link.
You're nitpicking.
Yeah.
I see it.
Well, she's nitpicking.
Okay.
And
all right, holiday schedule.
It's being
well,
denied.
under that same section, if there's no school, transfer time should be the same time school lets out. We have it much later than even the Sunday transfer. If there's not going to be school, it should be 3 p.m. if no school, because that's the time mom was originally getting them. Why is it suddenly later if there's no school?
And that's to accommodate work schedules, because if mom's picking up directly from school, my client doesn't need to transport anywhere. But if it's a non-school day, then we need to have a transporter, and so sometimes that means somebody has to be out.
And then that limits my client's time to stay at home while she's working from home, and Mr. Klopp is off on Fridays.
Okay. Your point.
I'm sorry, where are you looking? I'm not.
Line's about 8, 9.
Yeah.
So she's looking at, there's a paren right at the end. It says every first, and then there's a paren or 6 p.m. if no school. So it's just what time if no school.
And neither party works on Friday. So it makes sense to have the 3 p.m. trade-off rather than waiting hours, because she would normally get the children at school at the end of school.
I say child, but
that,
whatever.
Actually, what I tend to do is actually go in the morning, but if neither of them working, it can be 3 p.m.
Very good.
Okay. That's
It's a damn shame.
Section 12.
It's a damn shame when the court has to micromanage your custody.
Yeah, because
like
because mom's being a pain in the rear.
These things should be able, like little things like
people do that. They do.
I just don't see where there needs to be a court order for visitation.
Because
it should be
because people
so
can't get
simple.
along.
Yeah, well, you got along enough to lay with them. I mean, or to get married.
Okay.
The holiday schedule, my apologies, section 10. If you look at that schedule, it's overly biased towards the parent with the majority of visitation. You'll see the even odd years are not followed. Typically, these parents have exchanged the split spring break in half. It should still be that way. We also have 4th of July. My client doesn't want that, but what my client does want is to see the child on Christmas Day. My client would like to have Thanksgiving, since she used to be 50-50, and now we've restrained her so much back. These are coming up quickly, especially spring break.
That's her fault.
I'm not as concerned with Thanksgiving or Christmas at this point, but spring break is coming up, and it makes sense that they split in half with the exchange at 12 on Wednesday.
Denied.
I maintained them from the last order.
TV.
So the complaint is I want to rewrite them, but I'm looking back at the March 2023 order, and these are what they were.
And that's when they both had 50-50.
Right. So I don't think that that's reasonable to say, well, now I want to rewrite this. I didn't argue this at the time.
So this is a temporary order. It's going to remain as written here.
Like let the gal make her decision. Like, first of all, spring break, the gal is supposed to, they have a case in March, right? Spring break is not usually until like what, April. So
March,
you know, bring it up in March. What you want to do for spring break? Why are you bringing it up now when you don't even know what the gal's findings are gonna be?
Okay, what's the hearing point?
Huh?
This is hearing what, 6, 7?
I think this is 6.
Okay,
But
so what's the hearing date?
this one was January 23rd. So you're asking for spring.
Away.
You're asking for a spring break in January when the gal is supposed to work on things between now or between then, January 23rd, and the March hearing.
Right.
So why not wait until your March hearing to address that when spring break is coming right up? Like, because who knows, the gal might come to the decision that they can go back to 50-50. Maybe by then the mother will have broken up with the boyfriend. You know, you never know.
Right.
This lady is this lady, who at least today has dry hair, is gripping at straws. I feel like you guys can't see my mouth circling her head, but whatever.
I can.
Easter is not in this order at all, though. Is that something we can take care of rather than come back on at least Easter?
I'll take no position. Your client's call or your honor's call.
Easter, well, Easter tends to go with spring break.
It does, and it does this year.
So if it's not a part of the spring break, I have no problem adding it, and you can do an amended or something to get it to me so it fits in. But yeah, do you know which it is, at the beginning or the end of spring break?
I think it's at the end of spring break this year.
Okay, so it would go to mom.
Okay.
That'll stand.
Okay.
Okay, anything else?
Section 12, the transportation should just say park and ride. None of the other was argued. Again, we're putting an order from a restraining order, which is in place and still current. It's not going to fall off between now and the end of trial. It's a good order, and it can be renewed quite easily. It just needs to say park and ride. That's what the court ordered. That's what's in the transcripts. Transportation's at the park and ride.
So so 2 things. The restraining order is set to expire in 2024. We do want these provisions to remain. 2, the restraining order protects specifically my client's children as well as his significant other. But we don't want the game to be played that if it's just him in the car, then all the rules are off and we can play this game. So again, we should have sort of the same rules, whether it's just my client in the car or him and the kids or him and his spouse. The rules should be the same. It should be incorporated into this order. That's reasonable.
And Your Honor, they attempted to get that protection order and it was denied. So to then essentially have it without argument now put into this order seems manifestly unfair. They attempted to get dad protected, and now they're going to get him protected without the benefit of having a hearing when it was denied in court previously. That seems really unfair.
Didn't I rule park and ride?
That's just us. It's your look, your rules. Disney Illy Forever, inspired by Minnie Mouse.
He
What's
must
your dream style?
just not be acting properly, even with that.
Creators and leaders.
They said that she would get out the car.
That's what you ruled. It's on the transcripts.
Okay, then it just needs to be park and ride. So you're going to have to get me a new order because I'm not going to.
Sure.
Okay.
Section 14H, it says the telephone privileges are from age 10. I've never seen an order limit a year. It usually says telephone privileges for the child. It doesn't give an age. What this does, if this child's 6, it means that there's no telephone privileges with mom for 4 years. It seems an arbitrary number that was chosen. It's not in the original. We would just ask that telephone privileges are from now. He can call mom can call child. It makes sense that way rather than suddenly picking some arbitrary number out of the air. It wasn't argued.
This wasn't argued and it wasn't ordered and it wasn't discussed. This is a high conflict case. What we don't want is then mothers calling child 10 times a day, fathers calling child in mother's household. The idea is at 10, the child is able to sort of manage some of those communications on his own. At 6, he's not able to. They're basically all have to be.
Exactly. That's literally exactly what I was thinking. A 10-year-old can control their own cell phone.
Right.
For those purposes. But I could see that because there's a restraining order against her.
Yeah, sure.
That
so Ms. Baldwin did that automatically, which makes sense.
Well, I don't know if she even added that or not, but the point of, oh, well, I can't do anything to them in person, but I can fuck with them on the phone.
Right.
Like, it's just giving her another tactic, as far as I'm concerned.
Ammunition.
So
I'm going to stop this. I have other cases I need to get to. So at this point, what I'm going to do is reserve on this because I'd like input from the guardian ad litem.
Exactly.
I'm going to leave it at this for the moment, and then I'm going to input from the guardian ad litem.
Can we also reserve on 14J in that case? That was just separate parent-teacher conferences. Can we just reserve for the GAL? I doubt there's any coming up at this point anyway.
She's like,
it's a little odd. The court can't force my client to do a joint parent-teacher conference.
No, I don't think I can. I think they have that right, and that's up to the school to set them up. And I think the school would want, with these 2 parents, to have separate conferences anyhow.
I agree.
Another tactic to be in his space.
Order.
Okay, very good.
Thank you, Your Honor.
All right, thank you.
The next 3 hearings were continued, March 19th, March 26th, and April 9th. I didn't include them because they didn't talk about anything but scheduling.
Thank you. That is so appreciated.
0361-08.
So wait a second. If those hearings were left out, were they identified here? They were not. So all of those other 3 things were rescheduled, but I guess they resolved the whole spring break thing anyway. So right. I guess it doesn't matter. So we're on hearing 7.
Here's Brady, and I have a couple of preliminary issues I want to address.
Go ahead.
Thank you. For the record, I'm Chelsea Baldwin, and I represent Stephen Klopp. There was a declaration of Lacey Klopp that was filed, and it contains a significant amount of hearsay or statements for which there's just simply no foundation, and I'd like to go through those with the court and have the court make some rulings on those.
Hold on just a second. Are we talking about the, well, let me see. My computer's going really slow. Just a second.
No problem.
We're talking about the one that was filed on April 10?
I believe so. The first paragraph starts, I've submitted the required paperwork.
Okay. Yeah, that's what I'm looking at.
Okay, very good. So page 1, the second paragraph, at lines 21 and 22, there's a claim that the child's bedwetting in my client's home. There's just simply no foundation for that statement. She's not in my client's home, doesn't make any statements that she gives.
Ms. Winkles?
Yes, my client states that she was informed that by Mr. And I believe there's text messages that support that.
It's not anywhere in this declaration.
I believe it was previously filed with the court or is in the medical. It may actually be in the medical statements. I believe both parents took the child to the doctor because of that issue. But I'll defer to Your Honor.
Okay. At this point, I'll strike it. I without knowing exactly where it's. You know, and ultimately, I will tell you, when I read this, I will go through this, but a lot of this I took as hearsay as as indicated. But let's go ahead.
So same page, just down on paragraph 3, the statement that the child's teacher is good friends. Again, no foundation for this statement, no evidence that supports it.
Ms. Winkles?
Yes, Your Honor. If you'll notice, the child's the teacher's supervisor is a family relation, has a family relationship with the stepmother, or I believe the father's girlfriend, is I'm calling her stepmother in this case, the supervisor of that person. And my client believes and alleges that due to that relationship with the supervisor directly to the stepmother, that they are friends, and considering the district's policy, it also makes sense. It's not hearsay, because there's no out-of-court statement that my client's relying on. That's not what it is. It's an allegation from my client.
So the statements, it's not hearsay is an allegation. There's no foundation, and it's sort of like, hey, maybe these people are related because they have the same last names. That doesn't make the underlying teacher a friend. And there's no statement of foundation otherwise.
I'm not going to strike it. I'll take it for the weight that it has, which I can only include as an assumption, because I don't see any foundation.
Assumption entered.
At page 4, at paragraph 17, and it's actually line 17 as well. So again, no foundation for the statement that respondent has changed the dates on the 911 calls. Doesn't provide any foundation for this. We're happy to file the CAD logs. There wasn't time to do that here, but again, no foundation.
We did file CAD logs and sent it to everybody involved, including the court. So we received the entire CAD report and filed it with the court, and also gave it to Ms. Baldwin. So those dates are incorrect. The CAD report should be with Your Honor, and I can check and see if it was actually scanned into Odyssey, but it was filed on, I believe it was filed on Friday.
April 12th, it's filed.
Okay.
So I'm sorry, Ms. Baldwin, anything else?
No, nothing, no further argument on that piece.
Okay. Ms. Winkles, anything further on that?
No, Your Honor.
Let's see, get back to where this was.
Oh, I have further evidentiary objections though, when you're ready.
So the issue as far as the respondent has changed the dates on the 911 calls. Let's just address that line. Ms. Baldwin, can you address that particular one?
Yeah, my client didn't. So we're just saying that there wasn't foundation. At the time she wrote this statement, there wasn't the access to the CAD logs. She doesn't indicate that she's looked at I will have CAD reports at the hearing. So she's not saying I've looked at them and I've verified that I have them in hand. She's just saying I disagree. But again, no foundation to actually say that she has the ability to verify when she's writing this declaration.
And if I can answer, Your Honor, she's the one who called 911 or called the police. It wasn't 911 in that case, but she's the one who called, so she should know which date she called on. So that's her personal knowledge of what she saw, did, said, and on the date she did it.
So with the log.
Well, I'll go ahead and allow it in the sense of I have a CAD report, so that by itself speaks for itself.
Yeah.
Next one is page 5 at paragraph. Let's see.
I think the argument is that she's claiming that that he changed the dates.
You can't.
Oh yeah, you really can't. But
a computer doesn't lie, folks. For the record, a computer doesn't lie. It's received on this date, this time, this second. There's no way to change that.
My whole thing is I don't think that
No way.
with the integrity of Ms. Baldwin, I just don't see her accepting something just from her client. We already know she's a subpoena, request records type of person. So she'll get the records firsthand before she gets it from her client. You know what I mean? So this other chick lying is just unnecessary, but whatever.
I believe as for paragraph 20, so paragraph 20, line 11, so claims that my client is paddling the child and continues to do so, again, not in his home, no foundation.
Swinkles?
Yes, Your Honor. My client supplied a text message where the father was actually talking about paddling the child, and then Ms. Baldwin also submitted the text message from my client about paddling the child. So I believe that they both use corporate punishment or have used corporate punishment in their house. My client's alleging that she spoke to the father. That's where the foundation comes from. Testimony. Mr. is a party to the case and can easily deny that. That would be the foundation.
So the text messages that my client provides are the mother discussing her paddling the child because the child essentially won't do what the boyfriend wants or won't apologize to her boyfriend. So those are the text messages that.
How about no one paddles the child?
I don't believe that the text messages that mother submits indicate that my client is currently paddling the child, which is the specific statement I'm discussing. And hey, Mr. has said, and there's no indications of that. These are people who have restraining orders. These are people that obviously are not communicating freely. So this idea that, oh, well, he told me, I think that A, it's not in the declaration, and B, it's very not likely.
Yeah.
So I'm going to strike that unless she's there in the home. There's nothing to confirm. And paddling can be interpreted differently, meaning paddling can be simply spanking a child on the bottom. And sometimes it can be while using a paddle. So it's a term of art, or not a term of art, but a term that can be read different ways.
And then same page, at paragraph 21, so really the vast majority of paragraph 21 is hearsay. Child tells me that they're saying all of these things. So this is just pure child hearsay, but my client would absolutely deny that these statements are being made. But again, mother's saying, oh, father's just saying these things. It's all just really rampant hearsay and child hearsay. That it's not appropriate.
Ms. Winkles.
And I don't have the exact paragraph in front of me. Is there a way, can Ms. Baldwin read it?
Paragraph 21.
I have the wrong thing up again. My apologies. Can you read that first line of that?
I am increasingly concerned.
Paragraph 20. Which line was that? I'm sorry.
Line 14, 15.
Clock's ticking.
The judge looks like she's half asleep.
And Your Honor can strike that. I think the pictures of the child and the injuries that were happening in Dad's house are enough. I can argue that without needing to argue anything the child said.
And that'll be stricken.
And then at paragraph 22, it starts with that same statement, child's wetting the bed in father's home. It's the same argument. She's not there.
And I believe Your Honor already ruled on that.
Yeah, I've already ruled.
So with that, I'm ready to proceed to argument when you're ready, Your Honor.
Okay, go ahead.
In this case, obviously there's a lot of information on both sides. But I think what's frankly should be most compelling is there's one truly neutral witness, and that's the child's teacher. And I often say that children's educational lives are a good barometer for how a child is doing. When children are doing, especially around children, when young children are doing well in school, it generally means that things are going well at home because they're able to sit down, they're able to focus, they're able to get through their school day and do well. As a barometer. And so in this case, child's teacher reports that child is thriving. Child is thriving on the consistency that he now has in father's household and that he's doing amazing. This is the teacher's report. And that changing his schedule now would likely throw him off and that she hopes that doesn't happen to him. And so that's the neutral observer that sees that child Monday through Friday, 8:30 to 3:30, every day. And so that is the person that I think sort of best tells the story about what this child needs and what's best for this child. And it's very telling what the mother's reaction to this brief report. This report does not slam mother. It doesn't say mother's horrible or some awful monster. But what is mother's reaction?
You put your child in charge of cybersecurity and now she's holding your company ransom?
Mother's reaction is not rational. She then goes and files a formal report trying to get the teacher in trouble for this email and is proud of it. She's proud she's got the teacher in trouble. And she says that in her declaration.
You tried to get the teacher in trouble.
I made this report, I sent these emails, and I said how dastardly this was that this teacher advocated for this young child. And that in and of itself tells you a lot. She has now tried to blockade and effectively, to some degree, has blockaded that witness from the future. It's likely that now, because you can see even the emails that they submitted, which are hearsay, but nonetheless, I let them in because I think that they're important for the court to see. It's now going to require us to subpoena that teacher and the school district to be able to get those records. We're probably going to have to depose the teacher instead of just talk to the teacher to be able to get that information because of how aggressive mother is to a simple email like this. And that is the inherent things that we're talking about.
I think a third party is not hearsay for certain professions.
I don't. It's not. It's what the thing that makes it hearsay is that you're saying that's like me saying to you, oh, Cindy told me that you Cindy told me that you stole a chocolate bar from the gas station.
Right.
Or actually, I'm sorry, let me add a little part in there. Let's say I'm in front of a judge, right?
Okay.
And it's me and it's you in front of this judge.
Okay.
And I say to the judge, well, Game shouldn't be allowed to play games anymore because Cindy told me he stole a candy bar from the gas station, and I think that's deplorable, and he shouldn't be able to be in games with other people.
Now, for the record, folks, I don't steal nothing.
Oh my God, it's an example. Hush. So, the point being that if the judge can't make a decision based on me saying what someone else told me. But what makes it different, right, is if I present to the judge that this person said what they said, and then I produce either like a deposition of that person giving testimony, or have that person present in the room as a witness, or have that person subpoenaed to testify to what they saw.
Right.
As opposed to me testifying to what they said, and they're not there. So, yes, in some regards, what this teacher has said or has put in an email is hearsay when the mother is addressing it. Because the teacher is not physically there to say, this is what I've witnessed and this is what I've gone through. Does that make sense?
The teacher submits it to...
The teacher did not submit it to the court. I'm assuming that this email was probably given to the gal, the guardian ad litem, as part of her investigation. And what is helping the guardian ad litem create her report. The mother did not like what the teacher said and has attempted to get this. I don't know if she succeeded, but attempted to get the teacher fired.
Okay.
Because she didn't like what she provided probably to the gal. That's my assumption.
But see,
because that's the only reason why the teacher would email.
My argument on this is, if it involves the child, I'm going to use, that argument for a second. Let's say it's, I don't see that as hearsay. If it involves the child, the person's teaching with the child.
It's not the email that's being put into question as hearsay. It's, I think, what the mother is saying. Like
what the mother is saying the teacher said?
No, I think, and I don't want to have to go back, but I think the hearsay is what the mother is putting in her declaration of what other people said.
Okay.
It's not, we're not going to allow what the teacher said because the teacher's hearsay. It's the mother saying something about what someone else said in her declaration.
Makes sense. Okay.
Now, if she would have put in her declaration an affidavit or like a sworn, by a notary public statement as an exhibit, that would be different.
Okay. Makes
but
sense.
remember, she doesn't like what the teacher said, so she's not going to do that. So a lot of the things, it's not about the context of what's being said at this point. It's that she's repeating what someone else supposedly told her, which the court can't prove because the person who told her is not there to testify.
Got it.
And there's no sworn statements.
Okay.
Like her claiming that someone at the school is friends with the ex-husband's girlfriend. Where's your proof?
Yeah.
Do you have a birth certificate? Do you have a family tree? Do you have that person there to say, yeah, that's my sister or that's my cousin? No.
Right.
So.
Interesting. All right.
She's gripping at straws. What I think is super funny, is I'm okay with the dad not being there because he's been there for all these cases, and he was, I think, there in the beginning. So I'm thinking maybe he turned off his camera, and the Zoom is set to not show people who are not on camera, because you can do that, I think, as a setting.
Yeah, it's a setting.
But I find it interesting that her attorney, his camera is also off.
Yeah.
Like, are you mad? Like, what's your problem? I'm sorry. Like, I'm not wishing it upon her, even though I already know this has already happened and everything's in the past. But part of me would not be surprised if this attorney's office drops her.
Yeah.
Because they're not. First of all, they're going against Miss Baldwin, right? And they're pissing off the judge with their nonsense. So, they might try to claim that it's unfair, whatever.
Yeah.
Anyway, let's get back to it.
This case is mother's behavior and how it impacts this child. When we look at the mental health records that are submitted in this case, my client argues that he was not allowed to provide input regarding the domestic violence relationship. That if that was specifically like, nope, we're not going to take that information from you. And nowhere in the report does it indicate that that information was taken from him and considered. This is a 5-year domestic violence relationship. That is significant to your mental health. But even so,
they divorced right after the baby was born.
Being set aside entirely, we still have findings that are very concerning. The findings here are that there is a dysfunction in role performance. The report itself says dysfunction in role performance. Yes. Risk of deterioration. Yes. So this, in and of itself, we have this mental health report that does not say she is okay, and in fact says she is not okay and needs treatment. And then you turn and look at the treatment records. the treatment records that they submit, sort of saying, hey, look, everything's fine. Delve a little closer. If you look closer into those records, record after record after record says no progress. That she, in fact, isn't making progress. She isn't resolving the dysfunction. She isn't improving on the risk of deterioration. And I would argue she's getting worse. And that you see that in the balance of the rest of the case. And it's notable that we essentially say, hey, she's not going, she stopped. And I think she had. So when you look at her last appointment in this string is March 4th. We then filed April 4th. It had been an entire month with no appointments that she had had, no mental health appointments, which doesn't make a lot of sense if you're continuing treatment. After we file, she then runs out and gets an appointment and says, oh, I'm still going. Look, I'm still going. But it's only days after she receives our declaration. So she's trying to repair that, but that only comes as a result of the litigation, not as a result of her genuine desire to work on her mental health issues and acknowledge that she has them. Again, so we see more than a month of gap in her treatment records. That is a concern. And when we see no progress, that is a concern. When we see dysfunction,
if there's no progress, then something's wrong.
Laid on top of the other evidence presents a substantial risk to this child. When I talk about dysfunction, we see 20 911 calls. We dispute the dates. They don't dispute the calls happening. They don't dispute that it's call after call after call for things that are not emergencies, frankly. Things that are, and the claim is they're baiting me into violating. It doesn't even make sense. My client doesn't call mine.
Huh?
Go back a little bit. Just
How back?
Maybe
Like
30 seconds.
Oh wait. Okay, so we're I'm assuming this is it.
And that you see that in the balance of the rest of the case. And it's notable that we essentially say, hey, she's not going, she stopped. And I think she had. So when you look at her last appointment in this string is
that what you wanted to hear?
Well, yeah, because that proves that there's no progress. She stopped going.
Yeah, but here's the thing. So when you're seeing a patient, right?
I'm gonna practice with this. How many patients of yours don't show up?
Huh?
Your patients don't show up all the time, right? Right.
Yes, they don't, right? But if a patient is missed, because this is a key point, did she have an appointment in April and then not make one until, or had an appointment in March and then not have any appointments and then make one in April? When normally, like when you're actively seeing a therapist, you see them either weekly or bi-weekly, right?
You're supposed to.
So the question is, did she miss appointments? Are there appointments she did not show up to at all? Or did she not have any appointments scheduled? Now, a therapist that's actively seeing her, if she's missed appointments, they're going to contact you if they're, up to date on all their stuff and be like, hey, we haven't seen you. Please, make an appointment.
Right.
But if that's not the circumstance, then it does look kind of fishy that she made an appointment after they filed that paperwork. Just simply for, it just looks sketchy. Hello. And there was another part to this too that's weird. Usually if you're not making progress, I think that usually that means that either the whatever therapeutic technique is being used. Okay, I realize you can hear me, but you may not be paying attention. Sorry. Da, 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 da. We should play some Jeopardy music for him. I realized I was talking, but you probably weren't listening or paying attention.
I got most of it.
So when you have
I
a patient that
apologize,
has no shit happens. When you have a patient that has no progress, that could mean that maybe the therapeutic techniques are not working. Or like when no progress means there's no change. And that's concerning because so especially depending on how your how stuff is being paid for. Like, okay, so if I were to fill out a progress note and, you know, when I do the mental status exam, identify that everything is good, that there's no problem. An insurance company, CPS, the VA, whomever, is going to look at that and see, okay, this person is not displaying any symptoms or any problems, so they no longer need therapy. That's like, I think, one instance of, like, you know, no progress or the person is better, right? I don't know. I think I would be concerned if a person is not making progress, because that means it may not sound negative to a layperson, but it is for me, it sounds sort of negative, because that just means that whatever problems that she's presenting to her therapist, nothing is changing.
True.
Which also means, especially too, if she's getting like cognitive behavioral therapy, which involves having techniques and taking action in changing behaviors and changing things that are around you, if she's highly stressed,
right,
which means it's probably some levels of anxiety in there,
okay,
or worrisomeness, she's not changing the dynamics that's around her that's causing that stress. And it actually seems like she's putting undue stress onto other people.
Okay, yeah.
Because her ex-husband doesn't need all this, like, this, what?
Unnecessary
fake
stress.
information.
Yeah.
So.
Okay.
That's
Sorry, guys,
that to me is a little concerning.
Sorry, guys. A little education for me. My apologies.
Well, I'm gonna look up real quick, since we can, you know, use Google.
Education
when
moment.
A client has no progress with therapist, what does that mean? Let's see what it says. Gotta love AI.
Yeah, what
the
does
phrase.
Google say?
Oops. You know, my fingers are not fingering. When a client has no, I put progress, it said no legs. Oh my god, and I use my finger. Okay. A lack of progress in therapy can mean the current approaches. You know what I kind of like when I say things? Because it kind of like, it makes me feel like, damn, you know what? I became a doctor and I know what I'm doing. It's my own little self-validation. I'm sorry. Okay.
You
It
do
says
know
a
how
lack
to
of.
say something correctly.
Huh?
You do know how to present what you need to present correctly.
Oh no, no, my thing is, like, if I'm presenting the correct information. Like, it's kind of funny. This happens with my mentor too all the time. Like, I'll like see like one of her clients or something, or just, you know, through some type of supervision, whatever, and I'll say something, and it's super validating when my mentor literally says the same exact thing. So it's like it's telling me that I've interpreted the situation correctly,
Right.
and that what I've learned and my experience is helping me to come to the same conclusion as this person who's been in the business for over 40 years.
Right.
Like, that makes her a great mentor, but, you know, for me, like, especially because, you know, like I said, like, I think most people kind of like look at me and they don't look at me as a person with authority, and most people don't value what I say. So when I get these little moments of validation, they kind of mean a little bit more than they might for someone else, but whatever. So anyway, it says a lack of
Moment of
progress in therapy
clarity.
can a lack of progress in therapy can mean the current approach isn't working. It's time to adjust treatment goals, or the client may be experiencing ambivalence about change or resistance to deeper issues. It could also stem from a poor therapist client fit, mismatched expectations, or a need to be more open with the therapist about feelings. It's crucial for the client to communicate this feeling to the therapist to collaboratively address the issue, which could involve changing strategies, reevaluating goals, or considering a different therapist. So yeah, I basically said that the treatment is not working. Um, I don't think there's a mismatch of goals. I think that goals were probably set in her treatment plan, and she's probably not hitting any of those goals for whatever reason. Whatever her excuses are, she's just not doing what she's supposed to do.
Right.
That's what that is. I don't think if she's not making progress, she's probably not like doing anything she's supposed to. Um The resistance or ambivalence, that's when a client subconsciously maybe subconsciously resisting deeper work or has conflicting feelings about making changes. That is you kind of find that a lot in some CPS cases where they're told what they need to do. And you would think that it's rather simplistic. You know, go see a therapist, go to a parenting class, go to a substance abuse counselor, you know, find a job, find a place to live.
But I mean,
like,
yeah,
these
it seems
they're
simple for someone to say, "Oh, go find a job," or "Go find
no,
a
no, no,
place
no,
to
no, no.
live."
Wait. You're misunderstanding. I'm saying it in not in go find a job like you need to just start working. It's these are things that CPS outlines for you to do to get your child. Wait, let me finish. To get your child back in your household. Now, granted, we're in a time right now where finding work is difficult, but a person trying to find work would fulfill the court's requirements. So I'm not saying that they have to find a job. I'm just saying that that is sometimes like you have to show that you're doing something.
Right.
And these requests are relatively simplistic requests in a sense. It's not hard to find a therapist. It is especially one in network with CPS. It is not they can give you that information. It is not hard to find a parenting class. It's not hard to find a substance abuse count. These are not things that are hard to do. CPS will help you with those things. But what I've found in some of the CPS people that I've worked with is they don't do it right away. They wait to the last minute. You know, they try to, in a sense, do the bare minimum.
Right.
And then when they don't complete stuff, then it's like, oh, I lost my parenting rights.
Yeah.
Well, maybe if you would have started when they told you a year ago, that wouldn't have happened.
Right.
Like, that's what I mean. I'm not saying they're being asked to do things that are like impossible.
Yeah, so the court does take into consideration that you're at least
if you're trying something
to do these things.
Yeah, and so does CPS when court is not a factor. Like if you don't have a court situation, if you don't have a custody situation, and CPS is involved, your caseworker, same thing. They ask you to do specific things as part of a part of a plan. They work with you. If you are actively showing that you are trying to do things, you don't necessarily, like, I mean, I guess every state is different. People are different. There probably are people that get punished for trying to do whatever. But I'm just saying, like, that's where you see where somebody is like resisting something that they don't need to resist. And she is, maybe, I don't know if if this mother is acknowledging that she has mental health issues. To me, showing up to someone's house while they're sleeping and standing over them is not something that somebody would make up. Like, that's just like so far-fetched that you can't see that being a lie. But somebody doing that is weird. The erratic behavior, we don't know if she has erratic behavior, but just from the other videos and stuff we watch, a person having erratic behavior is sometimes an indication of what alcohol is, like alcohol or drug or mental, right? So it's reasonable to expect that if you're doing something that's not normal, that somebody would want you to get checked out. And I mean, if her therapist is a poor fit, her therapist should have. Let me put it this way: if a therapist is seeing a patient and maybe they don't have rapport, or in this case, they're not making any progress, a therapist can refer the patient to another therapist. And even in doing that, you have to terminate a certain way. Because if you don't terminate with the patient properly and something happens to them, the therapist could be liable. So I agree with this attorney. If she's not making progress, that's concerning, because that means nothing's being fixed.
Right.
And then something needs to change.
Sorry, folks, we had a lot to cover there for a second.
Well, I mean, I gather that this is not necessarily things that people would know.
Right.
Unless they've been through it. Like, it's not, common knowledge. But now we have a clear understanding of what no progress means. And you didn't have to just take my word for it. AI helped.
Once in a while.
I'm gonna bite you. Okay, here we go.
March 4th. We then filed April 4th. It had been an entire month with no appointments that she had, no mental health appointments, which doesn't make a lot of sense if you're continuing treatment. After we filed, she then runs out and gets an appointment and says, oh, I'm still going. Look, I'm still going. But it's only days after she receives our declaration. So she's trying to repair that, but that only comes as a result of the litigation, not as a result of her genuine desire to work on her mental health issues and acknowledge that she has them. Again, so we see more than a month of gap in her treatment records. That is a concern. And when we see no progress, that is a concern. When we see dysfunction, that is a concern. And these concerns, laid on top of the other evidence, presents a substantial risk to this child. When I talk about dysfunction, we see 20 911 calls. We dispute the dates. They don't dispute the calls happen. They don't dispute that it's call after call after call for things that are not emergencies, frankly. Things that are, and the claim is they're baiting me into violating. It doesn't even make sense. My client doesn't call 911. They're never trying to get her in trouble for violating. They're never in this position where they're claiming that, some kind of exchange, every time that she's kind of making these claims to 911, they're not panned out anywhere in this case file. Again,
So mom keeps calling 911 to try and get dad's girlfriend in trouble for breaking the restraining order. Yikes.
Leans toward the dysfunction and the deterioration. That this is somebody who is not getting better, not making progress. Similarly, her declaration goes on to talk about, this harassment, these lies, but doesn't give any examples of how my client is harassing her, other than just going to court and saying, hey, here's what's happening and here's what's not happening. And when he talks about, oh, he lied, I'm like, my client has documentation from the physician's office about their policies. He has a letter, a formal letter that Kaiser issued saying, hey, this is what we told you. And she can't see that for what it is. It's lies. Folks like that, again, we talk about that being dysfunction. It's important to note that that dysfunction in and of itself leads to behavior. And really the behavior is the problem. And it's the behavior that led to the protection orders that are in this case. The allegations of those protection orders have been consistent. They haven't varied for more than a year. The stories have never really changed regarding those. And I would argue that her behaviors have not changed either. And notably, when you look at that mental health treatment progress, it is also unchanged. She has not made progress. Her behavior has not changed. And that's noted in her own mental health records. As a result of that, the protection orders had to be expanded and also extended. Again, because she's not making progress. She's not in a position where she's acknowledging her own issues. This is, I'll check the box and go to mental health, but I'm not actually acknowledging I have issues. There's really zero insight into her own behavior and zero acknowledgement. The domestic violence here is critical. When you look at the guardian ad litem report, she talks about the domestic violence for only a few lines, and that is troubling. And here's why. This is very much at issue in this case. This was a 5-year relationship with this person. And sometimes when you get a little bit deeper into a case and some of the declarations have gotten buried by other declarations, what Mrs. is trying to do is act like all the declarations in the file just haven't happened and we're just going to ignore that and just say, oh, well, it just never happened, so I'm just going to sweep it under the rug. But there is significant evidence of domestic violence. We have 911 calls about the boyfriend. We have her own text messages. We have the text messages between her and boyfriend. And that's part of the court file. The text messages between Lacey and her boyfriend, and I'll read it. It says, "You've gotten in my face multiple times before. You scare the F out of me and I don't trust you. I've told you that multiple times." That's not a text message of a relationship that doesn't involve domestic violence. These are people who are getting in each other's faces, yelling, screaming. Similarly, there seems to be just a flat denial, or I'm just going to put on blinders and ignore the declaration of Caitlin Slagle. This was filed December 5th, 2023. And I'll read a paragraph because I think it's really critical. This is the boyfriend's sister. She says, "I've known all these parties for years and years. I has relationships with all of them," and states how she's worried that even writing this is going to hurt some of those relationships. So she sort of acknowledges that telling the truth sometimes is realistically injures some of your relationships with folks. But she says, "Lacey and Michael's relationship is nothing but chaos. Seeing the fights break out between them, the obsession, the insecurities, and the threats was and is eye-opening. I have personally witnessed this. Within the last year, I have heard Michael tell Lacey to go kill herself while he was in a drunken rage. Then he drove off and was out of communication for days. Lacey is stuck with him despite all the threats made to her, about her, and even Brody. Michael has threatened to leave her and take all her things. He has threatened to leave her and Brody homeless. He threatens to kill her dog, Rudy. This is not safe behavior. These are threats which are indicative of domestic violence and should be taken seriously, not just shrugged off by Lacey."
This statement is from the boyfriend's own sister. That says a lot to me.
And it goes on. And it talks about additional incidents that have happened between these two people.
I agree.
And so when you have all of this evidence of this long-term domestic violence relationship, it creates a significant concern. And you put that together with photos of marks and burns that happened during the mother's time on the child, they're without valid explanation. Mother says, oh, it was a jump rope. I'm like, that doesn't make any sense. And we often talk about, does that injury make sense? Is that a child, is their shins? Or how does a jump rope cause a burn to your neck and bruising to your back? That doesn't make sense. She admits to paddling the child in a text message. She submits photos of injuries that my client's like, those are actually my photos that I submitted earlier in the case, and she's just recycling them now and claiming that they're hers. And then similarly, she submits photos where my client's like, you can look at the date and timestamp. Those are occurring during her time. It's not occurring right after the exchange. She's like, this is the end of her time. This is not the beginning of her time where she's kind of getting the kid saying, hey, what happened? This is right before we're going to switch back. And she's sending these texts. She's sending these, or those photos are what happened then. It's important to remember that domestic violence is a cycle, and without treatment, that cycle repeats. We all know that. And in this case, Mrs. is in full denial. Her declaration, the last one submitted, says there was no domestic violence whatsoever. She denies it entirely, despite lots of evidence to the contrary. And again, essentially, we have this statement of, well, he's gone, so just ignore it, just wipe it away. But domestic violence puts children at significant and exponential risk. I think it's notable. Domestic violence is a 191 factor that we have to consider. What other 191 factor would we treat this way? If someone was using methamphetamine and they said, trust me, I stopped using and I won't use it again, would that be the end of the story?
No.
Or would we say you need evaluation, you need treatment, you need help? If someone said, I'm schizophrenic, but hey, I'm promised that I'm cured, would the court say, no need for medication, no need for treatment? If my client was the one accused of being the domestic violence abuser, the court would, or absolutely, there would be an evaluation, there would be treatment, there would be limited time. But why here, where mother simply says, well, he's gone, don't worry about it, ignore that it happened, move on. Act like this is just something to kind of wipe under, sweep under the rug. And that's where, there's no follow-up, there's no concern. And that's where we do have to talk about inherent bias, where it's important to note that we have one party is male and one is female, and we have traditional gender roles. And so that absolutely can play a part in, well, if Mr. was accused of domestic violence, there would be all of these things that we would be very significant about. But if Mrs. is the one that is exposing child to domestic violence, well, she says it's done. So we're just going to ignore that. Again, 5 years is a long time to live in a domestic violence abusive relationship. It's a long time for that child.
He's got a real point about the difference in how this would be handled if it was dad being accused of DV. Yeah, honestly, if it was the other way around, they'd probably be trying to slap on supervised visits. His time would be reduced. There'd be all kinds of things.
Yeah,
if it was the other way around.
I agree.
And honestly, a male child definitely shouldn't be subject to watching their mother be beaten up or harmed, because those become learned behaviors. Yeah. That it's okay to put your hand on a woman.
Yeah.
So, yeah, it's a little scary.
That is a lot of abuse that child's witnessed, and to have that child be on that cycle and just ignore it is not appropriate. That is something we absolutely have to consider. It's notable when we think about the father's household, there are no concerns, really none whatsoever. And for the teacher, child's doing amazing. Child's doing
I'm concerned about this gal.
Consistency. Child slowly returning to a healthy weight and a healthy BMI. My clients noted that progress. My client is making sure he's meeting all of the appropriate appointments, all the appropriate milestones. There's literally no concerns when it comes to his household. When we look at Mrs., again, we have the verified dysfunction and risk of deterioration. we have protection orders, we have many calls to 911, we have protection orders, we have the domestic violence for denials, we have the photos indicating physical issues with the child as far as unexplained injuries, her admitting to paddling the child, locking the child in his room. There are very significant concerns that need to be fully investigated. We're here on just an interim report. We need a full investigation, and for that investigation to consider all the evidence, not simply child self-report, not each party's self-report, but to meet with each of the witnesses and to meet with all of the collateral witnesses in this matter. So what should the court do? In this case, my proposal is the court maintain the current parenting plan. The court should send us and get us, the court should send us to the Wednesday docket for a trial date. Trial dates are always a little ways out. We should get one on the books now. Likely this is a case that needs to go to trial. There's obviously a lot of information on both sides that needs to be presented. The parties do agree that the child needs counseling, and my client is absolutely in agreement with that. The parties should select an agreed counselor. If they cannot, that's not associated with either party or either party's, I should say, medical office or counselor. I always think that that's appropriate. And if the parties cannot agree, then the court can select. And we should do that within the next 2 weeks. I think there shouldn't be a delay or any further delay on that. I think that's a reasonable outcome for where we are. And again, some very significant concerns that deserve to be fully investigated in this case.
Thank you. Ms. Winkles?
Yes, Your Honor. There's an overall theme in this case, and that's one of a problem with credibility. Now, my client, when she went to the DVPO hearings and those hearings, she didn't really present a lot of evidence. What she was hoping is to maintain the relationship and essentially wait it out. But we really need to look at that because I think credibility here is the most important thing. If you'll notice from the text messages that my client submits, her and Brooke Adams, and I'm going to call Brooke Adams the stepmother, but the parties aren't married. They're not married. Brooke Adams stated a number of things, and so did.
Struggling to find finance and accounting talent? Join the growing number of companies embracing outsourced finance and accounting.
Ew.
Need a moment just for you? At Ollie, we get it. That's why we made these new vitamin.
Dad, that my client essentially went out of her way to stalk them and do all of these things, and they submitted some dates. My client, what she submitted is showing that these parties were very good friends. And my client, Dad says, she told me that the new child that they had should have been hers and mine together. But what you'll notice is that my client was informed immediately after the child was born, and my client sent mom flowers. Dad says those flowers were to me. So mom submits the receipt to the court showing that mom ordered the flowers to be sent directly to the hospital room of Brooke Adams, to Brooke Adams, congratulating her on having this beautiful baby. That time that she had the child in the DVPO, and in this case, Dad says that at that time she was stalking and she was coming to the house unwarranted and unwanted. That was a week after my client sent these flowers. Then we look at the next thing. They say that again, she's stalking them and she doesn't want them, they don't want her around. Well, that goes contrary to the fact that Dad and Brooke Adams, their child, they let my client take their child alone. So obviously we have no concerns in 2023 of my client essentially doing anything to the child or doing anything to anybody, because they send their own child, or sorry, 2022, they send their own child to the parade with my client. And you see the text messages there. They say, where do we?
I'm sorry?
I said, I really don't like this attorney.
It's giving, like...
See, I like Mrs. Baldwin's fight because I'm just gonna use this as an example. Maybe because I liked her from the last case, and that might be rejecting me a little bit. But I feel that she just presents her arguments better. She presents them with factual information, you know. And I feel like as I listen to this lady, she's not following the information we already have. She's presenting more information which we don't need.
Honestly, I feel like if his ex-wife sent flowers to the hospital for his current, I could see that as somewhat being stalker-ish, only because it's you're inserting yourself when the relationship is not amicable. So it seems like you're antagonizing her after she's just given birth to a child. Like, that's how that comes off. And just even like, why would you do that? Like, it could be understandable if they had a very good, healthy co-parenting situation where, like, where the significant others get along, then that makes things like a big sort of happy family type of situation.
Right.
But that's clearly not what's going on because, of all the things that have sort of transpired after that.
Right.
So I don't know what argument this lady is trying to make. And then saying that the ex-wife was allowed to take one of their children with them. Honestly, that's probably more of, first of all, I think this is before the protection order, I'm assuming.
Yeah.
But that to me would look like good faith on the father of trying to have his son's half siblings involved in activities that he's doing with his mother.
Okay.
Like,
right.
I don't know why, huh?
I mean, I understand that, but I'm kind of like, the way it's being presented.
It's weaponization.
Yeah.
It's being presented as weaponization, that him probably doing something in good faith or thinking that he's doing the right, them thinking they're doing the right thing by letting that child be with them, and and his son is now being used against him when things have deteriorated and behaviors have escalated.
True.
We pick them up. Where should we drop them off? My client is alone with a child that's not hers. That shows this really intimate family relationship. You then see text from Brooke Adams herself saying, "I'm so glad that we're friends. I'm so glad that we can do this and co-parent." They then invite her kayaking. They invite her camping. They invite her to the house. What happens though is you'll see that my client got upset. She got upset because Brooke made a statement about being able to get this child to do something that my client couldn't. My client overreacted and ghosted Brooke. That is when this all started. That was November 8th of 2022. Now, you'll see from all their—
So that sounds like it's your client's fault.
Well before that, claiming that as of October 2021, that my client was stalking them and harassing them and doing all these terrible things. That's really not the case. They claim that my client essentially threatened to kill them in May of 2022, but yet they invited her to go kayaking in June of 2022. She says, "Congrats, Mama." At that time, according to their declaration, my client is stalking them at their house. We then see that they're claiming that they both were sleeping with firearms, but you'll then see the next text message saying, "We would love to have you, can you go camping?" and them saying no. Now, my client was with Michael Slagle this time. You'll notice the August 2023 text that was submitted from Dad to my client, essentially saying that there were no issues, that they didn't think so. In November of 2022, did Michael Slagle and my client have a bust up? Did he get in her face and yell? Maybe. That occasionally happens in relationships. It doesn't say if the child was there or not. All it says is, "You got in my face, you scared me, stop." That doesn't show any domestic violence. Now, what
did your client not tell you?
Any of these pleadings, any of this hearsay, based on a lack of foundation for my client's allegations of bedwetting and so forth.
It's all hearsay.
But what they attempt to do here is claim domestic violence when they're not in the house. They claim that there was a 911 call, and there was one 911 call concerning Michael Slagle, one, in a 5-year relationship, that said he broke a Christmas ornament. And he did. And she broke up with him. She left him and he was gone. That shows a clear indication that my client is not willing to put up with anything. She mentioned back in November of 2022, you got in my face, I didn't like it. Considering when he broke an ornament, she broke up with him and kicked him out of the house and kicked him off the lease. You'll see that from the landlord, not a party to this case. You'll see the lease, he's out. But what you see is that obviously she spoke to him and he stopped. Because we know he stopped because the next time he broke an ornament, she was done. He's moved out, he's gone. Yet they make this claim that he's still there. And who do they use to kind of reaffirm this? They use Mr. Slagle's sister, and my client claims neither Mr. Slagle nor my client have had anything to do with the sister for over 6 years. My client herself has never seen him in the last 2 years. This is the same sister that wrote a declaration claiming that she saw them somewhere, yet my client was at work and submits her work records showing that she couldn't have been there. There is a massive credibility issue here. First, we have Dad making all these claims. Now, my client submitted no proof in the DVPO, so a DVPO was granted, or an anti-harassment order was granted. But what she's done in this case is actually submit the proof. And you can clearly see that on every day they state my client is stalking them. A couple of days later, they ask her to come over. They ask her to hang out. They say how great of friends they are. There's pictures of her with their children alone. This is clearly the case of a stepmother who got mad at my client's reaction.
Grip, stability, precision. That's the essence of driving. Lawfin.
And decided to get rid of my client. Now, why did my client call, not 911, you can see that from the CAD reports. Why did my client call the police? She called the police because of this credibility issue. They had already made all these claims that were clearly not true. My client was incredibly frightened that she was going to get arrested or have something used against her when it wasn't the case. We can see this in some of those CAD reports saying, hey, I'm afraid that I'm going here and I'm afraid something's going to happen. What do I do? And that's all the CAD reports are, is I'm going here, I want to let you know. And the cops say, that's good, keep telling us. So she does that. Now, Brooke calls 911 twice. First, she claimed that my client took, or essentially was at a game harassing her. My client wasn't even there. We submitted her work records. Then Brooke called 911 when my client wanted to take the child to a monster truck show. We see these things. We see this baiting. We see this attempt to get rid of mother. We can also see this coercive power of Mr. We gave him, or they gave him, the medical decision making, and you can see his texts that state, well, I will decide. I will decide. And then they attempt to rely on this statement from Kaiser. Well, here's the deal. He told this court in ex parte, which again is not really what ex parte is for at all, it's for an emergency, told this court in ex parte that only one parent was allowed. That wasn't true. Absolutely not true. Ms. Turnbull does an investigation, finds out that's not true. Another credibility issue of Dad. So what does he do? He reports to Kaiser, but he gives no name. They tell the person's name of who spoke to my client, yet he's self-reporting. Of course, Kaiser is just going to believe this. Yet another credibility issue. So what do they attempt to do? They attempt to rely on the teacher. This is the very same teacher that wrote a statement for the DVPO claiming my client had no reason to be at the school at the time. Yet my client submits that email to this court in this hearing. She didn't do it in the last one, showing that the teacher specifically asked my client to attend. And this is the same teacher that Mr. now wants us to rely on. The same teacher that's mentor, the direct supervisor above her, is the aunt of Brooke Adams. And they're going to say, well, the names are the same. No, that is the aunt of Brooke Adams. The fact is that everything in this is blown up, a credibility issue. We look at the supposed injuries of the child. The child goes to daycare, rubs a rope on his neck like this, goes to my client's or goes to Dad's house. Dad takes a picture of it, and you'll see the text. Dad said, "What is this?" Mom says, "Rubbing a rope on his neck at daycare." Dad then sends a text later saying, "Oh, we're so sorry. It's all right. It must have been the hot water of the shower that made it appear so much worse." It wasn't bruising. It was clearly an irritation. Hot water exacerbates. Hot water vasodilates, causes blood to rush to certain areas. As soon as the kid dried off, as soon as the temperature went down, the kid was fine. I want to remind the court that this is the same dad's house where the kid has had black eyes, bruising all over his body, got into an accident and had to be air flighted because he wasn't wearing a helmet and dad wasn't watching him. These are the issues that are at dad's house. Dad is the one who has always used corporal punishment. Mom paddled, a little smack on the rear end one time. There have been no allegations prior to today about any domestic violence occurring at mom's house. What you're seeing is an attempt, a frantic attempt, to throw spaghetti at the wall because all of dad's things have been fabrications. And we know this because we have text messages on every single one that backs it up. Dad says A happened, we then look at the text message, dad lied. We have B happen, look at the text message, dad lied. And this is the thing, is my client never used these texts. Most likely they didn't believe they existed. And so when my client now brings them up, oh no, we have a problem. Dad's been lying for the last 2 years. What do we do? Let's say that she's in a 5-year domestic violence relationship. Where's the evidence of that? We have a sister who knows absolutely nothing to Mr. Slagle. And we have Mr. Slagle saying some really horrible things after they broke up, which is why my client broke up with him. You can clearly see that from the lease.
You know, horrible things after they broke up? I don't know if they rely and wait until after. Yeah, see?
They just...
I don't like her. I don't know. What's the bullshit? Sorry. One-sided, I know, but...
I guess the concern is the guardian ad litem not really addressing the domestic violence issue. That's weird.
Why would you not address that?
They're trying to say that she hasn't been with this man for 2 years. But here's my thing. If he's not in the household, if she's been broken up with him for however long she claims, then why was that not said when the judge put a limitation that the child was not to be alone with him? Why didn't you say then, wait, Your Honor, I'm not with him anymore? Why is it being brought up now?
That's what I want to know. And that's
that doesn't make sense to me.
I think she's full of shit. Sorry to be so strong, but I think she's full of absolute shit.
It just, something is not adding up, and it just seems kind of interesting, too, that we're like, what? This is hearing 7, and now we're just now flipping the script to make the father look like he's the bad parent, when there's a teacher who said that the kid is doing better. And honestly, even if the teacher's supervisor is the aunt of the current girlfriend, student records don't lie.
No.
And other people have interaction with that child.
Right.
I mean, maybe not as much as the teacher does.
And that's what I was trying to get to earlier.
But here's the other part of that. Why would a teacher risk her license? Why would she risk her job to lie in this matter? Why would any of these people risk their livelihood on this case? That just doesn't make sense.
No.
So I don't know about this gal. I don't know if she's really up to snuff. This attorney, we don't like what she's saying and doing, but she's doing her job. And she's doing her job with, the information her client is providing her, and with however she can interpret what she's seeing and it not be her blatantly lying to the court.
Right.
So, it just seems
my whole take
it just seems
on
weird.
her argument is it's invalid. I feel it's invalid. And the reason I say it's invalid is because, one, we would have heard that long ago. And two, Dad provided the both the hospital and the teacher report. Two credible sources, right, that are mandatory reporters of problems.
It is questionable, but I think it all comes down to what the judge is gonna say.
Yeah, it does. But I'm just pointing those facts out. Anyway.
I don't know. Things are getting a little questionable, but let's keep going. We still have like a whole freaking hour left.
Talk about whether or not my client has had mental health issues. So essentially, we're asking the court to wonder why a woman who's been an amazing mother to this child and has had 50-50 custody of this child throughout his life, his grades were absolutely perfect until essentially November 8th of 2022, which is when Dad's campaign against Mom began. So we're wondering why there is an issue with Dad. Or issue with child's grades. Well, child's grades are absolutely fine until November of 2022. Then we see a problem at school, and now apparently his grades are fine again. Let's think what happened there. That's when Dad's campaign against Mom started. Dad's disparagement against Mom started. The child's of course doing all right now because there's no reason to disparage Mom because Dad won. Dad doesn't have to, Mom has almost no visitation. There's no reason for this campaign at the moment. So the child is of course doing well. What child would do well is if Dad stopped lying to the court, stopped fabricating, and stopped attempting to get Mother in trouble for things that are easily proved and that Mom's not doing. The fact is Mom had an evaluation. And what they're claiming is we see no change in a month. A month? If mental health professionals were able to help somebody in 1 month, this world would be a much different place. But how can Mom get better when the fabrications are continuing? Mom has had over 50-50 custody for this child's entire life.
That was a prime example of her misinterpreting the information.
Yep.
So the attorney did not say that the mother was only seen a month. What she said was that her last appointment was in March. They filed their paperwork in April, and there was no visit to a therapist in that entire month.
Right.
Because they requested the information. So that's what she's saying. She didn't say that the mother only went to a therapist for a month. She said that she stopped going and only started back up to, after this, the court filing. Where is she getting that from? That's not what was said. That's nobody said anything. No, it's not common practice. Usually a patient, I think at minimum, has 6 visits, right? So that's already still over a month.
Yeah,
but
it's a month and a half.
The point is that nothing was said about her only seeing a therapist for a month.
Right.
It was that she did not see a therapist for a month. And it's something you're supposed to go to consistently.
Right.
So she's, like I said, example of her misinterpreting or changing the narrative to suit her argument. Which I think this judge is smart, so we'll see.
That's pulled away for things Mom knows are false. Mom knows Dad is lying. Mom knows Dad has made statements that are clearly not true, and she has proof of it. What mother wouldn't have a mental health problem from that? She's essentially had her visitation cut by more than 75% for something that isn't true. Dad has made it very clear.
But that was
he does
recent.
not want Mom in this child's life.
Wait a minute. But that's recent. They just made that order recently, and after that order, she did not go to a therapist for a month.
Right.
So that negates that argument right there.
Right.
That if she's having a mental issue, then why the fuck did you stop going to your therapist for a month?
Right.
Like, attorney, make that make sense, please. I'm sorry.
GAL is here today, and I think the GAL would concur with that. Dad wants nothing to do with mom being in this child's life. Mom is the opposite. Mom wants dad to be involved and has tried to facilitate that the entire time. So again, we're asking to rely on the teacher's declaration, a teacher that, contrary to district policy, wrote a declaration in 2 cases. The fact is the teacher did that because this is a very tight community in Castle Rock. It's very small. Her mentor is already the aunt of Brooke. The only reason she would put her teaching up for that is obviously for a good friend or a family member.
Or responding to the gal?
We've seen dad have no problems with mom. We've seen them get along really great. There's no stalking. There's no mental health. Now, dad, what does he do when he finds out, when he knows that everybody knows he's lying? He starts bashing the people. And we have to really think about who he's bashing here. Ignoring mom from this situation, who is he bashing here? Who's dad lashing out at? The guardian ad litem is number 1. First, he takes a Scrivener's error of an accidental date put in, and he says she didn't do a report. This is
bashing people. Where's your proof of that?
My thing is, we haven't heard anything until just now that he had a problem with the guardian ad litem.
Yeah.
So, I mean, you can see his attorney is completely disinterested in this argument.
Yeah, she doesn't care.
But she's going to have a rebuttal that's probably going to, like, knock this lady on her ass.
Turnbull we're talking about. This isn't some GAL that this court doesn't know. This is a GAL that's in a significant amount of cases that has clearly stated no issues in mom or dad's house.
No.
Then we look at the evaluator. Then they say, this is a social worker. She's not able to do this evaluation of my client. Well, actually, the law says she can. And she has more education than a simple therapist. She's a licensed clinical social worker who is able to do evaluations. The WAC actually says that in it. So then dad says, I didn't have any collateral time whatsoever. And what do we have from the therapist or from the evaluator? The dates and times of speaking to dad, what dad said. So obviously, once again, another lie of dad. And one wonders if dad has a mental health problem because he continually lies to this court over and over again about, she said she said she wanted the baby to be mine. The flowers were sent to me. She stalked us at her house. We see a picture of her waiting here. Yet the text messages are between them saying, hey, come on over. Do you want to do this? Do you want to make cookies? Do you want to do this? All of this stuff is lies, and yet dad keeps doing it. Then he says she can't come to the court. She can't come to the hospital. Well, she clearly can. I never spoke to that woman. He clearly did. Every single thing that is being said by dad, which is really shocking because they're very easily disproved, as you'll see from my client's evidence that is very pointed, is a lie. Then they say Michael Slagle's still there. Michael Slagle's moved out. There's a lease that shows that. There's an empty room in the picture that shows that.
What does an empty lady? What does an empty room have to do with anything? They slept in the same bed. Really? And just because he's not on the lease, what does that mean? That doesn't stop you from still having a relationship with someone and them still being at your house every day.
Right.
Just because they're not sleeping there doesn't mean anything.
Right.
Because it's not, especially too, if someone is abusive, they're not leaving willingly.
No.
I mean,
that's
unless you're moving and they don't know where you live.
Right.
Clearly, that's not the case either.
Your Honor stated in our last hearing that if there were no concerns on that GAL report, that you would be looking back at the 50-50 plan that these parties have had in place for over 6 years. The GAL has no concerns. Now, the school is a problem.
Yeah.
Let's absolutely, my client understands
wanna
the
hear
child is
from
in
the-
school for another month and a half.
GAL too.
You know, it's funny because looking from the outside in, Hollywood is a place of dreams, right? But what most people don't see is that it's
What my client's proposing is that we slowly expand the time until the child's out of school. And then starting in summer, we go back to the 50-50 plan it was. The fact is that there have been enough fabrications. My client's literally lost visitation over lies that text messages show that that's what they are. He continually lies to this court. There's no neglect, there's no harm in my client's house. And when they show you these bruises on the kid, I ask Your Honor to look at the date. Because these were taken on day one, a mom's visitation, which means they happened at dad's house, because you can clearly see the bruises losing color over time. We have a series of photos. Every injury that happened, and we're not saying dad's abusing this kid. This is a little boy who could fall off a bike, who could, jump off a ledge. Little boys do all kinds of things and get injured everywhere. They get injured at daycare. They get injured at, they're little stuntmen in a way. But what we are saying is dad's abusive conflict, his attempt to remove mom from the life of this child is appalling, especially when this started over mom overreacting to Miss Adams. And it could have been ended there, but instead.
When you say it started by mom overreacting, it really makes me wonder what she did. Well, they said it, that the girlfriend got excited that she was able to get the child to do something that apparently the mother was not able to do. And the mother got upset about that and ghosted the girlfriend.
Yeah.
And then from there on, there's the conflict.
Yeah.
Now, here's the problem. If the mother wouldn't have overreacted, then there wouldn't have been a conflict.
Right. And here we are today.
And that's where the problem started. He's not. She's focusing on how they had a decent relationship in 2020, but prior to what happened in 2022. But they're talking about stuff that has happened subsequent that, like after.
Right.
So, not subsequent, but after.
Yeah,
so
that's why I'm like, are you drunk?
I don't know. I think it's just weird that they're now mentioning that this man is not in her, she's no longer with this man. But it was never said, that was never said before. And if you've been broken up with someone for 2 years, that means you've been broken up with them since 2022. So why would domestic violence be an issue now? That just doesn't make sense. It doesn't make sense.
Dad and stepmom decided no more for Miss Klopp. She's out of the picture. We're going to get her out of the picture, and started a campaign essentially against her.
She has visitation.
And it's been successful until now. We probably could have ended this had she submitted all this stuff back when she first had it, but she didn't. She has submitted it to Your Honor now. We ask you to review the evidence in full, because this is a travesty. It's essentially a travesty of justice, considering these are all things that can be proven. We'd ask Your Honor to go to this expanded to 50-50 time. And I'd also ask Your Honor to not allow any rebuttal, because this is not Mr. Klopp's motion. This is a GAL.
It's a bit of a red flag to me that you don't want the judge to allow dad's attorney to rebut you at all. If your proof is as strong as you claim, then nothing she says will make a difference anyway.
You know better than that.
Miss Baldwin's already spoken. I've now spoken. I asked for you to speak to the GAL, but this is not nobody here is the moving party. And it would not make sense nor fairness to allow either of us a rebuttal. So I'd ask that you speak to the GAL. Thank you.
Do you want to hear from Ms. Turnbull?
Thank you.
So do I. I want to hear from someone who isn't framing things in the best light for their client, just the facts.
I have spoken with the counselor. I've reviewed the mental health report of Ms. Klopp. I've spoken with the regional director of Kaiser, who manages the sleep study. This was all in my report, and at no point did anybody have concerns with Ms. Klopp. The parties are aware there was a recent CPS report by one of the school counselor, and I spoke with a CPS social worker who was in Ms. Klopp's home last week. She also did not have any concerns regarding Ms. Klopp or her home. I have not, all of the third parties.
But someone did so enough to call CPS.
Not had any concerns. I did have concerns that Mr. Klopp did manipulate some of the information. The sleep study, sent me an email afterward that said he did have conflicting information. But when I spoke with the regional director, she did report to me that she contacted both Mr. Klopp and Ms. Klopp and informed them that essentially two adults could be in the sleep study, that they would have possibly a second room that they could use. They could have one person on the floor, they could take turns, that they would accommodate this, that two parents could be there, that essentially the one adult was that one adult had to be present. You could not just leave your child. That doesn't mean that two people couldn't be there. And I asked her if in the records it indicated anybody had had contact with either parent after her conversation, and she said that they had not. There was no record of any contact with the parents regarding this issue after she had called them. So that gives me cause for concern that that information, even if it had been conflicting before, her call was to clarify. And so that's where that piece of information is. I do have some concerns about.
You told mom only one person could go, but two could.
I do think that some education and counseling regarding domestic violence is appropriate. I do think she was the victim in that relationship, not the perpetrator. And so having a domestic violence evaluation would not be helpful necessarily in that sense because she was the victim. I think that would be a counseling recommendation. So I think that's where we need to go on that front. Let's see, I'm trying to think of any other questions that you may have. In terms of recommendations for moving forward with the parenting plan right now, I do think Brody is really significantly in the middle of his parents' conflict, and that is my biggest concern right now. When I spoke with him, he essentially said he tells his mom what mom wants to hear, he tells his dad what he wants to hear, and he doesn't really know what he wants. But I think that by giving those answers to each parent, that is just stoking the fire of the conflict between both parents, and they really need to stop asking him what he wants and asking about what's happening in the other home. And he needs to be in counseling, and I have expressed this to both attorneys that it's critical, and the CPS agent also is going to be recommending that. So he's sad. He's just a sad kid right now, and he misses his mom. So whether you decide to go back to the 50-50 or you want to keep more stability throughout the school year, I do think some more time with mom would be appropriate.
So one of my questions has to do with long-term plan for a final report. What are you looking at? What are you thinking you'll need?
I would say another 4 to 6 weeks.
Okay. All right. Thank you. So in regard to the idea of rebuttal, when new information is brought up, it's not a matter of whose motion, it's more a matter of one gets to hear all the argument of one and then be able to respond and add additional, but that doesn't give the other the ability to respond to the information that's brought up by the others. So with that, Ms. Baldwin, if you can address just any new information.
It really is fair to allow her to address these accusations now rather than later.
True.
So, a couple things. Again, it's concerning that we have records from the sleep study that say one parent to attend. We have a letter from Kaiser themselves that says, yeah, we told you it was one parent directly. This is their official in writing statement. It says, yep, we told Dad it was one parent. We probably told Mom something else. That's on us. But it's couched my client being malicious when he wasn't. And it's notable that this is a sleep study. Mother's request was, despite the difficulties between these two people, she wanted to come and sleep on the floor next to my client during the sleep study, which it would absolutely have disrupted the efficacy of that sleep study. Her interest was herself. She was most important in that situation. Not, hey, this is not a surgery, this is just a sleep study. The child is most important. This is just getting information like a blood test. They don't both need to be there for a blood draw. So again, even Kaiser says, this is on us. We told you different information. And all the documentation supports that my client in no way did this maliciously. And it's frankly logical that both parents were not there. As far as the domestic violence, the claim that domestic violence has not been on the plate from day one is contradicted by the records. And again, I quoted records from back in December. So that's absolutely been on the table since day one and very clear. We have never said that Mrs. was the perpetrator, but that instead she is stuck in a cycle of violence and that absent treatment and acknowledgement that she needs treatment. She's in a pure denial state right now. That absent that acknowledgement, that the cycle will repeat and that cycle puts the child in danger. Similarly, the statement that my client lied and said he's never had collateral input. No, his statement to the court specifically was, I was not allowed to give collateral input on the domestic violence issue. That was the issue he was not allowed to provide any input on. So he says, like, they would take information from me, but on this, they just said, nope, you're not allowed on that issue. So that's specifically what his declaration states. So not that he doesn't have any input, but very specifically. And again, that's one of the main issues in her mental health. The fact that she's receiving mental health treatment is good. That has not been on board just recently. She's had mental health treatment since January, and there still is in a position of no progress. As far as the claim that the protection order was not defended against, that's also not accurate. Ms. Klopp in this case filed her own protection order, which was denied. So she filed sort of a collateral defensive protection order, and that is how she responded. So to say she didn't respond into that file, she just created a different file that was heard at the same time. So again, that's sort of a bit, or is directly misleading. So in this case, what is in the best interest of this child? Stability is in the best interest of this child. The child getting into counseling, the investigation being fully fleshed out. And it is concerning that we have reports to CPS that are coming from not either party. These are coming from third parties who are then saying, hey, child's making some concerning statements and investigations are occurring as a result of that. So again, that leads to their concerns, but those concerns are underpinned with evidence. And so we have to do what's right for the child. Child is priority. And so again, I think that my suggestion is a good one. It would maintain the current plan and set us to the trial setting calendar to get a trial date. I think that this case is likely one that will proceed to trial.
Brief response, Your Honor. The CPS, we have no indication that CPS was called by mom. And in fact, I believe one of the CPS calls was against Dad's house. Second, the DVPO that my client issued was actually dropped. It wasn't denied. Finally, this child has stated to the GAL that he's sad, that he misses mom. There is no reason why it would not be in the child's best interest to increase visitation with mom. What dad is asking you to do is let's let this child continue to be depressed until we set for trial. There's no reason. There have been no concerns by mom, by anybody. Should mom go to counseling for being a victim of DVP, domestic violence, if she is? Absolutely. My client has no problem doing that. But there's no man in my client's house. There's no boyfriend. There's no immediate threat.
You can choose to raid the caravan.
It doesn't matter. That just means that if she doesn't work on herself
to the child,
and this is what they're not, this is what his attorney's addressing, but she's clearly not addressing. Even if he is not in the house, the next time she gets in a relationship with someone, she's not going to be able to work through dealing with that type of situation again.
Right. My opinion on this matter is Miss Baldwin is actually correct. There should be, kind of a general overview again, right? But at the same time, mom needs to do. Maybe they both need mental health things. I don't know, but I feel like if things are occurring, the evidence is there by mom, but it's not convincing.
I'm
not
intrigued.
Convincing.
I'm intrigued that she flipped the script about the CPS thing. Ms. Baldwin didn't bring up anything about CPS
She did
being
not.
involved. The guardian ad litem brought that up. And the guardian ad litem said the CPS was at the mother's house. So I don't know where she got that CPS is against the dad.
Okay.
That's just...
Because there's nobody in my client's life. There's just my client and the child. So my client would ask that we do what the child wants and needs. We help the child. We expand mom's visitation. And come the date school gets out, we go back to a 50-50 plan. Then we wait for the trial, which most likely will be at the very end of the year, given the trial schedule. And hopefully that summer with mom and summer with dad, if these parties can just stop talking to the child about anything, and we can put that in the order. Neither party speaks to the child in any negative way about the other parent. Either party asks the child about anything. Neither party does this. And the child's in counseling at that point in time. So the child can say if somebody is violating this easily and has this third party to talk to. But there's no reason why this child shouldn't see mom more. The only person that has a concern with mom is the person who is fabricated against evidence that clearly proves that, not just the Kaiser, but a whole host of things, including dates and times. So we'd ask for expanded visitation until June 14th.
Yes.
A child, for one, is not going to follow that. I know that off the top of my head.
Wait, follow what? Not talking about what's going on in the other house?
Yeah.
No, they're not telling. They're not saying for the child. They're saying for the parents to not talk about or ask, not to talk about the other parent and not to ask questions. Now, whatever the kid voluntarily says is a different story, but
that's not how I took that.
Yeah, they're saying for the parent to not talk about each other.
Okay.
To the child, and there is the assumption, I guess, is that if that's not happening, it'll give the child more clarity matched with them going to therapy, that if somebody is violating that, the child will let that therapist know, which is assumption.
Right.
But I feel like the mother has been showing the unhinged, manipulative behavior, and the dad hasn't until today, because we have not heard the dad doing anything until today, right?
I don't believe her, though. I don't believe the attorney.
I'm not saying whether it's of believing what the person is saying. I'm just saying that so far it's the mother who seemed to be unhinged and doing things that were like, manipulative and not normal. It's not until this hearing that we're hearing that the dad is doing something similar. Right. Is what I'm saying. So it doesn't matter what's truth or fact. It's just that we're just now hearing that about him, and it's 7 hearings in, when his presentation from the start till now has not shown us anything negative.
No.
And now all of a sudden things are negative. And that's just weird. Because it even makes you wonder, whatever like messages and stuff that she's providing, are you seeing it in her phone? Is she printing it out from her phone? Or did you subpoena her records from the cell phone company? Like, what did you do? Because right now we don't really know her credibility either. But we're also not seeing the physical documentation. We're only hearing them argue it.
Right.
So that's also taking a component out of it. Like, we can't validate what's being said because we're not seeing the paperwork.
Right.
And then come June 14th, we go back to a 50-50 plan where there's clear measures in place that allow neither party to talk to the child about the other house. Let's just pretend the other parent doesn't exist for the child. Enroll child in counseling immediately. And the GAL can then review and drop in as needed to both parties' home. That makes sense. What doesn't make sense is to punish mom for a relationship that no longer exists and to punish child. That's really what we're doing by leaving child away from mom. This is a depressed kid. That's not fair to him. And when school's out, we have no educational issues at that point. School's out. So we'd ask for the expanded visitation as far as Your Honor sees for the next month and a half, and then go to this, it's not even a month and a half now, and then go to a 50-50 plan, and then set the GAL report, let's say in July, come back, and we can go from there. Set a trial in the meantime, but let's be honest, the trial's not going to be until November or December. Thank you.
50 plan.
So first question I have is, when is school out?
Usually June 10th to 15th.
I think it's the 14th this year.
Okay. All right. So first, I'm going to talk to the parents. One of the things that makes me very angry and upset is when parents decide that they are going to involve their child or children in the middle of a custody matter. Those children or child, in this case, has a right to love both parents and not be torn apart because the parents are going at each other. I expect you to act as adults, let the child be a child, and do not involve this child in the middle of this legal action. You're not to talk about it. You are not to talk about what goes on at the other person's house. You are not to talk about and ask that child anything about anything related to this case. That child wants to love each of you. So stop putting the child in the middle. It scars them. It scars them for the rest of their lives. So stop. In regard to what's going to happen from here, the court has reviewed the interim report as well as the pleadings associated with it. The court understands it was an interim report, but what the court also sees is a lot of pointing fingers and blaming everybody else but taking responsibility, and that's for both parents. That always makes it difficult.
Right.
I agree. I'm seeing problems with both of them.
So credibility becomes a big part of this. And obviously when all I see is a picture of somebody sitting on Zoom, that can be very difficult. And that's where the court does rely on the guardian ad litem to make that investigation and give at least some sense of where that is. And the court has some issues with credibility on both sides. Again, it seems to be a who's going to win rather than what's best for our child. So the court is concerned with the many issues that have been raised on both sides. And the interim report simply is not going to get to the bottom of those issues because there are a number of them. So based on the files and record and figuring out what's in the best interest of this child at this time. And this is not a decision to be taken in the sense of a final decision, and this is a temporary order.
We met in high school. Our daughter is 10 weeks old, very fresh. We had this.
This is a process that needs to occur. And so at this time, in regard to what the court is going to do, is going to change the current schedule just slightly, because what the court does not want to do is upset this child any more than the court needs to. So what the court is going to do at this time, and I apologize, I think I was looking at the parenting plan when I did this, came up with this, but the mother is going to be having the child the first, third, and fifth Thursday from the time school is released, or 9 a.m. if no school, to Sunday at 5 p.m. That is commencing this Thursday.
She'll have 4 days and 3 nights a week.
And then the mother is also going to have the child, I believe she's having the child on Wednesdays, Ms. Winkles, is that correct?
Yes, that's correct, Your Honor.
Oh, no, that's not correct.
I'm sorry. Oh, what's correct?
There's no midweek.
Yeah, my apologies.
Okay, so there is no midweek. Okay. So the mother is going to have a midweek and just basically the same time from the time school is released until 8 p.m. And if no school, then at 9 a.m. That would be on Wednesdays. I thought about making it Thursday, so Thursday was consistent, but that creates other problems, I think, down the road. So I made it Wednesday. I don't know, counsel, Wednesday or Thursday, I'm good either way.
I think Wednesday is fine, but I would make the suggestion, because it avoids contact between the parties, instead of Thursday to Sunday, if you do Friday to Monday, mom picks up from school, she drops off at school, the parties don't have any contact.
Yeah, does that work for you, Winkles?
It does, and what I can also suggest Tuesday instead of the Wednesday. So the way the schools work is they all have a shorter day on Wednesday. That way the Tuesday, I just Wednesday after school is fine. I was just thinking about, I think I got it wrong. My apologies. I was looking at a different schedule. I think the Wednesday is fine. I think they have a shorter day on Wednesday, and then turning to 8 p.m. is fine. My apologies.
So be Wednesday for the midweek, and then that's fine Friday to Monday. That's fine. But if they don't have school on Monday, then it would go until 5 p.m. that day.
Okay.
So that changes that time just a bit. And if no school on that Friday, 9 a.m. If no school on Friday.
Very good.
All right. And then the mother shall not have the child around Mitchell Slagle. I think that's the name. And then the court adopts number 2 through 5. The recommendations of the guardian ad litem. And in regard to the counseling, I think it was Ms. Winkles, I can't remember who it was, that suggested that if the parties can't agree that it comes back to court, I'm not sure what, it doesn't really matter, but see the parties agree I don't know because Kaiser is the provider, if that somehow plays into who's available for that. Do you know, Ms. Winkles?
It does. Kaiser has their own in-house child counselor, Dr. Leah. I don't know if that's the child's doctor, but that's pretty much every child's doctor in this area. She would make a referral based on their recommendation, and we can actually send that directly to Kaiser, and they will refer the child to a child psychologist.
Okay. So essentially, I'll rely on that. That's who the child will go to, so it's covered by Kaiser. And then I understand that there's some counseling, the mental health counseling.
What?
I said, shit, that's nice. The guys who do their shit. Wow. I didn't know they did that.
Well, maybe it's something that's done in Washington State. I don't know.
Something happening that needs to continue to happen. But what the court also wants is for mom to go to the domestic violence class at the shelter. And file proof that that was done. Ms. Turnbull, were there any other evaluations or anything that you wanted?
Not at this time, no.
All right, so in regard to the summer time, the court is not ordering. I do want just the standard holiday schedule that needs to occur.
And that's already part of the plan.
Okay. Let's see. So I have counseling that. And then what I'm going to do is set this on for June 2nd, excuse me, June 4th. For a final guardian ad litem report. I'm hoping Ms. Turnbull can have it done prior to that time.
Yes.
And then look at the summertime and what the schedule is going to be like from there.
The court, so council referenced maybe setting out into July because we won't have the child's counselor's input likely within the next 3 weeks. I didn't think that was a bad recommendation, is to allow for the child's counselor to have input.
And Your Honor, I'd ask for it to be in June before school gets out, because then we're using half of the school, we're using half of the summer where a child can be integrated back into mom's house, if that's going to be what the court decides. Otherwise, we're looking at less than a month to integrate the child, which will be difficult.
It'll be June 4th. That's when the guardian ad litem's report is supposed to be done, and hopefully we'll have at least some information from the counselor by that time. If not, we can address it at that point, but I do want to have something going before summer.
And then the guardian ad litem's recommendations included you're adopting 2 through 5. That includes my client taking a parenting class. He's already done that, so I just asked that we strike that because my client's already completed that and filed proof of that report.
Okay, yeah, that can be stricken.
And
so
my client has taken a parenting class as well.
This investigator recommends Lacey Club does not introduce Brody to a new romantic interest for 9 months. Court's adopting that. I already talked number 3 about the counseling. Number 4, if that's been done, then that's fine. That can be stricken. And then 5, that the mother discuss signs of an abusive relationship and appropriate boundaries with her counselor, which is essentially already talked about as well.
Presentation in 2 weeks.
So in regard to presentation, I'll go ahead and add it to that May 7th.
Okay. All right. Thank you, Your Honor.
Okay. All right. Gonna call number 2 on the docket, 19-3-00361-08. Klopp v.
His
Klopp.
attorney is always on time.
She's always on time.
And Your Honor, I don't know if you saw my order that I put in. I don't know where it went. We filed it on the 17th, but it disappeared. I have very minimal issues with Ms. Baldwin's order. So it's up to you, Your Honor, if you want to have one that's just from that hearing, or if you want parenting plan to include it. I can argue either way. Both of them are minimal.
So in reviewing that, I would prefer to just work off the parenting plan. That seems to make more sense.
She's working from home.
I looked at both as far as that goes, but let me get that out here. Okay, I'm looking at the amended temporary parenting plan proposed by Ms. Baldwin. Tell me what your objections are.
Very minimal, and my apologies to Ms. Baldwin. This is my dropping of the ball, has nothing to do with Ms. Baldwin. She got these in quite early. Section 8B, it just says every first, third, and alternating fifth weekends. Your Honor stated every first, third, and fifth weekends. The word alternating needs to be struck, and that is on, and I did submit the transcripts for this. That would be on page
4.
I don't remember alternating.
Yes, Your Honor, page 4, and it's on in the transcripts on page 45 of the transcripts if you want to look.
Ms. Baldwin?
Alternating is most common, so whichever Your Honor intended.
I intended just fifth weekend. There are only 4, and I was just looking for some additional time is all. So I'll go ahead and delete alternating. Okay.
And then the only other issue that we had was on page 9 under 14H, the telephone access, beginning at the age of 10. I just wanted to make sure that this was still what you're.
Sorry, this is so choppy. This was recorded around the time my laptop began to die.
Okay, so
it's them, not us, or them, not the court. Yeah.
Honor intended. We didn't speak about it. It seems like they are calling the child at different times. I just wanted to make sure that was still intended, given the expanded visitation.
Ms. Baldwin?
Not argued, pled, or ordered. We shouldn't be changing things that we didn't argue, plead, or order at that hearing. So I would ask we just leave it alone. If the parties want to negotiate something separately, we can do that off docket.
And that's fine.
Okay. It will remain as currently set.
And that's actually my only issue. And again, my apologies to the court and to Ms. Baldwin for dropping the ball on this one.
All right. So with that, Ms. Winkles, are you okay to put approved via Zoom?
Absolutely, Your Honor.
And then I would just ask we also sign the order on hearing that just has the clerk's action in it for the review date.
And that's fine with me as well, Your Honor.
All right, I have signed off on those orders. Anything else?
No, Your Honor.
Thank you.
All right,
thank you.
That concludes that matter.
I like his dedication for showing up every hearing.
Continuances, agreed continuances.
I believe I believe that's Ms. Winkles and I.
Oh, that was her husband.
So I believe we have...
That was funny. That was her husband in the Zoom too.
Yeah. He popped
I
out.
think he just turned off his camera. Because like I said, this is their docket. So I think some of them sit in a Zoom and then they just appear when they need to appear. Because they run over time, I think. Usually I think they run over time, and that's why they have to sit there. Yeah. Because you never know when your case is going to be called.
Yep.
One on Klopp and Klopp, that's number 3 and 4 on your docket, 19-3-0036108. we were on to review the guardian ad litem report. The guardian ad litem wanted to have an opportunity to review some of the depositions that we were able to complete. We were only able to do those last week. Usually those take about a week or two to get the deposition transcripts in and then get them to the guardian ad litem with a rational amount of time for her to review those. So I was thinking probably a date in early July, and the guardian ad litem can pipe up and let me know if that makes sense to her.
And I have July 2nd, July 9th, July 16th.
I thought they wanted to do it in June.
The 2nd is fine
for reunification of the kids.
And I believe that's fine with my client as well.
Okay.
And my apologies for no camera. My internet keeps going out this morning.
Okay.
Oh, there's Ms. Turnbull.
Sorry, I'm just moving slow.
So I'm guessing the reasoning has gone out the window.
July 2nd would work for me. And
Are we dumping him?
July 9th or the 16th. Any of those is
Let's go ahead and go to July 2nd.
Okay. Very good.
That works. Thank you, Your Honor.
Thank you. Any other agree? Going to Klopp v. Klopp, number 3 on the docket, 19-3-00361-08. I have Ms. Baldwin, Ms. Turnbull. Do I have Lacey Klopp?
You have Mr. Roberts, who's new to the case.
And Your Honor, we sent an NOA in yesterday. It should be there any minute, but I'm appearing for Ms. Klopp and
You switched attorneys. Why? I wonder why. What happened? Please tell us what happened.
Oh, I know exactly what happened. But we're not going to talk about that.
Well, the mom was not at the last. The mom wasn't at the last hearing.
No.
So the only thing, oh, well, she spoke for her client. The last hearing was, this one was July 2nd, right? So the last one was June 23rd. Wait, June 23rd. I thought the whole purpose, June 4th. And now they're July 23rd. They were supposed to meet July 2nd. So no idea what happened there. But in May, they said June 4th because they wanted time for the child to see a therapist and for that to be incorporated into the gal's report. And they wanted all that done so that they could, rearrange the parenting plan to, slowly move into 50-50, basically, after the summer.
Right.
Like, I think after the summer, they'd go back to the 50-50 thing. Interestingly enough, they go to court and on June 4th, and that does not happen. We don't hear a damn thing. And I'm guessing it's because the gal didn't have what she needed, or the reporter, whatever, wasn't able to be done.
Nope.
And her attorney in that moment said that her client was okay with it being adjourned until July 2nd.
Yeah.
What happened on July 2nd and what's happening now? I'm
Maybe we'll find out.
Yeah, I'm thoroughly now invested in knowing what the fuck happened. And we only have a little bit over a half hour left, so this should be interesting. Okay. So, new attorney.
I'm up to speed enough to discuss this hearing today, so we can go forward.
So We're here for the review for the guardian ad litem report. There was a little bit of additional information that we were waiting for, but we're just able to get that in within the last bit. But it's quite a bit of volume, so we were synthesizing it to be able to provide the guardian ad litem. So I know that she was sort of waiting on that, given that the report's clearly not in the file. I think this should stay with Your Honor, and so I would ask that we just set to the next docket that Your Honor is available. And I think that's
August 20th.
That would be fine. And my client's not available through August 6th. So we would, the 13th or the 20th, and if the 20th is the first available, then that's fine.
Mr. I'm available the 20th. What I was hoping to do, and I believe I spoke with Ms. Turnbull, and I believe she has some update, but I'll defer to her. This has been an ongoing situation with delays due to additional information that Ms. Baldwin's tried to get to Ms. Klopp. My understanding is that Ms. Turnbull, her inclination thus far has been to expand my client's time. This was on June 4th. We are now at July 23rd, and we are about to be at the end of summer without my client having any expanded time. The very least I'd ask for, I don't have an objection to the continuance because I know Ms. Turnbull needs to finish her report, but pursuant to Ms. Turnbull's input, I would ask that my client has expanded visitation between now and that hearing, because the delays are solely because of father doing this last minute fishing expedition, for lack of a better term. It may determine the outcome, but I doubt it. And at the very least, if Ms. Turnbull is on board with expanding some time, giving my client more than she currently has between now and the next hearing, that'd be great. I also understand that some of the outstanding information that Ms. Baldwin is trying to get to Ms. Turnbull is pursuant to at least one subpoena that was objected to, that was never calendared for the court to determine whether the subpoena should go forward or not. So I know that's not on the docket today, but I did want to raise that because it sounds like there's probably an issue there, but I can't speak more to it at this point.
So in regard to this idea of expanding or changing one, I have no report, and I get it. Ms. Turnbull is still working on it too. I have no written motion. I understand, Mr. Roberts, you just joined. And at this point, I don't have any information that I've reviewed. And so where things are even at, I don't have a clue. And I don't want to make a decision based on a recommendation. It's a recommendation, no offense to Ms. Turnbull, but I have no information in front of me. So that's my concern at this point.
So we'd ask that we set to the 20th. I'm happy to talk with Mr. Roberts off docket about discovery issues.
And if we are going to have it set over to the 20th, could we at least get clarity on when all of this documentation is going to get to Ms. Turnbull, so we're not here on the 20th, kicking it out until September 15th? And again,
I think that Ms. Turnbull should be able to provide her report by the 20th. Either I have the information and I can provide it, or I don't. So at some point, I think it's reasonable that she prepares a report.
So Ms. Turnbull, where are you at with the timing on this?
I'm substantially completed with my report. I could finish it within a few hours. I'm just waiting on the information that Ms. Baldwin would like to provide.
We have some subpoenas that are supposed to come back this week. And so I'm anticipating, which they weren't due until this week, just the timing that we had to give. So, and those I think would be important depending on what's received.
And I guess my concern, Your Honor, is this is a case that was, the jail report could have been finalized the last week of May, and then subsequent to it being right on the edge of the deadline, further subpoenas and depositions have been taken to just drag this out. So what I'm asking for is some kind of hard date to have this information to Ms. Turnbull. Otherwise, there's going to be potentially new subpoenas, new depositions to drag this into October, November.
There's no reason why it would extend past it. Ms. Turnbull's largely complete and waiting on the data. I should have until the week before the 20th to provide it, because that would just be supplemental, and then weigh however she wants to weigh it.
Your Honor, it sounds like
In regard to that,
And it sounds, sorry, Your Honor.
Okay, enough. So in regard to that, looking at August 20th, I want all information to Ms. Turnbull by August 9th. Then Ms. Turnbull can finish up her report and get it sent out.
Very good.
Yeah.
Right. That's it for today.
I'll go ahead and set it over to the 20th.
Thank you, Your Honor.
Thank you, Your Honor.
This is,
I believe number 1 and 2, Clop and Clop on your docket will be an agreed continuance. This was on for a guardian ad litem review as well as a motion to compel. Guardian ad litem just provided her report yesterday, and essentially clients haven't even had a chance to review it yet. And so we're asking for a 2-week set over, give everybody a chance to review and respond. We were also on for a motion to compel. That response was also received late last week. So it makes sense to just set both matters over 2 weeks. I think that would take us to September 3rd.
So the exact thing that the attorney didn't want to happen happened anyway.
Yeah.
Because of the GAL.
Yeah, the GAL stalled.
all right. So I did see the what was emailed yesterday.
Actually, I'm kind of wondering, I just don't see the attorney providing the information past her deadline, potentially. But if the GAL said that her thing, she could finish it in a couple of hours, that might mean that whatever, if this lady got that information to her on time, that whatever was provided to her maybe was potentially substantial.
Possible.
That it took her longer to get the report in. Because if you only needed a couple hours, I mean, you could have finished up what you were doing and then you know, make adjustments. So I don't know.
My problem, and forgive me, but my problem with a lot of people is they don't get their work done on time ever. And even if you have a deadline, the deadline's always done wrong in any profession. Me personally, I'd rather get it done sooner than later. But that's me. But if you're relying on others, you'll probably get it done that day. Maybe. And
well, we don't know.
And companies do not send things on time. They don't.
Well, we don't know, and we don't know what they're going to say here. So hopefully, maybe we'll get something.
Adding as the guardian ad litem has been ill.
She was sick.
So understandably has not been able to get the interim report done. So if I'm not hearing any objections, so we'll set the matter over 2 weeks. What date does it?
That's the 3rd.
Okay. We'll go ahead and set number 1 and 2 over to September 3. Number 3 and 4 on the docket, 19-3-00361-08. Clop v. Clop.
That's ready.
All right, there are 2 matters on. First is the final GAL report, and the second is a motion to compel. We have Ms. Baldwin, we have Ms. Turnbull, and we have Ms. Klopp here in the courtroom.
And the court had indicated already that you're setting over the final GAL review 1 week.
Correct.
Wait a second. Did she say the wife is in the courtroom?
Report done.
Oops, I'm so sorry, y'all. I'm so sorry.
Going on there.
I keep going too far. I apologize. I'm
I
sorry.
indicated already that you're setting over the.
So that's still 2.
That's ready.
All right, there are 2 matters on. First is the final GAL report, and the second is a motion to compel. We have Miss Baldwin, we have Miss Turnbull, and we have Miss Klopp here in the courtroom.
Oh yeah, she went to the courtroom.
And the court had indicated already that you're setting over the final GAL review 1 week.
Correct.
Okay. So as to the motion to compel,
So let me clarify in regard to the GAL review. I did receive your motion to adopt, but again, the court doesn't find that it was timely for all the paperwork to get done and responses to be done. And so that's why I'm not considering it today and setting it over. Okay. All right. So that's what's going on there.
Where's her attorney?
Motion to compel. Go ahead, Ms. Baldwin.
Thank you. So on the motion to compel, we're specifically looking at, and this is to compel, and again, a request for fees and sanctions in this case, regarding a couple specific pieces of information that are really crucial to being able to show a number of underlying factors in this case. One of those first items is the Google account. Although the account is provided, what the account shows is that it was substantially edited prior to being provided. It showed that information was edited, information was deleted, there was a repeated takeouts, which is the sort of Google term for redacting information and removing it from the file. And then the file was downloaded essentially 19 different times in order to confirm that all of those takeouts were successful. As we know, sometimes you'll have computer data that's in one place and then another. And so there was sort of an assurance that the other party wanted to make sure that all of the information that they didn't want shown was removed from the file. So and you can see that as attached as Exhibit B to my client's declaration of July 23rd. She also changed the settings within her Google account to make this possible. So again, this is not a whoopsie. This is not a mistake.
Oh wow! I paused like just at a commercial. Wow. So, is it possible that?
This is a very intense.
Is it possible that her old attorney found out that she had manipulated stuff? Or did the new attorney find out she manipulated stuff? And now she has no representation?
Yeah, that's possible.
A little scary. Okay.
But I'm going to tell you that there are two types of transfers. Okay? Google keeps a track of anything you've done on your account. Period. It'll even show when it was deleted. And the reason it does that is for this exact thing.
So, translation, she done fucked up.
Don't do it. Okay?
Let's head back. Methodical.
And I'm going to say this, folks. Computers don't lie. They don't.
Well, unless you're a hacker and you know how to hack.
Everything is timed. Everything is, it's there.
Does that conclude your statement?
No. I mean, they don't. They don't lie. They don't manipulate. They don't change things. You have to change it all. So, yeah, I'm done now.
Person who is going through making those changes, changing those settings, and then...
Well, because I remember I can't hear the video.
I know that.
Over. I hope I didn't go back too far.
A repeated takeouts, which is the sort of Google term for redacting information and removing it from the file. And then the file was downloaded essentially 19 different times
in order to confirm that all of those takeouts were successful. As we know, sometimes you'll have computer data that's in one place and then another. And so there was sort of an assurance that the other party wanted to make sure that all of the information that they didn't want shown was removed from the file. So, and you can see that as attached as Exhibit B to my client's declaration of July 23rd. She also changed the settings within her Google account to make this possible. So again, this is not a whoopsie. This is not a mistake. This is a very intentional, methodical person who is going through making those changes, changing those settings, and then removing the information that would be harmful to their case before forwarding that information on, making material changes. Similarly, we had requested communication, essentially her social media communications. There's a significant dispute about whether some relationships continued. And what you see is essentially Mrs. continues her, you see her stop her communication with boyfriend on one day, and then her social media app usage with Messenger and WhatsApp then explodes thereafter. And she doesn't provide that information at all. And in this case, she says, oh, well, that's all work related, and so I don't have to provide it. And my client says, absolutely not. We have nothing from not even a single employer that says this is in any way employer related. It would be very odd for an employer to use an app like WhatsApp for communications. And then when you look at the communications themselves, that doesn't make any sense. Her communications, you can see her using this, you can see her using it to message on March 6th is really when this starts. That doesn't align with when she started with that employer. So, so again, that doesn't make sense if she's saying this is work related. Similarly, you can see that the messages themselves, again, we can't see the messages. That's part of what she's not providing. But you can see her messaging at 11:30 at night, 1:15 in the morning. Those aren't work times. That's not when she's working. So again, that doesn't line up with, oh, this is work related, so I don't have to provide it. So again, we have
4 reasons
Oh shit,
why Green Chef
that was
makes
weird.
eating clean easy for me. 1, my meals support my evolving.
Have somebody who's not providing these critical pieces of evidence, materially changing them. In the same vein, we have Snapchat, which is another social media app where she claims, oh, well, I deleted it, so I don't have access to it. But the app
Snap
itself,
has it.
again, my client shows that she was active on the app as of April 11th, and this request was served, and that's 14 days after our request was served. So if she deleted it after our request was served. So again, withholding evidence, destroying evidence, or deleting it. So we're in this situation where we have a number of critical pieces of evidence where my guess is that they would show things that Mrs. does not want seen, that they would prove things that she doesn't want proved. And so in this case, she's just saying, well, I'm just not going to provide it or claim it comes from other people, or claim, essentially that these are communications with other people, but I won't show that. So in this case, that causes substantial issues. So what we're asking the court to do is first order her to provide it. We believe that it's most likely that she does have a copy of the original Google account, that she removed it, looked through it to find all the things she wanted to delete, and then deleted them. So there is a chance that she has that original file that should be provided. Similarly, she should be required to provide the Snapchat as well as the other social media apps like WhatsApp. Those all need to be provided in full. There's just no excuse for not providing those, especially when we have no verification that they are from her employer or in any way associated with her employer. And at this point, she's had more than a month to procure that. So again, just not really an excuse there. Finally, we should set our dates to review compliance. If she has not complied and not provided those things, then at that point, it's not sufficient to simply issue a financial sanction, because then what that means is that parties can simply buy non-production. If something's going to harm you and all the court is going to do is fine you, great. For some parties, that would be an excellent choice. I would choose not to produce this If I know that the cost is $1,000 sanction, many people would say worth it. That's a great, that they're willing to pay that cost. So simply a cost alone is not enough, especially in a case like this. So the court should set a review date, and if it's not provided and not provided in full, then the court should then make findings that are associated with the request. And those are findings to the findings in the negative or contrary findings that the court will authorize the court to do. So depending on what she provides and the quantity of what she provides, I think then I would propose findings if she does not provide all of the data that we have requested.
Go ahead, Ms. Klopp.
For the Google account on March 27th, I had said that Ms. Winkles had asked me to pull a Google takeout to see if I was tracking my location. And I put that information in a declaration on March 28th. I didn't even get the discovery request from Ms. Winkles until April 1st. So I wouldn't have known prior when I took that takeout. And when I did do that takeout on March 27th, all I had deleted was an old iPhone that said it was still attached to my account. I had numerous other things that I had to get for them, my Instagram, my Facebook, which they have all records of that I had downloaded. On April 11th, I sent my Google takeout information to Erin, and I even provided the email that said that there was errors. When I was downloading it, I'd opened the file and the file was blank. So I don't know what was going on, but that's why it was essentially downloaded so many times. I never deleted anything or intentionally tried to withhold any information on my Google. I don't have any of those files. I had a computer that my ex had given me last year. And when we had that crash for the software on July 19th, my Adobe wouldn't work on that old computer anymore. So I had to finally use the Lenovo laptop, and Brody had always, my son wanted computer, so I deleted everything off that computer and made it a kid's account for him on it. So he has that laptop, but there's nothing on that. For WhatsApp, I didn't provide anything for WhatsApp because the number 9 I can't even say it, says to provide in which it's related to any way to this action, and there was no way it was related at all. It's all work related. I use it for travel. Also, when I have clients overseas, it's easy to contact them with a WhatsApp. And then for work, I have an employee that lives in Paris, and she comes for the summer and visits. And the only way for me to talk to her without racking up a ton of money on my phone bill is through WhatsApp. I had deleted it in 2023 at the end of the year because I thought she was done coming over and working. I reinstalled it this summer for clients for travel, and also she came back over and did summer work with me. So I was talking to her for that. And Paris is also 9 hours ahead. So when I do talk to her, it's usually late at night because it's morning time or afternoon for her. And I do use Teams for work. That's our main form of communication, but with the limitations in different countries, they can't always access Teams. So that's why I would talk to her on WhatsApp, but with Teams, we do hundreds of messages daily and calls.
I mean, it does seem reasonable what she's saying.
My job is based in California, so I work remotely.
The data.
My boss is in communication with the works attorney since we do have NDA.
No,
and it's
I'm saying her explanation for using that app and the times a day makes sense. But who's to say she isn't using it for something else? So I kind of get why they want the information too.
Yeah.
Privacy. I've talked to my employee about her pay and all sorts of stuff on WhatsApp. So she emailed me last night and said that she did try to follow up with the attorney last night, but with it being a holiday.
Okay, and I'm going to object to the hearsay, and this isn't in any declaration anywhere.
I would agree. You can't add that in.
Okay. And then I did, there was a protection order that was filed that went along with number 4 and number 5, request for production. In between going from Erin to the other attorneys, there was, I guess, a docket notice was never filed. And so I filed that this morning, and I haven't had time to serve them as the court opened right before this. but that is set for September 23rd. But that would kind of go with number 4 and number 5 request for production. I wouldn't be able to pay anything. I'm obviously having to do this by myself. I can't even afford an attorney, as I've spent so much on fighting past allegations and everything. So I don't really think anything should be awarded for that.
Anything else?
No. I've tried my best to do what I can with what I have and limited resources without an attorney. So I'm just trying as good as I can.
He was going with the old feel sorry for me because I spent so much money on lawyers and now I have to do it myself. Well, why did your attorney? Oh, so maybe she lost her attorneys because she can't afford them.
Yeah.
I
They'll
guess.
tell you no if you can't afford them.
No, wasn't she making $30 an hour? I'm $30 an hour working part-time. Well, maybe you should increase it to full-time, and then
maybe you should work more. Yeah.
and and then you can go from making $780 a week to $1,200 a week. I mean, if you don't want your job, give it to one of us, right?
Shit, I'll do it.
Ms. Baldwin?
Thank you. I want to be clear, just because you
I'm sorry, but I don't think this will end well for her. I wouldn't want to go up against Attorney Baldwin.
delete an app on your phone, it doesn't mean that the data is gone. The app is just a conduit to essentially the server of that company. So all you have to do is reinstall that conduit. The data is still there. So this idea that I deleted it off my phone, that does not mean that all the data is magically disappeared. It's still there. You reinstall the app, all the data is still there with your same passcode, in the same way that it works with your computer. If you delete your Outlook off of your individual computer, it doesn't mean that your email address is disappeared. You can get onto a different computer and access your email. So I just want to kind of provide some of that clarity. Again, she says, well, I'm not going to provide my Snapchat because I deleted it April 11th. But here she even acknowledges that even if her attorney didn't give it to her right away, that she had the request by April 1st. So well, hey, I deleted it, then you deleted it after, you are just fully acknowledging you deleted it after receiving our discovery request. She makes no response or no answer as to the files that are labeled Tombstone, as to the Google information and the Google calendaring information. So again, really doesn't have an excuse for why that happened and why these settings are changed, why the deletions are showing. So again, real concerns there. Nothing whatsoever to show that these communications are work related. She said, well, I've signed an NDA. She could have provided that very readily and easily.
Struggling to find finance and accounting talent? Join the growing number of companies embracing outsourced finance and accounting.
It's what we asked for.
Didn't. Not a scrap. And here we are, this was filed in July, and here we are in September. There's been plenty of time to provide a scrap of anything from her employer showing it's work related, and there's not a scrap. And so again, it's just her word of, hey, believe me, this is work related, when none of it really lines up. None of it really makes any sense that she would be doing this in this frame. And my clients provided gone through essentially the data and provided you with essentially, here's exhibit A, here's what she did, here's exhibit B, here's how she did it. This is the information we're seeking. And it is imperative that we obtain the information and have it, or that the court make those findings. Because again, parties benefit when they just withhold information and say, oh, well, that's going to be really negative for me, I'm just not going to provide it. So in these cases, it's critical that the court make orders that penalize parties appropriately when they don't provide.
So the court understands that you are representing yourself. At the same time, you have the same obligations under the rules as anybody else, including attorneys. And that I have the information that's in front of me that has been presented and provided. And that's what I have to look at and base things off of. So based on the files and record, the court does not believe the statements of you as the petitioner, and the court expects you to comply with the requested discovery. Based on the notes from the 26I conference, the needed information was discussed. Now, that information will be provided within 21 days of today's date. The court does grant the attorney's fees of $1,000 to the respondent for the necessity of having to bring this motion, and that's to be paid.
Okay, so she had until, so this was done, what, September 24? And let's see. She has until, they don't even give a till date. It just says attorney fee. They don't even say when she can, how much time she has to pay it. That's crazy.
Okay, $1,000.
That's a lot of money.
Within 60 days. I understand your financial state at the same time when it costs the other party.
That's irrelevant. Usually when we see, when this particular YouTuber puts that up there, there's usually like where it has like the interest, there's usually like a date, another date there of when the interest will take effect. And there was no date there. So maybe there is no like that doesn't make sense. Why would you put the interest but no date the interest will take effect? Does that make sense?
Okay.
Do you get what I'm saying?
No, but
when we usually see this credit debt page, at the bottom where it says attorney fee and it says the 12% interest rate, it usually has a date that interest will start.
Right.
There was no date there, is what I'm saying. There's no date identified for when the interest will start accruing.
Interesting.
I think I've noticed that there's been other ones where that wasn't there, and then there's been ones where I've looked and there was an interest start date. So I just think that's interesting that maybe they don't put interest on attorney's fees, and maybe that's just standard wording that's on that form. But
maybe.
But the judge just says she has 60 days to pay it. I don't know if that's going to happen though.
Money, that's where that comes from. If the requested information is not provided as ordered, then the court will consider additional fees as requested by the respondent, including the penalty for the failure to provide unaltered documents. In addition, if the documents are not provided, the court will consider the striking of the responsive pleadings or strike any testimony by you as a petitioner on the topics that are being talked about. So if I understand correctly, and correct me, Ms. Baldwin, if I'm wrong here, I have Google, Snapchat, and WhatsApp. Is that correct?
Yes, Google, Snapchat, WhatsApp are the main ones in this case.
Okay. Do I just do like the downloads for it? Is that the information that Ms. Baldwin's?
So what I would suggest is Ms. Baldwin and Ms. Klopp is have another conference, telephone conference, to talk about just what she needs, because I'm not involved in the discovery part of it, so I don't know what has or hasn't been provided. But have that conference again with Ms. Baldwin, and that way it's clear as to exactly what she's looking for.
Okay.
Okay.
Presentation.
Yes, sir.
Can't Ms. Baldwin just request that information from the company themselves?
I think it's because she might have done that she sees the background stuff. Like she sees that things were that things were downloaded multiple times. I'm thinking that she got that from the subpoena.
Server.
Yeah. But as far as like her, it sounds like she just needed to download stuff. Like download Snapchat and download WhatsApp or whatever. Maybe if a person doesn't have it downloaded, I don't know how that works. But here's the thing, for legal reasons, right? I'll explain. So when we're in a personal injury setting, so that is separate, but it's similar concept. So when we provide medical records for our clients, the medical records are what we requested from the client's doctors. We get that information and we provide it in our discovery to the opposing attorney. But also in the process of doing that, we also provide the opposing attorney a HIPAA authorization that's addressed to the attorney and directs the doctor or facility, clinic, whatever, permission to provide that attorney medical records. So even though we're providing it, they can still request it directly from the source. So even though she may have subpoenaed information, part of discovery is her asking for it too. Does that make sense?
Makes sense.
Huh?
I said makes sense.
Yeah. It's at least back in the day, it was a lot of paper. Like a lot of fucking paper just to, it's like, well, why do I have to provide this if they're going to just request it anyway? But the reality of it is that, it's for transparency, right? We might provide something, and what if we leave something out? And then they get it from the other, like stuff like that, I guess, can happen. So,
right.
I think it is like in part for some type of clarity, but I don't know. I don't think we'll ever know with this case.
So we have the GAL review, and that I didn't address today, that I just set over to the 17th, but you said you set your matter to the 23rd?
Mm-hmm. Yes.
Maybe the 24th?
It was whatever that Tuesday is.
Yeah, September 24th is the Tuesday. So did you put it on the
23rd, so that I might have to go out and talk to the clerk.
You'll have to refile that with the correct date because it'll be sent back. So why don't we just set these matters, including the GAL review and the presentation of the motion and your presentation of the motion have onto the 24th. That makes the most sense.
Okay, so everything over to the 24th.
Correct.
Okay, very good. All right, very good. Thank you.
Thank you, Your Honor.
All right, that brings me to Klopp v. Klopp, cause number 19-3-00361-08. We have Ms. Turnbull, we have Ms. Baldwin, we have Lacey Klopp here in the courtroom.
It must be complicated working with a friend. Stop. But I love you. Can you just show the time?
So there are a few things, but in this case, I'm actually going to ask the court continue this matter 2 weeks. Ms. Klopp didn't file her responsive materials until I believe late Thursday of this last week, and then the guardian ad litem filed materials yesterday. But given that, those are both very late filings, I think it's appropriate that we continue it so that my client can receive those, review them, respond if necessary. And I think if a response is necessary, that's why I'm asking for 2 weeks, just so that there's a response that actually makes it to the court file. And then we can have an orderly hearing. The materials in this clock file are pretty extensive and fairly large. And so I do think it's appropriate that my client have an opportunity to review them and respond if necessary.
There must be something I didn't see.
And it might not have made it to the court file based on when she filed.
When did you file it, Ms. Clark?
Between that and restraining orders and law, it might have been Wednesday or Thursday, but I did send bench copies, so they were going to have them on your desk.
Okay, so the request is to continue it. Any objections to that?
I just don't think it's necessary because it's been continued nonstop since May 14th. I just would like.
Well, you're not paying an attorney, so you'll be fine.
Part of the problem is I haven't read everything. So the other thing that I wanted to make sure is clear to everyone is I had talked about a motion needing to be filed to adopt the recommendations of a guardian ad litem report or modify a temporary order or anything like that. But there's no note or docket, so it's not actually noted up. And I recognize you're not an attorney, but it gets it on so I know that's what's going to be done. Because with the many cases that I deal with, I need to know what am I actually doing that day. Okay. So that needs to be done as well. So I would not have considered that motion or that request today anyhow.
Okay, I just had figured the clerks would have said, I don't think just kind of.
So you will need to do the note, make sure Ms. Baldwin and Ms. Turnbull get a copy of that.
So do I just go to the clerk's office and say that I need like a docket notice for the motion?
Correct. Okay. That should be, I guess I don't want to speak for the clerk's office.
I'll just talk to them.
Talk to them.
Okay, thank you.
All right. So if that's the idea, I'd like to set it over to October 15th so everybody has time. That work for you?
That's fine.
Your Honor, that's the day I'm in trial.
That's right.
I can either do the 22nd, it's fine.
Okay. It's October
the 22nd.
Okay. Does October 22nd work for you?
Because there's really no other.
Okay. All right. So let's go to October 22nd.
Oh. We did have a presentation on, there weren't any objections to that, so I don't mind doing that today. I'd rather get that entered just because I'm worried that I'll get lost again. Okay. That was just on the order to compel.
The protective order also getting that thing moved out.
What's that?
The motion for the protective order for discovery.
Okay, so let's talk about the order first, compelling answers. And I reviewed it. It appears to be reflect what I had ordered. I didn't see any objections from you, and the court rules require you to put it in writing and file.
Nothing.
Don't make me come through this mic.
No, I was responding to my chat.
Oh.
Your objections to okay. All right. I understand you may not approve of what's in here, but do you approve as to it reflects my?
Yeah.
Okay. All right. So Ms. Baldwin, I've signed on that order.
Great.
And then if you want to address the, all right, so I reviewed the motion for protective order that was filed quite some time ago.
Is there going to be some type of resolution here?
May 28th, 2024. Was there anything that you wanted to add in regard to that?
It was just had been lost between transitioning between Scott and then Miss Winkles and then me being by myself. So that's why it was taken so long between. I didn't realize that a doc notice was never done. But for the protective order, I know that she said the subpoena had already been issued.
Tis an all new season premiere. It's beginning to look a lot like competition. It's Team Naughty taking on Team Nice.
But it was also objected to. And from my understanding, there's like certain things that need to be done for an objected subpoena instead of just sending it out. And then there's also the number 4 request for production is in the protective order because it's asking for all text messages that I've had since 2022 until present. And I just think that's like overly burden and it would affect a lot of people's privacy that they have with me.
Oh,
Including
give
my
us a
work
break.
employees. I have 2 jobs. I have clients that I talk to. I just think that it's irrelevant to this case. It's overly broad.
All right, Ms. Baldwin. First of all, the protective order was regarding the subpoena for the phone records specifically. So she can't now say, ooh, let me lump in other things I want to protect. Now, she can't. It's only regarding the subpoena, and we filed a copy of the subpoena for you in with our response. Number 1, this is moot, that they essentially abandoned their request. For them to obtain a protective order, they have to actually file it and bring it before the court. It's not a way of just filing it and then just thinking that that acts as sort of a barrier. You have to actually bring your motion. You can't just file an objection. That's not sufficient to protect. And the rules in that are very clear. Number 2, when you look as far as it being overly broad, it was regarding 2 phone numbers. And we ultimately only ended up requesting, after I spoke with opposing counsel, I agreed to limit it from January of this year till when we sent the subpoena. So 2024 for 2 phone numbers for this period of time. So essentially it ended up being 5-6 months worth of time. So that's very direct, it's very limited, it's limited in scope, it's limited in time, there's no burden on her whatsoever, so there's no cost to her. These are phone numbers associated with the people that we have concerns that would relate to 191 factors. And essentially what this is just a motion that's very buzzwordy, but with no substance whatsoever. And that's true also in the response that she puts in now 4 months later, she puts in a response saying, oh, this is, invade my privacy. We're getting directly at, are you still communicating with this boyfriend you say that you've broken up with, that's a domestic violence risk? Those are the things that we're directly driving at. And again, time limited, scope limited, no burden to her. This is not privileged. This is fully discoverable. Discovery and discovery motions are not supposed to be used as a sword, and in this case they are. Is that Mrs. is trying to say, let me bring this motion because I don't want you to see what these negative things could be. I don't want you to gain access to these things that would be problematic for your case. Everything that's not privileged is discoverable. And so in this case, they just have no leg to stand on whatsoever. The court should deny the motion and the court should grant fees. This is really a baseless motion, especially when this is targeted, it's direct, it's directly on point within case law within the statute. And at this point it's moot. So then bring it before the court when it's moot. After the fact, 4 months after the fact, just there's no basis to have done so. Sorry, I am asking for fees to be awarded. Any response?
Yeah, in the motion for the protective order that was given, it talks about the subpoena, but it also talks to preclude discovery of phone records involving communications with third parties non-relevant to this action, and to limit the scope of discovery to exclude communications with family members and friends to protect against harassment and undue burden, which goes back to the number 4 request for production that was sent in the discovery. So it's not only the subpoena, but it also is talking about the number 4 request in that discovery. So it does mention it in the original motion that was filed in May.
So again, the court understands that you're not an attorney and all the ins and outs may not be known. The court agrees with Ms. Baldwin in regard to what she said. It was filed in May. We're here in October. It's not brought to be requested until several months later. Meanwhile, in regard to the subpoena that was sent, the court does not find that it was fraud. It had to do with the telephone records. So are you saying that you think that the text messages?
No, the subpoena isn't broad. It's very narrow between the two numbers. It's just that the discovery request for number 4 is overly broad. It's asking for every text message that I've ever received or sent since January 1st, 2022, until that discovery was sent in April of 2024.
When I read the motion, I didn't see text messages as part of it.
I don't believe that they that all because that's honestly, this is very old.
It was just kind of briefly in the relief requested stated that discovery of phone records involving communications with third parties is relevant to this, and then limit the scope of discovery to exclude communications. So that is talking about like the number 4 request in the discovery where it's asking.
Right, but so if you look at their motion, it's regarding. Okay, I'm happy to address that if the court wants me to.
No.
Doc?
The court.
Yes.
I must be stupid or something, and I need some help here. Okay? When you subpoena I'm just going to use a number request, right? The court has the right to look at that number, right? The entire in entirety, except certain things, right?
When you do a subpoena, see, I'm kind of used to I'm used to subpoenaing like people, not records. But I imagine it's similar to like when you do a HIPAA authorization or authorization for records, you specify specifically what you're looking for. So, they subpoenaed her for her records, and if anything, I'm guessing that they were looking for specific numbers or communications with a specific person. Which, the way I look at it, there's so many different like phone apps these days for texting. Like, I have so many ways to text people that, you could say, oh, this is so and so's phone number.
Yeah, and I have like 10 different ways to text you. Yeah.
But I'm texting you from my Google number that you don't know about.
Right.
Like, so I could understand where their scope of records needs to maybe, be a little bit bigger.
Right.
But usually with a subpoena, you have to say what you're looking for. It can't be, I guess for lack of better terms, what that attorney said, it can't be a fishing expedition. Right. But I highly doubt that this attorney, Baldwin, is a fisher, is a expeditionist. I know that's not a word. But I highly doubt that she's fishing for shit. She knows what she's asking for, and she knows what she's looking for. Yeah. And I think this woman... Here's the thing. This attorney is not looking for anything outside of what's relevant to this case.
Right.
So, whatever her deal is just, I think, that's like a tactic that people use to avoid doing things. That's all.
Right. I just want to make sure I understood. Thank you.
Yeah.
Doesn't agree that it extends to that. You need something very specific to the text messages, the interrogatories, if that's what you want, and bring a separate motion for that request.
Okay.
Okay, and the basis for why, legal basis as to why those text messages shouldn't be disclosed. Okay. So in regard to the fees, the court does find and will grant $1,000 in fees for the necessity of having to be here on a.
That's another 1K for playing these games with the discovery. Mom won't win this.
Filed back in May.
We just do presentation on that same date.
60 days, what?
Oh, we can just do presentation on that same date.
That's fine.
On the 22nd.
Yes.
That concludes this docket.
The next docket would have been on October 22nd, but I was sick and unable to get the stream that day. According to Odyssey, they reviewed the GAL report and the judge signed the presentation of orders. There was also a motion to adopt the GAL recommendations, but for some reason the judge denied it. The judge also denied Mom's motion for a protective order for her text messages. It's hard to believe, but this case is finally near its trial date. I currently have readiness hearings scheduled for both November and December, and trial dates in December and January. I think the judge is probably worried about whether this case would be ready in time for trial in December, so she set those second set of dates. I wish these two could work things out between them for the sake of their son, but that doesn't seem like it's going to happen. I think a trial is unavoidable for this family. There will not be any new updates in this case as this courtroom is returning to in-person hearings after November 1st.
Aw, boo. That was pretty cool, though. So, we don't get to find out what happened, but we know that it goes to trial. And it said that the judge denied the gal's recommendation.
Mm-hmm.
So, that's kind of a shocker, huh?
The gal's recommendation, in my opinion, didn't make any sense.
Well, the thing is with the gal is that she did not see the red flags or the problems or the things that were problematic that the dad is not part of, right? Because he's not a part of the domestic violence stuff. He's not part of her behaviors. He's the recipient of some of her behaviors. But I feel like them pushing for for them to go back to 50-50 when the kid is excelling at the current custody situation seems crazy. Mm-hmm. But that she did get more visiting time. She gets from Friday to Monday every other week. So that's something. You still damn near get like half a week at least. Yeah. I don't know, but and also too, if she's not, her motion to protect her info was also denied. So, what is she hiding?
Right.
That she's probably still in a relationship. So, I don't know. That was a long one. Okay, so do we want to do the TPO hearing? Judge sends cops to remove child during the hearing. Actually, I think we will do this one because it's the same person that we normally watch.
Yeah, that's fine.
But I do think number 3 is going to get removed. Yeah. For reasons. Anyway.
When you get injured, they shout.
I wonder how old this one is.
Battle for you! Hurry!
I want to see how old this one is. Real quick here. This is 2 years ago. Okay. I was just kind of wondering why I had a different picture. It's the little things that catch my attention. Don't judge me.
Right.
I think we've seen something like this before. Wait.
Oh, this is
this is not being read. We too long. I don't know what the we too longer. Okay, whatever. TPO hearings today. The first with a man who thinks he should still be able to come and go from his wife's home whenever he wants, and the other concerns a woman who is acting so unstable in the video evidence. The judge calls the cops to take the child during the court hearing. Oh my god. Ugh, okay. That's crazy. Like, that's a whole nother level crazy.
Right.
Miss Bernie.
Whoa.
How did that go?
It didn't.
Okay.
And so
we know this judge too. We actually funny. We have potentially seen a portion of this because we've seen these two people already. The Michael and Perlia. We saw Michael and Perlia in a case before. Right. And we also like some of these people are very familiar looking right now. The Aponte person was in the last one also. We were seeing Glenn and we couldn't figure out why he was there. Now we know, cuz see we were so amateurish when we first started watching these court hearings that I wasn't realizing that we were looking at dockets and that people just kind of just sit there, I guess because they're waiting for their own case or they're just being nosy after their case is done. So now we know why there's always all these damn people in here sometimes, because this is a huge Zoom call. And if I'm not mistaken, the one that we saw, I don't remember the cops being called while she was there, or while I don't remember the cops being called while the case was going. So, I guess it may not even have to deal with him. But I guess we're gonna find out. Maybe we're gonna be rewatching something. Who knows?
Weren't really able to make any progress, so I think the court is gonna have to hear at least from Mr. Johnson. He had some procedural, I guess, concerns as well as, concerns related to the petition, so.
Okay, all right, Mr. Johnson, Ms. Johnson, if you both raise your right hands for me, take yourself off mute.
Yeah, we do know this judge also.
All right, you swear a firm testimony you're about to give in this petition for TPO?
She's no nonsense.
Nothing but the truth. Ms. Johnson?
I do.
Mr. Johnson?
I affirm.
All right, is it just the two of you or is there any witnesses, Ms. Bernie?
No witnesses, Your Honor.
All right, what about you, Mr. Johnson?
We're allowed to use witnesses in this case?
Do you have any witnesses?
I do.
Where are they?
Right here.
They can't be in the same room with you. Are they gonna have firsthand knowledge?
Yes, ma'am.
Okay. Well, we'll hold them send them out of the room. They can't be in there with you.
Go out of the room. Go out of the room.
And he said it so rude too, but
opening and just go straight into testimony.
Yeah, I'm happy to do that. I think we probably need to take up Mr. Johnson's procedural issue regarding service.
All right, go ahead, Mr. Johnson. I'll hear from you.
Go ahead. Well, my issue was I never was properly notified about any of this or anything going on. I didn't know about the procedure or anything. I came to my home and there was a piece of paper lying on the ground, and I looked at it and saw it had my name on it and a court date. And so I was real confused about that. I immediately contacted my lawyer and told her that I saw something and didn't know about it or whatever, didn't know what it was about, or just by happenstance saw something on the ground. And I was like, is this something serious, is whatever? And my girlfriend.
I want to hear about your girlfriend.
No, I'm saying she read through the document to me. You know what I'm saying? I read through it and looked through it or whatever. I never actually looked at the document and stuff myself. So she read through it, told me what's going on, told me the content of it and stuff like that. And,
Why didn't you read it? Why didn't you read it?
Because I don't want to read anything that I'm not supposed to have or I don't know about. So because it wasn't placed, anything wasn't given.
Okay, so according to this affidavit, which too bad you should have read it, according to Mr. Braisman, he personally served you.
He did not.
4:45.
He did not. Nobody personally served me anything.
According to
It was a
him.
blatant lie.
Okay, well, according to him, he served it. It's spot on here. There's an affidavit.
Oh,
for him that
he
did, so-
saw you and you let the paper drop on the floor. That's what you did.
You said what, ma'am?
Looks like it's a valid affidavit that he served you here.
That's fine. I'm telling you, did
See,
not.
you found it on the ground because he said he placed it at your feet.
He did not. That is a lie, Your Honor. And I will testify to that sworn on the oath that I never got anything.
I mean, you're testifying to it right now. He said it
Yes, ma'am.
testified it near the hands and feet of you while located at.
He seems combative. Just a little.
ACDC back live.
Got a good judge, though. Judge is not going to be.
She's no nonsense.
Looks like there's been proper service, so.
That's completely untrue.
Okay, well, we're going forward. Anything else?
Yes, ma'am. Well, what I was saying, yeah, that I went through that, and so you want me to discuss the contents of it, or how do you? I don't really understand how to.
Is that your only procedural question you had?
Yeah, I never received it. I just never served that order properly, and I did, so I wasn't aware about the court hearing. And there was something said about a previous court hearing or whatever, where this was.
I don't know about that, but you're here, so how'd you get this Zoom link if you didn't know it?
Ma'am, I saw it's on the front page. I saw the link, saw the thing. Like I said, my girlfriend picked it up and read it to me.
Okay, we're going forward with the hearing. So now would you like an opportunity to speak with Ms. Burney or not?
No, let's go forward with the hearing.
Okay, go ahead, Ms. Burney. He's all in.
All right.
We're all in. Let's go.
Ms. Johnson, you're married to Brian Johnson, is that correct?
That is correct.
Whoop, he said he had a girlfriend. There we go. We're going downhill right now.
And prior to May or June of 2021, how would you describe the status of your marriage?
Well, very very unstable. We were married in 2009, and in the first few years it was fine, but we had a lot of issues, a lot of control issues, and we just decided to part our ways, and he moved out, and he's been out for 3 years.
Okay, so he moved out 2018 or 19?
About 2018. It's been 3 years, so he moved out into June, July. I believe it was 2018.
Okay. And you all have lived in a bona fide state of separation since 2018?
That is correct.
Okay. And do y'all have any children together?
We have one daughter. She is 6 years old, Blair Johnson.
Okay. And you filed a TPO against Mr. Johnson, is that correct?
That is correct.
Yes, he keeps coming in and out of her house.
Opportunity to read the petition before it was filed?
I did.
Okay. And are the allegations contained in the petition true?
They are.
Okay. Let's take a minute and go through the petition. You stated in paragraph 4 on June the 6th that he came to the house and he took security cameras down.
That is correct. He does that. He comes to the house. He takes down the security cameras that I have in place.
Okay. Was your daughter present during that time?
Sometimes she is, sometimes she isn't. At that particular day, she was not there.
Okay. All right. And then you also allege in your petition that in May that there was a physical altercation, and that's really what the court wants to hear about. So tell the court what happened.
So in May, Brian was upset that I was dating someone, and that person was doing my yard, doing the landscaping on the home that I still currently live in.
Which is the marital residence, right?
Yes, which is
the one that he moved from back in 2018.
Correct.
Okay, go ahead.
Since 2018, I've been living there, maintaining the home, the residence, bills, everything. Then when a few weeks before that, I did explain to him, he came to the house. He was upset that somebody was doing the grass, the yard. He said, next time you need to let me know. You need to ask me for permission and tell me, ask me for permission, and I give you permission if someone can do the yard. So 2 weeks fast forward, I told him that the person I was dating was coming and he would be doing the yard. So he was aware, and I didn't ask for permission, but I did let him know. And so the day came, and when he FaceTimed our daughter, he saw my friend's child, and I guess that alerted him that, hey, this guy must have stayed the night in the home. He then texted me that I was out of line, and the next thing I know, he's coming through the garage door. He didn't go, no ring doorbell, just barging through the garage door, and he said, "Yeah, I need to talk to you right now." He, my friend walked outside. I guess Brian didn't notice. Brian came again. I said, "Where he at? I need to talk to him right now," And so then they proceeded and they went outside. They exchanged words. To what I wasn't out there. I don't know what they said. It's just hearsay. Basically the gist of the conversation is hearsay, and what it was that he told him he could no longer stay. He couldn't come to the home anymore. This is his home, and that my friend couldn't come anymore. My friend told him, "No, I am." So they had no physical altercation. So at that point in time, I guess when he asked my friend, "Are you comfortable now? You comfortable? You got enough space? You good? You good?" And so my friend said, "Yeah." And I think once he told Brian that he wasn't going anywhere, then Brian started to advance, and my friend took 2 steps back. He retreated, and then he showed Brian that he had a firearm. Like, he lifted his shirt up or, showed his hip. And then Brian ran in the house and was screaming, cursing. And I guess in the midst of all of his, the excitement, the anger of the situation, he decided to punch holes in my bedroom walls.
Okay, so was it Brian that punched the holes in the wall?
Yes, ma'am.
Okay, and so it sounded like from your testimony, you're saying that he took the first steps toward the other person that was at the house.
That is correct.
Okay. Was there any intervention by anybody? Were the police called?
The police were called. When the police came out, of course, when the police arrived, I was already outside with my friend. Brian came outside and told the police, "What are you doing?" I called him, talked to me. The police said, "I got it, sir." And he proceeded to talk to my friend. Once he talked to him, he decided he wanted to talk to me as well to figure out what the situation was. And then another officer came and started to talk to Brian, and also Brian's girlfriend, who also came with him that day.
Okay.
They both, at that time, the cop pretty much said that, my friend was very much within his rights, because but they both got, Brian had received a simple assault charge, because, Brian felt threatened, but my friend also felt threatened. So he received a simple assault charge, and at that time, when
okay, hold on. Mm-hmm. I'm gonna see if the screen share work.
Grip, stability.
This don't sound like it's going in his favor.
Essence of driving. Lawfin.
Ew. People do things without consequence.
Let me show you what I marked as Exhibit 1. You recognize this document? Can you see it? Is it on the screen?
Just your files on the screen. I don't see anything yet.
It says I'm sharing it.
Oh, yeah, because you clicked the wrong window, lady.
You gotta click on, yeah. It's on,
You gotta share the specific window or share your
now it
entire
is.
window.
Okay. Can you see it now?
He wants me to cover
Yes.
up.
Okay. All right. Do you recognize this document?
I do.
What is it?
It's the police report.
Okay, and is this from the date that you were just describing in your testimony? Can you hear me?
That's a yes or no, lady.
Oh, I think she froze.
Yeah, I think so.
Ms. Johnson?
Crash and bury me in.
Yeah, I think she froze up too.
I just sent her.
Yeah, she may have to come back on.
Yeah.
Whoops.
Hey, shit happens. I mean, they could fill up the space.
Yeah.
I don't know why anybody would go to court sitting in their car.
A lot of people do.
Yeah, but it's not reliable.
No.
Quite a bit of dead air.
Yeah, a lot of dead air.
I'm surprised they didn't skip this part.
Standing by.
I'm texting her to see if she's reconnecting.
Okay.
I guess this is the only bad thing about technology.
This is.
Yeah.
The best thing is the mute button.
True that. True that.
Okay, she's trying to reconnect.
Got her.
I don't know. To me, like certain like some
You're on
things,
mute, Miss
something
Jones.
like
There you go.
this is serious enough.
The temperature got too hot on my phone.
Okay, so you identified this police report as from the incident that you were describing. Is that correct?
That is correct.
All right. Move to admit.
Any objections, sir? Take yourself off mute. Any objections?
That this is a, you asked me if this is, do I agree that this is a police report?
Do you have any objections to this being admitted into evidence?
The police report, no ma'am.
Okay, it's admitted.
All right. And for the court's information, the document is certified.
All right, thank you.
All right, Ms. Johnson, also show you
My booty. You'd be so proud of me. I put my clothes in the dryer. I told you, right?
Yes.
I don't remember.
Yes. Yes, you did.
I'm hangry. I don't know what I'm gonna eat.
Food. Hopefully.
Whoa.
all right, can you see that, Ms. Johnson?
Ooh, that's an ugly
you're on
color.
mute.
Yes, I can.
His girlfriend
Okay.
thinks of him acting
You
this way about his
recognize
ex-wife's
P2?
new boyfriend.
Yes.
And what is P2?
That is my bedroom and the 3 holes that Brian punched in the wall.
Okay. And are these true and accurate photos of what you just testified to?
Yes.
Okay. And can you see P3?
Yes.
Okay, and that's a close-up of the same holes that were punched in the wall?
That
Okay.
is correct.
All right. Move to admit P2 and P3.
Any objections? Any objections?
No, no, yeah.
Okay, it's admitted.
Nothing like being faced with your bad
Nick
actions.
Simrod, and today I'm checking out the Yamaha Modi X M8. One of my favorite new things about the
Okay. Now, Ms. Johnson, in your petition, you also described prior incidents of violence by Mr. Johnson. Can you tell the court what happened?
We had an incident about last June, I believe, where we had a disagreement over a used bike that he said that I knew where the whereabouts were, and I did not. So he told me I was a liar. He said, I will kill you, bitch, which is normally, you know, when he's upset, that's what he says. He called me trash, I'm weird, I'll kill you. During that incident, we were close up on each other's face, and he had his hand on my face, and he spit on me. And he was so close, he was spitting on me. And when I moved his hand, I moved his hand out of my face, and we started tussling on the steps. To protect myself, I did try to grab, like we were on the steps, so I tried to grab anything that was on the wall, and I started to hit him with it so he can get off me. He pinned me down. I started to kick by anything to get myself from underneath him. He pinned me down to the ground. At that point, his cousin, our mutual friend, came out of the room and said, let her go, like she can't breathe, let her go, Brian, let her go. And she said, I tried to pull him off of me, and he didn't until she was like, Brian, like my heart, I can't take it, let her go. And then he finally let me go.
Okay, and that's what you described in paragraph 5 of your petition, where you said he threatened to kill you, he pinned you down with his forearm, it made threats to kill you, etc.
Yes, that is correct.
Okay, and were the police called at that time?
For that incident, no, ma'am.
Okay. And have you initiated any contact with Mr. Johnson since you filed this petition?
Since I filed this petition, no.
Okay. And has Mr. Johnson initiated any or made any contact since he was served with the petition?
He just, he had, since he's been served on Sunday, he did come to the residence on Monday to pick up a package from the home.
And this was after he was served?
Correct.
Okay. And tell the court what you want to tell the court about Mr. Johnson. Do you feel threatened by him in his presence?
I do feel threatened by him because I feel that if something doesn't go his way, or he's not in control of me or the situation, then his behavior is very unstable. I'm very fearful because I don't know what he's going to do, when he's going to do it. I don't know what's going to what is going to upset him, what's not going to upset him. I can't even walk in my home without the alarm going off, so he can know when I'm home. There is, the trackers on our daughter's phones. Whenever she's with me, he knows exactly where we are at all times. It almost feels like I can't live my life without him knowing every single thing that I'm doing.
Okay. Now, you've talked about the violence and the threats made against you. Has he exhibited any of this behavior towards your daughter?
No.
Okay. So you don't have any concerns that he will harm her? The real concern is towards you.
Right, none at all. Him and Blair loves her father, she loves him, that's never an issue.
Okay. And are you asking for the court to enter this temporary protective order?
Yes, I am.
Against him? Okay.
Yes,
and
I am.
You're not asking for the TPO to apply to your daughter Blair, are you?
No, I'm not.
Okay. What do you want the court to do with respect to Blair? Well, let me start here. Do y'all have any sort of parenting schedule in place already?
There's no schedule in place. It is some days I know when I'm going to keep her because he drops her off. We've been trying to communicate a schedule, but it's off and on. And even if it's my time with her, he'll still pop up to the house and have his time with her as well. And he said he can see his daughter anytime he wants to, and he can come to his house anytime he wants to. So even if it is something that we try to set in place a schedule, he'll pick her up and he'll spend time with her even if it's my day or my time.
Okay. So basically, he just does what he wants to do.
Yes.
Okay. And so are you asking the court to enter a sort of a temporary schedule?
Yes, I definitely want a schedule. There needs to be boundaries set in place. We need to respect each other's space and each other's time. Our child needs consistency. We need consistency, and that's what I would like.
Okay, and what schedule are you asking for the judge to put in place?
If we can have alternating weekends, would be fine. A Thursday to Sunday, and then Sunday to Thursday is what I would like to be in place.
Okay.
And for us to have a mutual a location where we don't have to see each other, party that can intervene and keep Blair in a public space, so that we don't have to be around each other.
Okay, well, the TPO is issued. You're not going to be allowed to have contact anyway. So what you're saying is you want designees to be able to do the exchange with Blair.
Yes.
Okay. And in your petition, you also asked for temporary child support. Has he been providing any child support at all for Blair right now?
He has not.
Okay. Tell the court how much. What is your current income? How much money do you make?
Currently, I make $30,000 a year.
Okay. What's your hourly rate? Is it?
$13.50, I believe.
Okay.
I'm working in this wet material that's just like quicksand. Just gotta be cautious. Oh no,
Ew.
I think I'm sinking.
Okay. Is that on the screen? I'm sorry, I can't tell.
Yes, my page. It's not. It's highlighted. It's just you just need to click on it.
Okay.
You did it again. You don't know how to share screen.
Sometimes this works and sometimes it doesn't. On my screen, it's open.
It's you.
Already.
I think you just need to drag the open file over to that screen.
Share your entire screen, lady.
No, because what's showing is I think a couple of your clients' names.
Okay.
This is not rocket science, lady. Not rocket science.
That must have opened in a different screen. Drag whatever opened up over to in front of that.
Her problem is she's sharing a specific app and not the screen.
There you go. But it just had it.
Okay. Is it gone now? Or
yeah, it's gone now. Where you just moved it, it was there.
Does this attorney need Zoom 101?
I'm sorry. Sometimes I get this right. Sometimes I don't. Okay. Is it there now?
No. No, lady.
Okay. What about now?
No. She's not sharing her entire screen.
Okay. I'll just have you testify to it. So your hourly rate is, you said, $13.50 an hour?
Yeah, that is correct.
Okay. Do you know what Mr. Johnson's income is? Approximately?
I do not know.
Okay.
I do not know.
All right. And you work approximately 40 hours a week?
That is correct.
Okay. Thank you. That's all I have, Your Honor.
Mr. Johnson, do you have any questions?
The questions?
Right. Any questions for her?
For Sharika or?
Yes.
Okay. Let me think about it for a second. I'm not very familiar with the court process, so I'm trying to kind of learn as I go and take in everything. I have a couple of. Is this the point in the trial where I can dispute what she says, or would I do that?
If you have any, right now if you have questions for her, you can ask her a question.
I don't have anything to answer.
All right. All right. Anything else, Ms. Bernie?
Sorry, I was muted. Nothing else, Your Honor.
All right. All right. Go ahead, Mr. Johnson. I'll hear from you.
Yes, all right. So, she covered a lot of ground and a lot of different things. If the court could, as I take my time trying to remember everything that was said and all the allegations, I want to kind of run them down one by one. First off, majorly the problem with me being violent. I want to address that directly. I've never in my life touched her. I've never in my life put my hand on her. I didn't threaten her. I'll speak specifically to the incident that she directly responded to about there being a violent situation. I came in my home and just asked her where was an exercise bike. It was during the pandemic. And so I was trying to stay in shape at home or whatever because the gyms were closed. So we had an exercise bike, and I asked her where was the exercise bike, because it was in the garage the last time I placed it. And then she said she didn't know where it was or whatever. And I was like, but it was here, like you had access to it or whatever. It was here, so where did it go? She's like, I don't know. It was a long time ago. So I just asked her about the thing. She started yelling at me, and she was all the way at the top of the stairs. I was at the bottom of the stairs. There may be 15, maybe 12, 13 stairs or whatever in the home, going from the first level to the second level. She came down all those stairs, and I went up. She came down 8 of those stairs. I went up 3 or 4. We met on a plateau in the middle, and I told her, I was like, stop yelling and screaming at me. You can't yell and scream at me. That's unnecessary. And as she began to continue to scream at me or whatever, she got in my face. What you gonna do about it? What you gonna do? I ain't scared of you. Like, being very, very confrontational. I'm not in any way, shape, form, or fashion trying to have any type of physical altercation or anything with her. She kept screaming in my face, yelling in my face. I told her, stop yelling at me and get out of my face. She proceeded to grab a picture off the wall, hit me in the head and face with the picture, and cuts on my body. Then she started punching and screaming. I'm trying to grab her arm and restrain her from attacking me. She continued to hit me, punch me, kick me. As she did so, I restrained her arms by her wrist and stopped her from hitting me. Then she started kicking me. As she kicking me, I grabbed her legs and pinned her and got on top of her to stop her legs from kicking me and restrain her arms from hitting me. The third party who was in the home, who will not in any way, shape, form, or fashion, if we can subpoena her as a witness, validate any of her claims. The only person in the home who saw what was going on can testify, and I'm 100% for that. That third person say what they saw or whatever, but she did not have to tell me to do anything. She came and she was like, I talked to her the whole time. I was like, I got her. I'm just stopping her from hitting me. I'm restraining her from hitting me. I got her. I'm not hurting her. I'm not going to hurt her. I'm sitting on her legs and holding her arms because she's punching and kicking me. And I'm telling her, stop it, because I'm not about to get in any type of violent situation with a woman of any kind, because that's not my character. She then, as I was holding her arm, she bit a plug out of my stomach. I have pictures of that, where she bit a plug out of my stomach, and I'm telling my cousin, like, man, she's biting me and my cousin have a dialogue the whole time. Like, she just bit a plug out of my stomach. And then so I was like, Shay, get her and remove her. I do my best to avoid her. I don't like being around her in the same vicinity, in the same I don't like her in my personal space. I avoid her at all times because she has these delusional reactions and statements to things that I don't want any part of, because I know how this can look for a male. I know how this can look when a woman cries violence and stuff like that. I haven't done anything to her, so I make sure to keep myself out of those situations, but she initiates and engages me consistently. That's not the first time she hits me. She also assaulted me prior to that when I came to the house about another issue, and she hit me. And so she's assaulted me at least 2 or 3 times. I don't file police reports about anything because that's not what I do. So I don't have it's not a police record about them, but she has definitely attacked me on multiple occasions as the aggressor or whatever, and I never do anything but restrain her. Ma'am, I am 6'2", 280 pounds. I'm a very large man. I do not have any type of youthful strength of any kind to do anything to that woman. So that's a blatant lie. And like I said, the third party who she claims as a witness the thing, told me verbatim that she does not agree with her account on the statement and would say so. The home, let's go back to the beginning like they did. The home was never vacated. Me and Ms. Johnson agreed in 2017 that our marriage was not working. It was not going anywhere. It was not processing, and we should mutually separate. In doing so, we cannot continue to cohabitate in the same space. So what I decided was I will go and get a secondary residence in addition to my home. In addition to the shared property, I will get a secondary apartment so we don't have to be up under each other and can live our own separate lives and do things the way we want it. I want my own space to be able to do what I want to do, not a space that's shared with her. Because I can't bring, if I want to entertain company, I can't do that in a home that we both mutually own together. That's disrespectful if I bring a female or whatever in that home or whatever and try and have a relationship functioning out of that home. So I got my own separate place, a secondary location to be able to run as I see fit. And so in doing so, I never in any step or phase of this said, this is your home, I'm leaving it, I'm whatever. No, I still continue to come over daily or about every other day. I continue to sleep there. I continue to come take naps in the middle of the day. I will come pick up my child. I come and build, we come do posters, we do projects together. I'm in and out of the house. I still maintain the property. I still cut the grass. I still service the yard man. I still have all my stuff stored there. I still have music equipment. I have clothes. I have gardening equipment. My grandparents are hanging on the wall. I still have my pictures of myself and my mother on the wall. I still fully have 100% access and use of that home. I still come over for dinners, for different things like that at times. Thanksgiving dinner, 2020 out, like that. I carved the turkey. We still jointly function at home. It has never been I totally removed myself from that situation and vacated it. I've never vacated that home. I still paid the mortgage on the home from 2018 until 2019 when me and Ms. Johnson mutually agreed.
So I really just want you to respond to the violence. You guys ain't got a divorce and y'all need one. I mean, I don't care about you paying the bills. I just want you to respond to the allegations of violence.
Yes, ma'am. Okay. Well, we'll go back to the violence. I never touched her. I didn't hit her at all. I did not curse her out or nothing. I didn't say anything to her out of the way. I did not put my hands on her physically. I did not touch her at all beyond restraining her wrist from punching me. I was being assaulted and attacked violently, and to stop that, I'm being hit with a picture frame with glass. I'm being punched. I'm being kicked, and a plug was getting out of my stomach. And there's a witness there that saw all of this.
All right, you've said that twice now. Anything else you want to tell me?
Anything else I want to tell you concerning violence or anything else?
About the allegations she's made.
Well, I was trying to respond to the allegations about the home or whatever, and I didn't. And you
well, I mean, who pays the mortgage? I don't really care. This ain't a divorce hearing. It's just about the violence. What else? Anything else about the allegations that she made?
Okay.
Anything else about the allegations she made? I mean, I don't care who owns the house. Y'all need to get a divorce.
Yes, ma'am, we do, and I filed for divorce, and it hasn't been served through the court. I filed two times, and I just went in last week to get the process, divorce papers process even faster or whatever. I'm trying to stay on them about that. But the violence is total. Her allegations of violence are total lies. I've never touched her. I've never assaulted her. I've never done anything to her in any type of violent way at all.
Ms. Brown, do you have any questions for him?
Sure do. Mr. Johnson, you were charged with simple assault, is that correct? In May of 2021?
I sure do.
Yes.
And isn't it true that those charges are still pending?
Yes. Can I speak to that incident, Your Honor?
Well, no, it's my opportunity now, so.
I wasn't aware of that.
Well, answer her question, sir.
Yes,
now, you also testified that Ms. Johnson was punching and kicking you and bit a plug out of your stomach. Did you seek any sort of medical treatment?
It's a plug in my stomach. It's not a gunshot wound, ma'am. It heals.
So my question is, did you seek medical treatment?
No, ma'am.
Okay. And you didn't call the police?
No, ma'am.
And you don't have any physical evidence of
I have pictures of it.
Of that?
I have a picture of it. Would you like it?
No.
I bet you wouldn't. Okay.
Wow. And you also admitted that you left the home and secured a secondary residence. Isn't that correct?
The judge just informed me that we're not here to talk about the home. So
answer her questions.
I don't understand this, Yana. I don't understand why.
Sir, I didn't want to hear about who paid the mortgage. Just answer her questions.
Yana.
That's all I have.
Jonathan, I don't care who pays the mortgage. She's asking you a question. If I think it's not relevant, I'll tell her to stop asking.
Yes, ma'am. What's the question?
You testified that you secured a secondary residence. Isn't that correct?
Yes.
And you also testified that you come to the house to take naps in the middle of the day. Isn't that correct?
I come to the house at all types of times to do everything.
Okay, when you come to take naps in the middle of the day, Mrs. Johnson is not at the residence. Isn't that correct?
Whether she's there or not, that's not my concern.
Okay.
I come to my home that I own.
I have no further questions, Your Honor.
Right. Anything else, Ms. Bernie?
No.
No, would you like closing arguments or did you?
Sure, go ahead. You give me closing.
I'll let Mr. Johnson go first and I'll defer.
Go ahead, Mr. Johnson. Mr. Johnson, how much money do you make a month?
A month?
Uh-huh.
Not enough.
Before taxes.
Now I'm a calculator now. 2,400.
Sorry, sometimes my mouse is on the other screen. Takes a minute to get to the other side.
Do
you give Ms. Johnson any child support?
The child stays with me out of most of the time. She's with me more than her mother. She stays with me maybe 4 or 5 days a week, and I pay for her, provide for everything.
Johnson child support?
No, ma'am, I do not give her child support because I support the child directly myself. She's with me the majority of the time. She's with me all the time. I take care of her fully. I pay for all her bills. I pay for whatever she got, clothing, expenses, gym, extracurricular activities. I offer to pay for anything her whole life. Any financial gain?
Is she on your health insurance?
On my health insurance? She's on Medicaid. Or Medicare, whichever one it is for child. I forget which one's for children, which one's for elderly.
Okay.
I wish whoever's doing that would mute.
Contractor, so I don't have health insurance through my job or anything.
Ms. Bernie, you have any more questions for him as far as finances?
Disgusting.
Who's your employer?
I currently work at a church. You need the next actual name of the church?
Mm-hmm.
I work at Impact Church.
Where are they located?
In East Point, Georgia. I recently just started there 3 weeks ago.
Okay, what do you do?
I'm a musician.
Okay, that's all I have.
All right. Anything else, Mr. Johnson?
Concerning what? Because and I like I said, I'm not trying to be out of order or disrespectful or anything. I'm just not.
No, anything else? I mean, I don't care about who pays the bills. There's allegations of violence. That's all I want to talk about is the allegations of the violence, not who pays what bills, anything else.
Okay, so as far as violence,
anything else you want me to know?
Yes, ma'am. I've been assaulted. Speaking directly to the other incident, I was threatened when someone walked in the home. When her boyfriend was there on the incident in May, I calmly asked him can he step outside and talk to me and have a conversation with me man to man because there was women and children in the home. We walked outside. We decided to try and discuss. I tried to explain to him and just have a simple conversation with him about what happened and about how our situation is set up to try and make sure he understood, my concerns about him being on the premises or staying at the home. I don't know why, another man would want to stay in another man's home, but I just wanted to have a conversation with him about that. He became agitated with me. And I actually have video of this whole incident from my neighbor's Ring camera from start to finish, where we're having a conversation and where you can see that there was no threat or whatever from me towards him. There was no screaming or yelling from me. I never agitated, never got excited or anything. He proceeded to flash it, to show his weapon to me in my own home. I had to run inside the house to get away from him. And his weapon, he followed me through the garage and then came around the front with the weapon pulled out. You can see all this on the video. He came in saying, my home screaming, yelling, causing the kids to cry, causing, you can see the weapon, like I said, you causing the kids to cry. He threatened, he said, I'm going to whack this nigga. Quote. He threatened to kill me in my own home with children and them present. His son came out screaming, I want to stay with Blairberry. I want to stay here. And screaming, he like get in the car. He agitated the whole thing. He was screaming, I ain't going nowhere. Ain't nobody gonna tell me what to do. He said he made all types of threats of violence towards me. My girlfriend, who was the witness, was there present, saw his
Mr.
gun.
Johnson, I hate to interrupt you, but do you have a TPO against him?
I don't have his address to get a TPO against him.
Okay, so I mean,
no.
There's nothing I can do. There's nothing I can do to him. You don't have
Yes,
to
ma'am. And so she can't. She also.
So that's what I'm saying, Mr. Johnson. So there's nothing I can do about him. So
Yeah, but she was able.
I mean, there's nothing.
She's able to tell the story about what he did.
She had him in the home. Is that not her responsibility?
You don't
That's what
have
the
a,
police was saying.
You also haven't applied for a TPO against her. You didn't file a counterclaim.
Because I didn't know. I wasn't aware that a TPO order was filed against me until.
Sir, if you'd have picked up the papers that were laying on the ground instead of having your girlfriend read them to you, and you would have read them. But I'm digressing. Miss Bernie, go ahead. Closing argument.
Judge,
Go ahead, Miss Bernie.
Judge, it's remarkable that in Mr. Johnson's closing argument, the story became more elaborate than when he was testifying and he presented evidence to the court. All of a sudden, we start hearing about all of these various things that happened. And instead, he tried to say that Ms. Johnson punched him, kicked him, bit a plug out of his stomach. There was no TPO filed against her. There was no police report made of that incident. He did not seek any medical attention. What you do have in front of you is a police report that was made on the incident that formed the basis of Mrs. Johnson's TPO. Mr. Johnson admitted on cross-examination that he was charged with simple assault, which is indicated in the police report, and those charges are still pending. Notably, you also had the photograph of where he punched holes in the walls, which, by the way, he did not deny.
Park City, your boundless playground. Plan your adventure.
I don't wanna.
Money for your car crash case? Call William Attar, 444-4444.
Can I speak to that?
So
we're closing, sir. Go ahead, Ms. Bernie.
I didn't get a chance.
Mr. Johnson, you have had an opportunity. You wanted to talk about her boyfriend. Stop. Go ahead, Ms. Bernie.
So we're asking for the TPO to be granted against Mr. Johnson. We are asking for the court to enter. This is the first time we've heard that he has filed for divorce. I'm not sure why he's not had her served, but that's great because she doesn't want to be divorced. We're asking for a temporary parenting schedule to be put in place from some sort of schedule Thursday to Sunday. We're asking for a reasonable amount of child support to be issued, and that's on a temporary basis. Obviously, we can deal with the rest of that with the Superior Court judge on the divorce. I'm happy to run a worksheet or whatever the court would like.
All right. We'll be glad to go ahead, Mr. Johnson. Go ahead, Mr. Johnson.
Ma'am, I'm not allowed. I'm not sure what I'm allowed to say and what I'm not.
Sir, you were allowed to, but all you want to talk about was the boyfriend.
No, ma'am, I want to talk about everything.
You didn't, Mr. Johnson.
Well, I don't, because you keep, every time I say something, you
No, sir, I didn't. I told you I didn't want to hear about you paying the mortgage.
I tried to talk about the incident. I tried to talk about, I want to speak to what's being said to me. I want to be able to dispute the allegation. I punched a hole in the wall because I was locked. I was stuck upstairs while someone was with a pistol. Me and my lady and my daughter were locked in a bedroom while someone else was at the door with a pistol, keeping us safe. I'm fresh cheese. I locked her out of the bedroom to stay away from me. I'm trying to protect and stay away from us. No one was in the room. Out of frustration of the incident going on, I hit the walls because I'm trapped in a room in my own home with my daughter and my friend, and I'm not allowed to. I'm frustrated because I can't protect myself because I'm unarmed. No threat to her. no violence towards her. I'm in a room locked by myself with the man standing downstairs at the pistol, with her and the man standing downstairs, and I can't leave because there's someone threatening my life. So I call the police because I'm trapped in a room upstairs. I punched the holes in the wall.
Yes.
Okay. This guy is like, what? I'm over here like, what the hell?
No, I completely agree with him. His wife was able to tell these stories about him in her, her perception of what happened. He has every right to respond to that. And one of the incidences that she shared was with him and her boyfriend. So he has every right to tell his version of what happened.
Well, yes, but he's doing it during a closing statement.
Well, people don't know the decorum of court. He keeps saying he don't know the decorum, but even when he was talking or giving his own testimony, yes, he moved on to the like mortgage and stuff, but that's because his ex-wife mentioned that he keeps coming in and out of the house, and he's letting y'all know, I come in and out of that house because that house belongs to me. I still technically live there, even though I have a second residence.
Yeah.
I live there. I come and go in and out of that house. I've, for whatever time he contributed to the bills in that house.
True.
Just because he doesn't like pay the bills now or whatever, he can still come and go out of his own house. Like,
Right.
I understand why he said what he said, but the judge cut him off, and instead of telling him, hey, don't talk about the mortgage, he didn't probably, because people don't think in the moment, but he probably didn't get a chance to redirect his brain to respond to the other stuff that was being said to him.
Right.
And so he took the opportunity of the closing to address what the other incident, and then he gets cut off of that too. He's not talking about her boyfriend. He's telling his perception of the incident and how he was feeling that day. Why does she get to paint him as being, the violent husband that's being intrusive, when people who are married and are not divorced but maybe a little bit separated but still have she even made it sound funny that he had shit come into the house, that he picked up something from the house. Why wouldn't he? That's his mailing address.
Right.
Like, make that make sense.
Okay.
And it's even a little unfair that she's doing this TPO order, because now you're preventing him from going into his house.
Mm-hmm.
So if you really want a TPO order, how about you sell the house and then you both don't have the house?
Right.
But I guess that's a divorce issue. But
I guess so.
I don't know. I'm not saying that he's not guilty of the things that she's saying, but let him fucking talk.
Yeah.
Like, usually the person that doesn't have the attorney is the one who sometimes gets kind of railroaded because they just don't know any better. But we've also kind of seen a case just now, right? We watched 4 hours of a case where both parties didn't have an attorney at some point.
True.
And even in that, there was the railroading happened at the end, actually, when the wife didn't have an attorney anymore. She got caught up. But her ex-husband didn't get caught up because he knew what he was doing.
Yeah.
These people. Sorry. Let's get him over with. I think the next one's going to be
Hit
more
the
interesting.
wall or whatever, out of frustration because I'm trapped in the room. Not any violence or anything toward her. She's locked outside of the room. I'm keeping myself and my daughter and us safe from them.
I've had a few mortgages over the years. I always mentioned I had National Guard service, but nobody ever...
There was no threat of violence towards her. She was not in danger in that situation. So using that as some form of danger is insane. I locked us in the room.
Anything else?
Yes, ma'am.
What else?
Also, you said only speak to violence, right? or am I allowed to talk about the house in the way that they're trying to frame it that I vacated it and was not have access to it? I'm just trying to make sure and be compliant, man. I don't want to be difficult.
You're not being difficult. So this is about.
Yeah, but she brought it up.
This is about family violence. They
He
don't
brought
want
it
you
up.
near the house is what their argument is. They
Yes,
don't want
ma'am.
you near her. They don't want you near the house. That's all they're saying.
And I'm leaving. I want to live in my home. I do not want. I've notified her that I'm moving fully back into this home, and I want access to the house to live there. I'm not going to live anywhere else. I want to fully 100% live in my home, and I don't have any problem.
She don't want you. She don't want you there.
That's fine, and I don't understand. So my question would be, what rights does she have to more access to the home than
You
I
need to
have?
get a lawyer for that. This isn't rights time. I'm not your lawyer. I'm not your lawyer. I'm sorry. I'm not your lawyer.
Yes, ma'am. But so I'm saying I don't want to vacate the home. I want to live in my home.
Okay.
So I don't want to be barred from living in my home or having access to it. If she doesn't want to live there, that's fine. She can go wherever she wants. Her whereabouts, her whatever. I just want my property, my child, and that's all I care about. I can really care less about anything else.
Judge, he's admitted to the violence that was depicted in the photograph. He's admitted to the simple assault that's indicated on the police report. We have the evidence of Ms. Johnson about the prior incidents. We believe there's more than enough evidence for the court to issue this TPO against Mr. Johnson, to schedule a temporary parenting agreement so that there's no confusion about that, and temporary order of child support.
All right, Ms. Bernie, I'm going to go ahead and put this in place. We'll email you a blank order in Word. If you want, you can use that what is it called? Exhibit A, the Fulton Exhibit A parenting plan if you want. You can still find that online. So you can fill it out and shoot it back to us, and we'll e-file everything whenever you get it to us.
Okay, thank you, Your Honor.
All right, and Ms. Free, I think we got her email. I think it's on the calendar. We have Ms. Bernie's email, Ms. Free?
I think she does. I got the reset order. Yeah.
Okay. Okay. All right, thank you. Everybody stay healthy and safe. Is it .net, .com? How's it?
Oh, sorry. Oops.
It's .net.
Okay.
And you want me to do the parenting plan and a proposed order on the child support?
Sure.
Okay. Thank you, Your Honor.
Okay.
Thank you. May we be excused?
Absolutely. Stay healthy and safe. Have a good weekend.
Thank you. You too, Your Honor.
Go ahead and leave. All right, Brown versus Kennard.
Okay, so that's what I thought it was. We don't actually, I don't think we need to see this next one because you and I've already seen it. So I was gonna make an executive decision to kind of like either to move on.
That was a lot for me.
This was your idea.
No, no. That case was a lot for me.
Oh well, it's just a lot of mumbo jumbo. So, do we want to? I can't do number 3. Number 3 is I associate this YouTuber with clickbait because of what happened last time.
Okay.
So.
But it's also no.
It's only 14 minutes. So and yeah, and I'm gonna be upset if I waste 14 minutes and then don't hear the resolution. I'm being honest. Okay, so this is a forging paper one. Does that sound? Angry judge slams vindictive ex-wife for forging papers and destroying property.
We saw that one.
We did? Okay.
We did.
I'm taking your word for it. I don't know if I want to see terminating biological father's parental rights, and it's a part 1, so I don't want to commit myself to watching more parts. Greedy ex-wife demands judge to dismiss the nope, I need to remove that one actually. There was one that I've been wanting to see. I just gotta. Everybody has to bear with me. If you don't like it, too bad. There was one that. Okay, this one is she's demanding new home. And I don't even know if that's in English. So we're just gonna skip that one.
Let's not do things that are not English, please. That would not be wise.
I don't even remember what that one is. It says it was watched. Did we watch this? Did we see this one? Son refuses to go with mom, runs away during custody exchange.
No.
And okay, because I'm assuming it's that time of the day too, where you rather us do some shorter ones and not the longer ones.
We got lots of time still. It's only 3.
Yeah, 3 hours. Okay, so then maybe I'll look at something longer. Okay, and these are the non-court ones. All right. So I really need to do
non-court ones will be done on another day.
Yeah, I just hostile mother curses out the court and demands.
Okay.
Demands juvie. Daughter is returned to her. And demands juvie. Daughter is returned.
Ooh.
I'm a little confused, but
wait,
strung out. Hold on. Strung out and neglectful mother tries to fool court in desperate bid to get her daughter back. Ooh. No, that sounds like it's gonna be crazy. Okay, we'll do hostile mother curses out. The court demands blah blah blah.
Experience the peace of riding on the advanced tread compound of the Alenza Prestige.
This is a filtered shower head, and these are the filter beads. They remove harmful stuff from your water. But this newly designed shower head also.
I can step away and still hear what's going on. Yeah, but I don't want to pause anything.
Welcome to Looking at Legal Stuff. We have a bit of a wild one today. We have 7 hearings with a father who's trying to establish a parenting plan after his daughter fled her mother's home. Despite having her daughter charged with assault, she demands that the child be returned. When the court doesn't just give her back full custody, she gets more and more hostile, leading to screaming, cursing, and getting muted a lot. We also have 2 bonus hearings from Rebecca's eviction, where she tries to tell the court she's too deaf to hear anything on Zoom. Let's watch.
There's a new update at the end of the video for hearing 7. In addition, hearing 3 is also new.
Oh, and look, y'all. Look, we have Mrs. Baldwin. Yes. Oh, shoot. That's too funny.
All right. Next, I'm going to call Inri Christopher Kodiak and Rebecca Knowles. This is 23-300-33508. And I see you there, sir. And
wait a second.
You can go ahead and unmute. What I don't see,
the thing that's throwing me off here is, first of all, I paused with her looking super scary.
Yeah.
That's very fearful. Like, that's creepy. But she's cussing and screaming in a public iPad room. Really, lady? You are acting a fool in the courthouse? What is wrong with you? All right, I'm sorry.
That sounds awesome.
I just want to see something. Okay, so a hearing was inserted in here. And then there's an update. I was wondering if these had dates. I was looking for a date.
We don't have dates.
So this premiered This was done March 22nd of 2024.
Okay.
So this video is old. I guess for people who may have watched this before, they can just kind of skip ahead. I just kind of wish I knew what year it was. Only because we've kind of gone, we know that with this well, I guess we call it a commissioner, whatever.
Right.
We know already that she's representing people in 2023 and 2024. So just kind of interesting to see that her like doing both roles.
Before we go back, I'm going to do a 3-minute break. I will be right back.
He's forcing me to take a break, y'all. Okay.
Yeah, break time. We'll be right back.
All right, we'll be right back, y'all. I beat him. I made it back before he did. And I come bearing donuts. Ow.
All right, I am back.
I beat you. I went to the bathroom and I got food.
Hey.
And something to drink.
What you got for food?
Looks like today is bagel day.
Bagel
I
day.
apparently
Nice.
I still had 2 mini bagels in the fridge. And I just ate a bagel earlier.
Nice.
So, and I also, so I know you can't see it through the bag, but I got donuts.
Okay.
And I brought some cheese.
Nice.
And I have the butter with me, but I have a refrigerator in here, so I'll just put it in the refrigerator when I'm done.
Nice. Nah, I was just talking with my provider to get things set up for dinner while I was out there.
So that's why he took more than 3 minutes.
Hey, I didn't take that long.
I didn't say you took that long. I said you took more than 3 minutes.
I did say I need a break.
Yes, you said 3 minutes.
Okay, I was gone for how long?
I don't know, but I know whatever I did was more than 3 minutes, so. Well, look, we'll have to visit that at another time. But yeah,
I'm gonna have to go look at the log now, won't I?
I am really wondering how this is gonna go, because I think even the last time when we saw Miss Baldwin in a judge-esque situation, it wasn't toxic.
No.
But this lady's gonna be toxic. So we get to see the judge kind of like be able to react to people that are acting stupid. And they're not, and it not be her, her client's not so better half. So this is gonna be interesting. Are you ready? Are you ready to get rolling? All right. If I can find my mouse. Okay, there we go.
Is any proof of service in this matter? Has this matter been served? Oh, you'll have to unmute. So if you tap your screen, you should have a little old-fashioned microphone come up. Usually it's in the left-hand corner.
Oh, he's so patient.
And same for you, ma'am. There you go. I see you, ma'am. Ma'am, can you tell me your name?
Rebecca Knowles.
Okay, very good. Thank you.
All right, and I see you're unmuted, thank you, and I see you're unmuted as well, sir, thank you. Ma'am, I'm gonna start with him first, and then I'll ask you a couple questions. So sir, I see that you have filed documents, but what I don't see in my file is what's called a proof of service, and that's just a document that lets me know that everything that you filed in this case has been served on Mrs. Knowles. Has that happened?
Yes, it says it's filed in. I got a phone call. I went down there for council stuff like that on Monday, and they said, and they just printed this out. Basically, is what it was. I don't know if she'd been served or anything like that. So
You got paid the.
yeah, I paid the fee and everything else. So I'm not really sure.
Okay, you paid. Hold on, I'll get to you, Ms. Knowles. I promise. So, sir. Oh, I know, I can't hear him very well either. Sir, what I'm going to have you do is I'm going to actually have you turn your video off. Our video takes up a lot of the bandwidth. Perfect. And so I'll probably be able to hear you better now. So I know that you have filed your case. Have you given it to the sheriff or a process server? Okay, so you gave it to the sheriff to have her served. Is that right?
Yes, that's correct.
Okay. Have you received a document back from the sheriff's office that lets you know that that actually happened?
No, we just have the receipt.
No, I just have the receipt.
Okay, all right. Thank you for that information. I'm going to ask Ms. Knowles a couple questions. So Ms. Knowles, thank you for being here today. Have you received a copy of all the documents?
I have received a copy of one document.
Okay, what was the document you received?
It was saying that I have court today.
Okay.
Because he filed for a immediate restraining order ex parte when I tried to file one.
Okay.
An MSC cruise isn't just a vacation, it's a holiday with European style
and American comfort.
Okay, so
I'm sensing she's a tad pissed, but I'm not sure why yet.
Got here this morning, I got this. I paid to get this.
Okay. Just one moment. So here's the way this process works so that you both understand. What I have, well, number one, the way the process works is this isn't a time where people testify and swear in. Everything that I have to consider has to be in written documents that are filed with the court. Those have to be filed usually about a week in advance for them to make it into the computer system. So I don't usually look at actually paper files. I look at electronic files, and there's a little bit of a time lag from the time you drop it off to the time it gets scanned in and makes it into my system. If I was to make decisions today, obviously I don't have any information provided by you, Ms. Knowles, and then it would be, hold on, I'll explain and then I'll give you another chance to talk. Then it would just be a one-sided case, right? Because then I'm basing everything that I'm deciding only on what has been filed. And so far, what's been filed is only by one party. And that certainly wouldn't be fair to only consider one side of the story. The court really wants to listen and understand both sides of the story before I make any orders for children. So what I have is the initial documents that have been filed, but I don't have anything from the other side, which is what I need to make a decision. Okay, Ms. Knowles, go ahead. What do you need to ask?
I would like to know when my daughter's returning because I have a court order from 2014 from Oregon because Chris had stipulations for him to be in his daughter's life, did not do them, and he hasn't been present for.
Do you think she was listening at all? It seems like she couldn't even sit still until she got to go off.
Since 2014.
So this is where I said that this isn't a time where we testify. So you're telling me really potentially critical information, but it has to be written and it has to be filed for me to be able to consider it. So you're sort of saying, well, I want to tell you information and ask the court to make a decision based on that. Hold on, when I'm talking, then you wait and I promise I'll give you another opportunity to talk. So we have to base it on, I have to base my decisions on what's in the court file. And I can only see the things that have already been filed. So you may have important information. I don't know. I just can't see it right now. All right. So with that, does that make sense? Do you understand, ma'am?
Yeah, I understand, but how is it that I have to pay to get my own court paperwork and completely miss court? This is the second court date. I haven't received.
She may have heard the judge, but it seems more like she was just waiting to say the same thing again.
Nothing. Besides trying to find my missing daughter.
Excuse me.
Get her the help that she needs because she has court orders, things that she's supposed to be doing. And
find your missing daughter. What the fuck does that mean?
So here's what we're going to do. Sounds like the sheriff's office has a full set of the paperwork. So you should be, if you're in the courthouse, you should be able to go downstairs and ask them about it. And they should have a full set to be able to provide to you at no cost to you.
So why is it does I still have to be away longer from my daughter because nobody did their job and I'm not getting served no papers? I had to buy papers when I came in this morning.
I understand. I have to base my decision on what's in the court file. I cannot base my decision on things I have not seen or things that you're telling me today. So here's what I'm going to do. In this matter, I'm going to set the matter over 1 week.
School next week.
I understand. I cannot base my decision on things that are not filed and things that I cannot see. So I'm going to set the matter
she's
over
been muted.
1 week. That gives Mr. an opportunity to file proof of service. And that allows you an opportunity to file a response, which is what you need to do so that the court can understand your position and what's happening. All right, I understand. So, sir, you understand that you need to file your proof of service. Ma'am, you'll need to file your materials, and then the court will consider it. It's the same day, it's the same day and time as I'm having a hearing today, so it'll be 9 o'clock next week at the same place, and then we'll have a hearing. I encourage everyone to file anything that they're going to file right away so that it's in the court file to be considered. Okay, so that's my ruling for today.
She's screaming about
raising your hand, ma'am. If you can speak calmly, I'm willing to listen to you. So you'll need to unmute and then you can speak.
She's like screaming at the judge.
My daughter has court-ordered things she's supposed to be doing, and they're withholding her.
Because right now there is a Washington order that dictates where she's going to reside. And I don't have any information that would allow me to make a different order at this time. So that's why. So I have to base the information on what's in the court file right now. So you'll both need to file anything you need over 1 week.
My daughter, because nobody did their job. And
Ma'am, you're done. I've made my decision. The current orders will stay. We're setting the matter over 1 week. I'll see you everyone back here in 1 week.
Don't mess up the iPad in the courtroom.
And I'll sign the orders that you provided, but it's just going to reference that the next hearing is 1 week.
Okay, thank you. I appreciate it.
She's an awesome judge, huh?
Hearing 2.
That takes us to Kudlak and Knowles.
Grip, stability, precision. That's the essence of driving. Lawfin.
We have a pretty small team. There was a lot of room for manual error, which we wanted to mitigate as much as we could.
All right, and I've got you there, sir. I see you there, ma'am. Thank you for being present. Give me just one moment to get that file up.
I can't imagine like being a judge and an attorney at the same time.
I do have an opportunity to read the things that both of you submitted. Thank you. I appreciate that both of you submitted paperwork for the court to review today. That's appreciated, along with some of the sort of historical documents associated with this trial. So I appreciate that. Before we get too far in depth, is it Kudlak? How do you say your name, sir?
Kudlak.
Kudlak. Okay. So where do you reside?
Kelso, Washington, out in Lexington.
Okay. And then I have you, Ms. Knowles. Where do you reside?
Longview, Washington.
Okay.
Well, at least she looked like she calmed down.
Very good. So the way this works is initially, Mr. was the one that filed. And so I'm going to give him an opportunity. I have to choose somebody to go first. That's how I do it. So sir, I'm going to give you the opportunity to explain what you want and why. I do, and based on the materials that you filed. And then ma'am, I'll turn the time to you to have the same opportunity. So go ahead, sir.
I'm just trying to make it to where I'm trying to put her in school and I'm trying to do stuff with her and I don't want her mom to just come up and try to take her. And because she's, she's worried about that. So and she's really stressed out about it. And so I'm just trying to keep her safe and trying to keep her to where she can, know that she's safe and where she's staying.
Okay, anything else?
No, ma'am.
All right, go ahead, ma'am.
Okay, well, first of all, 8 years ago, like the paper that I did in the response, AZA was granted to me because Chris was MIA. There were stipulations that he was supposed to do and never did them. Ended up leaving from a visit. It's been 8 years since he's even tried to do anything. He says something about him being there in 2018. I mean, AZA might have won a weekend, or that's about it. AZA assaulted me. She got in trouble. She got a judge's order. She went to juvie. She got an assault floor. They put it in a deferred disposition. She got court order to do counseling. She got court order to do multiple things that her and I've been doing. She got mad and ran away. She went to
oh my God,
Christopher Kudlachek's. And yeah, I don't let her have social media because she snuck out. She posted half naked pictures of her. She's 12 years old. And him saying that he wants to keep her safe. Where has he been for 8 years? I mean, as you can see, there's numerous stipulations.
There's only way more than anything you have said about Dad so far.
Has not done at all. I mean, 8 years, that's a long time. I'm pretty sure you could get that stuff done when you care for your daughter.
I think she's she's on drugs.
I put into the order, they're giving AZA drugs. There's black and white, her saying she's getting it from her cousin. Don't sit there and roll your eyes. That's not appropriate. I mean, I feel that AZA's not safe where she's at. I mean, it's been 8 years. I called the sheriff. It's not stalking. I'm looking for my missing child. She's still reported missing. Yeah, I called crisis response and had them go out there because just like I put in the response, she's suicidal. She got mad from the judge because she assaulted me and there's actions to her consequences. And she ran away. After she ran away, I found all the steps saying she's going to kill herself. She's taking pills to do this. That's why I called crisis response with her counselor, set that up, and her probation officer and CPS set that up. But it was refused. From Mr. Kudlachek and Connie at 252.
What was refused?
AZA, crisis response was there to transport her for intake.
Okay.
For the suicidal, all the suicide.
And she didn't want the intake you showed up on the doorstep with and probably freaked her out. Oh.
I mean, yeah.
But for someone who's not been around for 8 years, the daughter didn't have no problem running to him.
Little notes and stuff that I put in. He doesn't even know her birthday. If you look at the paper, the order, he put.
I said right now he seems like a real calm guy, but we haven't gotten in very far yet.
We have not. But if we go based on the title, hostile mother curses out the court and demands her juvie daughter is returned to her. If your daughter assaulted you and you had to call the cops on her, is that really safe for both of you?
I'm on drugs.
I don't know.
Me. That's what it tells me.
I think that she's on something. Apparently scratching is like an indication of that, from what I've been told. I could be wrong. Don't hold it against me. But the rapid speaking is concerning.
Yeah.
The constant moving. Like, she's just kind of jittery.
No, that could be ADD too. Not to make any judge. Yeah. Nervousness.
No.
I mean, you would know
But
better.
somebody I think with ADHD they might be fidgety with their hands or their legs, but she's doing like whole body movements.
No, my friend did whole body movements, walking around. He get nervous as shit.
But I think even still, like in someone with ADHD in this type of like setting would, to the best of their ability, practice decorum.
True.
She's not doing that by like her performance in the last case. Like, just because you're on Zoom doesn't mean that you can talk out of turn. If you were physically in the courthouse and you had an outburst, you could be arrested.
Right.
That's how that used to be back in the day. So I don't know why that's why they said they like the mute button. Because she's sitting there screaming at the screen, being disruptive.
Right.
So that's why I'm saying, like, I think she's potentially, like, either under some influence of something, or you would hope that they might test these people to see if they're drunk before they go to court to use the room. Potentially. But I mean, I don't know, right? Who knows? But just compare her to the videos that we've been watching of people having interactions with the cops, right?
Right.
Her behavior is reflective of some of those people.
If you're curious, I've got the VODs, so go check those out. There's a whole lot of stuff there. Go check it out.
Gotta love his plug.
Her birthday in wrong. Her birthday's not January 20th. And this is, 8 years ago. He didn't even put his birthday right on the birth certificate. His own. So that's null and void, because when you search it up, it's not his. And if he wants to talk about that, maybe we should do a DNA test. But I feel under the stipulations, Aza needs to come back. She hasn't been around him. They haven't done anything in 8 years. And it's more him, like with this paper, it's not just his phone number. He has his mom's email. Why isn't it just between him and I? Aza is supposed to start school on Tuesday. She has an intake. She hasn't done any of her counseling for disposition. She has less than 20 days to do what she needs to do, or she will be charged with that assault. And I don't feel it's right for her to run away and not have to do what the judge ordered when she assaulted somebody.
What if you could clean
So
the retainer
you
at
want
the
your
touch of a
child
button?
back
No
so
more
she can
brushing or
be
tablets. Over 4 years ago, our team of engineers
properly charged with assaulting you?
She's supposed to be starting school on Tuesday. It's been almost 2 months. And she's still reported missing, haven't had contact. He wants to put in a restraining order. He also read paperwork from the Oregon judge because he didn't do what he was supposed to do. He's not supposed to be around her. I just feel like, Aza needs to come back home because,
I didn't see what this was.
She starts, hasn't done any for
Sorry.
counseling.
I needed to see what
for
was
disposition.
one up there.
She has less than 20 days to do what she needs to do, or she will be charged with that assault. And I don't feel it's right for her to run away.
It kind of feels like you want her charged. That's what I said, isn't it?
She's supposed to be starting school on Tuesday.
And I said,
it's been almost 2 months, and she's still, she's still reported missing, haven't had contact. He wants to put in a restraining order. He also read paperwork from the Oregon judge because he didn't do what he was supposed to do. He's not supposed to be around her.
Oregon judge. Neither of you are in Oregon. Oh, well, that is a good point. Oh, she wants them to, she was trying to present them with an order from Oregon, but they're in Washington, so I don't know.
And forgive me.
I just feel like,
Sorry, forgive me, but my information, and just me, you can serve that information. Doesn't mean the judge has to follow it, though. From what
I don't know if the order, I'm assuming the order is not even a custody situation. Maybe No, it would have to be. Maybe that order that she's referring to is her custody order from whenever they lived in Oregon, which I think is kind of funny because you both couldn't have moved to Washington together if you had a child support or a child custody thing in another state. Why would you move to the same state? Or maybe she's confused. I don't know. But it sounds like she should be happy that after her daughter assaulted her and ran away, that she at least went to the house of her father and is not in foster care or on the street somewhere. But
True.
That's just me.
Asa needs to come back home because, I mean, I've been her only provider in over 8 years. No outreach. They haven't been to one school thing.
Don't you want her to have a relationship with her father too?
Out of state before? Yes, I have, because I got custody of her back in Oregon, and there was an interstate compact for me to bring her in Washington. I'm sorry, but there's stipulations he was ordered from a judge to do. He decided that Asa wasn't enough for his time for him to take time out of what he was doing the 6 months that it took me to get our daughter back.
He might still be in Oregon.
Doing drugs, doing whatever.
No, he said
And she had
still to this day, court.
No, here's the thing. He might be in Oregon, but because she resides in Washington, he might have had to file in Washington. It's a possibility that happens.
I mean, yeah.
Like you have to I think in certain cases, like you can file in the state of where you live, or you can file, I think, in the state of where the other person resides.
Wasn't there a case we did that with California and
well, that was different because at the time they had a California order because they both resided in California. Then she moved to Kansas, and when she moved to Kansas, then something was brought in Kansas, and the judge was looking over how, like, what they needed to do with the order from California. That's how that situation went. That wasn't a California court. That was a Kansas court.
Right.
That was looking at a California. Yeah, well, the dad still resided in California. It was the mother who had changed location.
True.
So, and I just know from like people that I know, when you know who tried to get her son back, the father filed for custody in his state, not the state that she's in,
right?
Because she didn't have the child in her possession. He did. So it I'm guessing it depends. Well, you know what? We can scrap all that. I just realized the father said he's in Washington. So I think that's interesting that she did a child custody thing in Oregon and then they both end up in Washington. That's kind of weird.
Yeah.
Why did you both move? Who's following who?
Get this order printed out. Oregon still doesn't know where he is. So, and yeah, Asa did. I never put a cigarette out on her face. When she assaulted me, I had a cigarette in her hand, and it got her on the face. And that's what the CPS report says, and also the police report, because they were called in.
Because that's what you told them. Just doesn't make it true just because it's in a police report. This is true.
And, I mean, that's it.
Is she done?
Sir, I'll give you an additional opportunity to respond since she got to listen to sort of what you said and then make her response. I'll give you an opportunity to respond as well. Go ahead, sir.
Yeah, she's not getting any drugs from me or her cousin anywhere around my house. She cannot. I've talked to her CPS worker that's been out to my house. I've talked to her FFT lady that's been out to my house. So I talked to her probation officer. They all say she's happy, she's safe where she is. I don't know what else does, so she's doing what she's supposed to be doing. I was going to put her in school, but I was waiting for what happened today to find out. So, because she's worried about if I put her in school that her mom's going to come take her out of school. And so that's what she's worried about. So I was waiting for her today before I put her in a school.
So it sounds like you've been in contact with her probation officers. Have you been in contact with her?
I have a family therapist out here at my house. I talked to her. I talked to her probation officer.
She's 12 and you and her aren't getting along. Let her live with her dad for a while. Good point.
I've talked to CPS workers out here. I've had sheriffs at my house. I've talked to them. The crisis intervention team, I've talked to them.
Stasher is the reusable food storage that lets you do more. More game days.
Wait, what's reusable?
More of
Ooh.
everything. With less.
Oh, it's kind of like a Ziploc bag.
More light.
Sorry.
Light with less plastic.
Yeah, that's kind of cool.
Help for Aza?
Hold on, one at a time. Go ahead, sir.
And so, yes, Aza's been doing everything she's supposed to be doing. And so, yeah, that's all.
The antics are like.
All right, thank you. I appreciate both of you. I appreciate you both being here. And again, the fact that you're both here is a clear indication that you both care very much about your child, which I appreciate. In this case, first thing we need to do is we need to appoint what's called a guardian ad litem. Guardian ad litem is essentially fancy Latin for court's investigator. People come to court similarly to the two of you, where I don't know either of you personally, which is a good thing in the sense that I'm kind of a neutral decision maker for you both. One side says, the father's terrible. The other side says mother's terrible. And I'm kind of like, well, you were both saying, each other is not a good place for the child. Guardian ad litem's job is to come and meet with all the parties, meet with the child, talk to all the providers, and it sounds like there's quite a few in this case, to give the court sort of a neutral person that is sort of boots on the ground, is what I say, and to get that information. So I am going to do that first and foremost. The clerk's going to give me the next 3 names on the court guardian ad litem list.
That's Twyla Corey, Keith Lawrence, and Heather Kale.
Sir, do you have any preference as to the guardian ad litem?
No, ma'am.
Ma'am, do you have any preferences to the guardian ad litem? Oh, you'll need to unmute.
No, I said a DNA test needs done.
So no, ma'am, that's not appropriate. If he is on the child's birth certificate and the child is 12, that ship has sailed. And the idea, and I'd have serious concerns with a parent who would try to disestablish a parent at age 12.
No, look, put his birth date wrong. Everything's been wrong. This is stuff that he was even ordered by a judge to fix, was never fixed.
It's clear that he is the legal birth father, according to the state of Washington. So we're not doing that. If you want to raise, anyone's free to raise that, but you haven't done that in a motion today, and the clerk's declining any oral motion to do that. That takes us to first name on the list is Ms. Twyla.
Why would you even do that?
Give me just a moment.
You don't know who your kid's father is?
Perhaps you should.
That's an interesting tactic, right? I mean, do you even remember who you slept with 12 years ago?
I mean, I do. I know.
I mean, I do too, but I'm just saying, like.
Not going into that, but yeah.
But to be like, I need a paternity test. What are you saying, lady? How many people did you sleep with? Is there other options, or are you just doing that to drag shit on?
She's trying to drag it out.
Now she's raising her hand. I can't with her. You know what's going through his brain right now? I made a baby.
What I'm doing
with
is I'm
that.
just filling out the guardian ad litem order, just so you both know.
She's scary looking.
Sir, are you currently employed?
No, I have a job waiting for me after all this court stuff is over. I didn't want to lose it while we were doing all this, missing days of work and stuff like that. But yeah, I'm going to be starting.
How much are you going to earn per hour?
$19.75.
Okay. Ma'am, are you currently employed?
No.
No.
Okay.
True.
They're both probably not the best stand-up citizens-ish.
I have a question.
Yeah, just one moment.
She's all over the place. And I don't know, that doesn't look like ADHD fidgeting to me.
It does to me.
So what I have done is I filled out what's called an order appointing the guardian ad litem. I'm appointing Twyla Corey. She's going to investigate all issues regarding establishing a parenting plan for this child. I'm also asking her to look at domestic violence issues, mental health issues, and substance issues as to all of the parties, including the child. I'm going to make her report due in early January with a review of her report January 25th of 2024. So I know that sounds like it's a long way away, but we give our guardian ad litems at least 120 days, and then usually it gives us a little bit more time to be able to talk to all the parties. She'll have to get releases signed, and please be quick on signing any releases. I'll get to you, ma'am, I promise. As you go along to make sure that you're not delaying the report. I'm sure you both would like to have the report issued in a timely manner. Obviously, she can do it sooner, but that is the sort of the deadline that the court establishes to get a report. I've put both of your phone numbers as I have them in the court file in for you to be able, for the guardian ad litem to contact you. But I encourage you both to contact the clerk's office once this hearing is done to obtain Ms. Corey's number and reach out to her directly. Let her know that an order has been entered and give her your information. That will certainly speed the process along and ensure you receive all the documents and materials from her as well. Ma'am, you had a question. Go ahead.
How much you want to bet it is nothing of substance?
Do you know what's really fun? Making a website on with.
Yeah, so I'm concerned about what's her being placed there, like what I submitted. She openly admits that she's getting drugs there at 12 years old. So, I mean, that needs to be taken care of or addressed. Because it's self-messaging, people saying she's getting drugs where she's at right now. She needs to be home.
All right, so I haven't gotten to where the child's going to be placed yet, so I am going to do that next. So at this time, what are we going to do? Obviously, there are concerns. There are concerns both ways. Both parties raised some pretty significant concerns for the child. There's some historic concerns, although I do recognize that those concerns are 7 to 8 years in the past, which is quite a bit of time in the concept of a child's life. You both raise current concerns as well. So obviously there's a long history of concern. At this point, I have child assaulting mom. That's not a good sign. It sounds like child has some mental health struggles. Again, I want to make sure that that gets addressed. She does, sounds like both parents are aware of probation and the diversion program, which I appreciate. Seems like both parents have been pretty cognizant of that and working through that process. So that's good that you're both up to date on that. At this point, though, considering the child's assaultive nature on mom and considering sort of the needs of the child, again, this is a temporary order. It is not a final order. I am going to place child with father at this point. Father is going to be obligated. Your Oregon order dismisses that case, meaning it does not exist. No, when I am talking, you are not talking. I reviewed that.
I saw that on a paper when she was holding it up at the last hearing. Oh yeah, judgment of dismissal. Yeah, nice try, lady.
Your Oregon order dismisses that case. It does not establish a parenting plan. I appreciate that you completed the things that the court obligated you to do 7 years ago or whenever that case started, which would have been further back. But at this point, we're dealing with essentially a tween, and before you were dealing with a young grade school child. A lot has happened between then and now. So my order is a temporary one. It is not a final one.
This is what we're going to do as a Band-Aid until we get to the next step and have a complete guardian ad litem investigation, which is what I am ordering. You both will have the opportunity to talk to the guardian ad litem, and you'll both have the opportunity to present your case at trial. So father's going to be primary. Father is going to establish the child in school in Kelso. So child will need to attend Kelso school. Father's going to need to work with probation and the diversion program on whatever she needs to do to be able to complete the diversion program and work through that process. You need to be good about allowing and informing mother of that process as well. So that means that you can't just cut mother out and act like she doesn't exist. You're going to have to provide her information on that you're essentially.
She should still know the important details concerning her daughter.
Similarly, you're going to need to establish the child, if she's not already, with a mental health provider or to continue her mental health services. So you'll need to do that as well. With the mental health services, again, you need to provide mother with notification of appointments and those types of things so that mother knows and is aware that that process is continuing along and that you're compliant. Does that make sense, sir?
He wasn't compliant, Judge?
No. And we're going to find that out, aren't we? So everybody is definitely under the microscope at this point, meaning that guardian ad litem is going to be checking up on you. The court has a review date.
I hope the father does everything he's supposed to.
On review, it doesn't mean that custody is going to stay how it is right now. The court can 100% change custody, and if you're not compliant, the court will. I need parents who can be on target for their kids and put their kids first, and that means getting them in school, making sure they're there every day, all day. Making sure that they're compliant with mental health. Ma'am, I've given you an opportunity to speak. If you keep interrupting, I'm going to have to remove you, and I don't want to do that. So you're going to have to make sure that she's child's compliant with probation and the diversion program, and provide proof of that compliance. Do you understand, sir?
Yes, ma'am.
Okay.
This is what makes her such a great attorney too.
In a program called Our Family Wizard. If you Google it, Our Family Wizard, you'll be able to find it online. It's an app that you can enroll in or you download to your phone. It's a de minimis cost to you both, but it allows you to communicate with each other through essentially a portal. Well, that'll be your choice, ma'am. Sir, whether or not she complies, I expect you to comply. So you'll need to download Our Family Wizard. You're each going to pay your own fee for that service. And then provide your own fee for that service, and then that's how you'll provide mother with information. So you can use that to download documents and send those to her appointment notifications and those types of things.
Buy a pass to the east.
She is literally giving, like, causing herself problems.
It's starting.
I do want to set up visitation for mother. I am concerned about what that's going to look like.
Huh?
I said, I like.
You're breaking up.
I like the way she presents herself. She gives all the information that you need all at one time. The app, the plan moving forward, this, that, this. She's good.
All right, well, we kind of missed what was said, and so now I'm kind of concerned about this message. So I'm gonna
go back.
I'm gonna rewind. Yeah.
In a program called Our Family Wizard. If you Google it, Our Family Wizard, you'll be able to find it online. It's an app that you can enroll in or you download to your phone. It's a de minimis cost to you both, but it allows you to communicate with each other through essentially a portal. Well, that'll be your choice, ma'am. Sir, whether or not she complies, I expect you to comply. So you'll need to download Our Family Wizard. You're each going to pay your own fee for that service, and then provide your own fee for that service. And then that's how you'll provide mother with information. So you can use that to download documents and send those to her appointment notifications and those types of things. I do want to set up visitation
for a mother, I am concerned about what that's going to look like. Here's what I'm going to do. I am going to.
It better be supervised.
Very much supervised.
I'm going to set visits with the child and mother, and those are going to be every first and third weekend. From
Not
Friday
just crying.
at 5 to Sunday at 5. Weekends are determined by Fridays. I'm going to have the exchanges be at the Kelso Safeway parking lot. Neither parent is to exit their vehicle. This is a 12-year-old. She can transport herself between the cars. So parents don't talk at exchanges. You don't get out of your cars. You don't make it a whole drama. Child exchanges herself. So she goes from your car to Mrs. and then on Sunday, she'll come back in the same fashion. Do you understand, sir?
Yes, ma'am. I had a question. I had a parenting plan, sir, and it's on the 7th of September. What are we doing about that? Is that not?
Is it a proposed parenting plan?
Yes.
7th of September of what was filed?
I filed a parenting plan and evidence and stuff like that. So.
Okay, you filed your proposed parenting plan.
Yes, ma'am.
Okay. I see that. Thank you. I'm not making any findings as to either parent today. So you're asking for a bunch of findings. Those come usually with the final order. So again, either trial, agreement, or default. So I'm not making any of those decisions today. I am going to leave decision-making. I'm going to put decision-making with father at the moment because I don't believe the two of you can jointly decide anything. That's unfortunate, but based on the presentation today, I don't believe anyone can decide that. Yes, ma'am.
The reason why DNA hasn't been brought up is he hasn't been in her life for the past 8 years. It was brought up in Oregon. He never came back and he left. That's why it has not been taken care of.
Okay.
In the birth, it was brought up when she was 4 years old.
Okay. I did that. Okay. At this point, I do have the Stills document listing him as the parent, even if there's some Scrivener's error as to the birth date, that does not invalidate him as a parent. Going back to the parenting plan, so I'm going to have father make decisions, not making any findings to either parent this time. Custodian is father. Talked about visits already. Mother is to have we'll be at Christmas before you're back to review. So I want to show
until her birthday. I can't see my daughter.
So I've never had a child complain about having 2 birthday parties. And so you'll each celebrate child's birthday on her time. On Christmas, ma'am, if you cannot manage yourself, you'll be excused from the hearing.
She doesn't care about her daughter's best interest. She just wants to win by not allowing him any access to the child.
I'm going to order for Christmas, mothers to have the child from 5 p.m. the day school releases until Christmas Eve at 8 p.m. And the fathers to have the child from Christmas Eve at 8 p.m. until school resumes. And then thereafter, the regular schedule recommences. I am going to enter an order that reflects this. You can both get a copy at the clerk's office probably tomorrow. Would be the soonest it'll be available to you. I think that takes care of all of those issues we talked about.
He is flipping the fuck out.
Contact with child. The guardian ad litem is free to bring the matter back at any time if there's an emergency, but I'd like to maintain some contact with the mother. I think that's healthy for the child. I'm not making, sir, are you currently paying child support?
Yep, I'm current.
Okay, so with that is I'm going to suspend your obligation for child support. And that's going to be effective August 31st of this year. So whatever you're obligated to pay, you're still obligated to pay through essentially the close of this month, and then the obligation is suspended. I'm not making any child support orders in this case, other than suspending your obligation because I don't have sufficient financial information to do so. Either of you are free to bring that back for me to address child support at any time or talk to the Division of Child Support. Go ahead, ma'am.
What about my court date on next week?
The court date next week, what is your court date for?
The restraining order, the response to his restraining order?
Okay, I'm not entering a restraining order on either of you at this point. So there was a temporary restraining order entered to ensure sort of compliance between last week and this week. I'm denying all restraining orders as to both parties. But you both have to comply with the court's orders. So if one of you starts not complying, then a restraining order can be appropriate. But at this point, I'm denying all restraining orders that either of you have requested at this time. It seems that the main issue was establishing a parenting plan and that there was a lot of fear about the child being taken from one home to the other. And now that you have a court order, that makes it clear what both of your obligations are and what your visitation or residential time is. All right. So you should be able to get a copy of those orders again tomorrow.
How does she keep raising her hand?
Go ahead.
So these people have not been in her life or anything for 8 years, and you're just saying,
heard you.
Okay.
If the child is assaulting you and having mental health problems, it seems that the child may need a
trouble at
change
school
at
for
this point.
doing sexual.
So at this point, that's my order. You can each get a copy of it at the clerk's office. You'll need to bring cash if you want them to print it. And you can get a copy of that tomorrow is a good time to get a copy of that.
I can't believe she said fuck you again.
So,
I don't think calling the commissioner a bitch is going to convince her that you are the stable voice of reason your child needs. And then she unmuted herself to make sure she said it. I am just...
I can put her in school. I don't got to worry about her coming and taking her from school or anything like that, or?
Correct. You can and should enroll her in school. Please go to Kelso Public Schools and do that today or wherever you reside. The court is going to note for the record that Ms. Knowles was incredibly inappropriate, that she swore and was not able to manage herself appropriately during this process. So her behavior is certainly going to be noted for the court, and you can also let the guardian ad litem know to look at the clerk's minutes.
Is the first noted like, so it's like tomorrow?
On Dad to tell the gal to look at the clerk's notes. Perfect response.
At 5, or like, or like go get that paperwork, and then it'll be on that paperwork.
It'll be on the paperwork. The way you determine what weekend it is by looking at a calendar. So I tell people, look at a calendar like it kind of has the boxes on the bottom and like the puppies and the kitties up top. When you look at that kind of a calendar, look at the Fridays. It's as determined by Fridays. And then the in this case, look for the first and third Fridays. This upcoming weekend won't be a first or third Friday.
Okay, thank you, ma'am. I appreciate it.
Thank you. Best of luck, sir.
All right.
Oh man,
the countdown is on. Your
did we lose? Did we lose Baldwin?
1099s, and your employees?
I think we lost Baldwin.
Let's see, Kudlacek and Knowles.
Yes.
I'm sorry if I didn't
we
say
like
that
her
name correctly. 2330033508.
It doesn't take.
Okay, wait. I didn't have a copy of this hearing until just recently, so it's missing from earlier versions of this case's videos. I can't wait to see what happened.
We have Rebecca Knowles.
They weren't supposed to be back until January. It only took a month to return.
I think in the Zoom booth we have Mr. Am I saying your last name correctly?
Yes, it's Kudlacek.
Kudlacek. Okay, thank you. All right, so we were here on the 24th, and Ms. Knowles was present, it looks like, on that date. And the court ruled, and Mr. Kudlacek was to prepare the orders. I have looked through these. I don't know, Ms. Corey, are you on this case, Ms. Corey?
Yes, I am.
Did you see a copy of the proposed orders?
I did not.
Okay. All right, so here's, I'm gonna go through and let's make sure, let's see. Our family wizard is ordered for any.
What?
Said I think he hired an attorney.
Who hired an attorney?
The dad.
No, he's in the court. He's in the courthouse.
Yeah, but the lady down, Corey, is speaking.
No, she's a guardian ad litem.
Oh.
Communication. Sorry, since I didn't do the order, I'm just making sure that everything that's in the minutes is what we have reflected in the order here.
I had a question. My ex had her first visit on Friday, the first Friday of every month. I sent my daughter over there, and at 5, like we were supposed to, and then my daughter, I had to call the cops to go check on my daughter, and then they had me come pick her up and bring her home. Do I send her back on the 3rd weekend? I don't want to break my parenting plan or mess it up or get in trouble. Do I send her back over there? Because her stepdad kicked her out and her mom was screaming and hollering at her, so I don't know what to do.
No.
So
the judge's best efforts, right?
Explain to me a little bit more. If what time was the visitation supposed to be? From 5 to what?
She was supposed to go over there at 5 o'clock on Friday, and she since there was no school on Monday, so she wasn't supposed to. She was supposed to come back on Sunday, but since there was no school, it attached to her weekend. That's what I read. That's what I'm assuming. So I was gonna have her come back at 5 o'clock on Monday. And she went. I dropped her off at 5 o'clock on Friday, and like 6 or 6:30 on Friday, she had called me and said, "Call the cops." My daughter. And so I talked to the cop over the phone. They didn't wait for me to get there, but they told me to come get her. So I went and picked her up and brought her home.
So she didn't even have a visit, which is why the mother's not there.
Do you have any? I see that there was a lot of findings that the court made last week. Any insight onto? Because that's clearly concerning.
I do not. I don't believe I was present last week during the appointment.
Right, it's only been a week.
Oh, you just were appointed last week. Sorry.
Right.
Yeah, I just finished my intake papers and just sent them back to her. Like we just started.
Good job, Dad. Good job.
I just didn't want to break my parenting plan or mess nothing up or get in trouble in any way. So I was just trying, I called the church, I called the sheriff's department, and they said it was up to my discretion, but I have to.
I mean, he's not, well, I think what he was starting was not complicated. I think things are going to get a little bit complicated, but it's good to see that he's following, what he's supposed to do. Unlike that other case we saw with the stepdad, where he just stopped complying with stuff, which, I mean, he got exhausted, but the judge tried to give her a chance, and it only lasted an hour and a half. That child was there for an hour and a half before shit hit the fan, and that's scary. That's super scary.
It's not hard. I don't understand.
But we already know the mom is upset about everything.
True.
And even though she wants her daughter with her, there's some resentment and hatred towards her daughter. Because if you haven't seen your daughter in a couple of months and she's now legally being forced to come back home, and you immediately start in on her, like, it shouldn't have started that way. I mean, at least wait until Saturday to get in a fight, right?
Be able to prove or explain myself why I didn't send her back over there. You know what I mean? So.
And I think we're having this hearing because of the guardian ad litem, I'm assuming.
Yeah.
The concerns.
And I got her glasses, I got her dentist appointment, and I got her in school. She's in school today. So
that's good.
I was a little worried. Yeah, he was gonna fall short.
I don't think
so. Huh?
I don't think so.
No, I was worried that he might.
Oh, yeah. I was worried that he might, based on a misunderstanding, maybe, but.
When I missed 3 new holiday movies because of cookie decorating duty, I didn't get mad. I got friendly.
I think when you have parties that may not be as educated or, well-rounded in certain areas, and just the fact that some of these things that they're about to be asked to do are daunting. They're tasks, like a lot of tasks that they have to complete, things that they're going to be responsible for. People sometimes lose interest, or they start creating boundaries for themselves and making things difficult. So that's what I meant. Like, not that I didn't think he was going to be capable, but
that's what I was worried about, though. To be perfectly honest with you, I was thinking that he might be misunderstanding what he needs to do.
Yeah, we've been hearing his mom in the background answering questions for him, so he's at least got somebody there.
Yeah.
Trying to nudge him in the right direction, but.
And the mom's not really guiding him either.
No, she's answering questions.
Yeah.
Like, he's being asked stuff and the mother's answering in the background.
Yeah.
That's guiding. It doesn't matter. He has someone helping him. So maybe that'll keep, things the way that they're supposed to be.
True.
Not quite sure why he's in the booth today. Maybe he went up to the court to pick up the paperwork.
Nah, maybe.
All right, let's get to it.
Or Mama wasn't home.
All right, and did you get her enrolled in?
Yeah, she goes, and she's at school right now.
Perfect. Okay.
Now she's being nosy.
Okay, so it looks like it was, so my notes, and obviously I wasn't at the hearing last week either. It looks like Commissioner Baldwin ruled that, looks like Miss Knowles was kind of left the hearing abruptly after kind of an outburst. She ordered that the child be enrolled in Kelso, that our family wizard be utilized for any communication. Exchange at the Kelso's parking lot, Kelso Safeway parking lot, excuse me. Neither parent get out of the car. The restraining order was denied.
Yeah. And she put on a temporary parenting plan, is what she did.
Made some decisions about the child's birthday, Christmas break.
What's on my phone?
Don't know.
Okay, so this proposed plan says that she just is to not have any contact with the children, so. Looks like you probably wrote this plan before the order was entered last week, or the oral ruling was made last week, so.
I'm okay with first and third as long as she's safe and she can, you know, and she's able to be over there. I'm okay with that, you know.
All right. So the third weekend, well, what's confusing is it says this upcoming weekend will not be a first or third weekend. So that doesn't make much sense. That's in the notes.
She's just letting
would be the first or third. Since Friday was the first of the month. So
that was on the 24th, those.
That was on the 24th. So she, on the 1st is when you took her. Thank you, Miss Corey. I was thinking it was the last week, the 31st. The 1st she went over and you got her back.
Wow, they're having audio issues.
Well, the next weekend then would be the 15th. And I guess I'm going to need to. Here's what I'm going to do.
Oh my God.
A new temporary family law order and a new parenting plan that complies with the rulings made by Commissioner Baldwin on the 20th. This was submitted in that matched up to what so I'll ensure that those orders are entered. That will mean tomorrow at the latest. You should be able to come to the courthouse, second floor, go to the Superior Court Clerk's office and get a copy of those orders. Okay. And I appreciate that you've gotten your GAL stuff done. And I'm assuming, I don't know that, hold on a second.
Why is this woman still getting visitation if there was an issue?
It looks like Commissioner Baldwin was more proactive than I anticipated. And I'm scrolling through here and it appears as though she did enter a temporary parenting plan already. She drafted one. So I'm going to set your stuff away. Okay, you have that. It's the temporary parenting plan. It's not temporary orders, it's temporary parenting plan. So I will do, and she also did an order appointing the guardian ad litem, Ms. Corey. So that's already been done as well. And it looks like that's all county pay. And then let me see here. I don't know why are we on today? It says we're on for temporary orders, but a ruling was already made. I'm sorry. I sound like this is super confusing, but everything was already entered. So I don't know. And Ms. Knowles not being here today is a little concerning. I'm gonna recycle and shred your orders that you proposed because we already got new ones entered. Next weekend would be Mom's Weekend. Obviously, it's your child's safety is first and foremost. You need to abide by the parenting plan, but obviously if there's safety concerns, for you moving forward. So I'm glad you got your paperwork filled out. The next review date that I show for this case,
oh my God, the glitch.
The 25th of January, 2020. Obviously you can bring it back prior to that. And like I said, I would utilize Ms. Corey as a resource for any concerns. You understand the information she's trying to gather. So I think we're good until then, unless another issue arises, and then you can note it back up.
Okay.
All right. Sorry for the. It took us a long time to get back to where we started from, but
I'm trying to see my pants. I don't even know what I'm doing half the time. So.
That's okay. I appreciate that. So, Mr. Kudlacek, good luck. Thank you for being here, Ms. Corey, and we'll see you back in January. Sure.
I can ask Twyla Corey or any concerns or anything that comes up.
She can't give you any legal advice, but if there's certain concerns about things, I think she'll be happy to answer if she can. And
It was very interesting to see this missing piece of the story. Miss Corey has no idea what she's in for.
she'll be happy to tell you that that's something that she can't answer if it's something that she can't answer. Okay? All right, good luck. Thank you. All right, Lovato and Lovato.
Yes, sir.
Christopher Kudlasik and Rebecca Knowles.
Motion from the gal. Uh-oh.
Introducing the only prescription hair regrowth
Once again, we didn't make it to January.
Formulated by dermatologists, this
and that means the gal has a concern.
Twyla Corey, guardian ad litem.
Mom is already acting disrespectful. She's rolling her eyes at the mention of Miss Corey's name.
Oh, and no Chris.
Miss Corey?
My guess, she's pissed about whatever this motion the gal has brought to before the court.
On your request, anything you want to tell
Yes.
me? What's the game?
Not everybody's here.
Yes, they are.
This cup, oh, sorry. A lot of things fast approaching. Uh-oh.
Twyla Corey, guardian ad litem.
Sorry about that.
Oh, and no Chris.
All right.
I'm about to give him a minute,
Miss Corey,
lady.
this is on your request. Anything you want to tell
Yes.
me? What's contained in that?
This couple wasn't due to return to court until next month, but I told you I thought they would return early.
Right?
Not everybody's here.
Yes, they are.
Go ahead.
This poor lady.
So, weekend before last, I believe.
That's wrong. It's 4 weekends ago, a month ago.
Ma'am, that's the last time you're going to interrupt. You understand? Go ahead, Miss Corey.
Thank you. So the child, Aza, went to her mother's new residence in Kalama. There was a physical altercation. Police were called, I believe. You have that narrative from the police report. This is at least the third time that there has been a physical altercation between the two with the police called out. So I have one in police report from February of this year, June of this year, and this most recent one in November. I believe that this has become a situation that the child cannot escape from. She cannot heal from until she has some distance from her mother. She is afraid of her mother.
I would be terrified if this woman was my mother. She's violent and unpredictable.
Yeah. Exactly.
The mother's home has been unstable and volatile in recent days, and I believe that it's my responsibility to ask the court to keep this child safe and ask that she have supervised visits.
Is a giant 3 tattoo on her neck new?
Mother
No, she had that
get a
before.
domestic violence evaluation, a psychological evaluation, and I believe a immediate hair follicle test.
Didn't I tell you I think she's on something?
All right. Miss Knowles, I need you to unmute that microphone now. All right, what do you want to tell me now? What do you want to tell me?
Yeah, my daughter has assaulted me because she's asked to do stuff. She's put her hands on me multiple times. I've pressed charges.
Yeah, that's what happened. It must be so hard to always be the victim.
It's gotten to that point, and I'm not going to do supervised visits or anything because it's ridiculous. My daughter and I just had a perfect weekend this past weekend. The weekend before that, she didn't want to take her dog out to the bathroom, so she shoved me down the stairs.
I don't believe anything she says about her daughter being the aggressor. This woman's hostile and violent nature screams out at you, right down to her tone of voice.
I mean, yeah, it does. It really does. Even her gestures are threatening.
Her face is threatening.
It's not the first time. She's on a deferred disposition right now for assaulting me.
So your position is you won't do any kind of supervised visits?
Do what? I can't hear you.
Is your position that you won't do supervised visits with her?
I'm not paying to do supervised visits when I had my daughter for 8 years and that she runs away because she gets in trouble.
She'd have to spend her money on visitation. I think she'd rather spend her money on drugs and new tattoos.
For assaulting me, and then she gets told she can stay where she's at. For assaulting There's no reason. Me, and then she gets told she can stay where she's at.
And
There's
what's
no reason, and then she gets told she can
today's
stay where she's at.
and going to look like?
Clean.
Okay. Mr. Kudlasik, anything you want to say?
No, sir. I'm kind of the same position as Twilight Corey is.
All right. Well, given Ms. Corey's concerns, what's going on, and Ms. Kudlasik or Ms. Knowles' presentation today, I'm going to suspend visits at this.
Her presentation today. You mean the over-the-top hostility that makes you think she's actively using?
Knowles, you are to take a UA today.
What did she think was going to happen?
Apparently, she's going away. So.
Oh no,
I'm right here. My son's underneath me.
You're to take.
Oh, she has another kid? Lord have mercy. When you act so disrespectful while telling the judge that everything is the child's fault, the judge knows you're full of crap. She said her son is underneath her. Does that mean that, another child might need to be taken away? Ouch.
A UA today, get those results to Miss Corey immediately.
What about me finding drugs in my daughter's purse this weekend on visit? Aza needs a UA.
Are you hearing?
Aza needs a UA.
You're going to take a UA today, make sure Miss Corey gets the results. And
what about me finding drugs and drug paraphernalia in her belongings on my visit this weekend?
I'm concerned about the adults today and those who hopefully act like adults. I'm less concerned about you.
And I'm concerned about the 12-year-old that has drugs at my house.
Okay, I would be too. I'd probably be approaching it different than you're trying to right now too.
Yeah, I didn't get anything. You didn't send me a message or nothing like that. You found anything on her, so.
No, I filed a contempt.
Okay, all right. I'm not going to listen to you two argue with each other.
I feel sorry for this guy for ever having to deal with this unhinged person as a partner.
You can do that on your own time.
Okay, well, I'm not paying for anything. I literally have surgery in an hour for my arm.
Okay, so yeah, if you don't pay for it, then it's not going to happen, and we won't have to change too much. We'll put it on to December 20th.
I want a UA for Chris.
We're going to put it on for December 28th, Miss Corey. If you don't have a UA and some cooperation from Miss Knowles, you won't have to do too much. That will be all.
Thank you, sir.
Thanks for your time.
You gotta love these Washington judges are like take no shit. Oh man, I don't like this guy that much.
This guy I haven't seen very much.
We've seen him a couple of times, but it looks like the December thing
and Rebecca Knowles
was put over.
This is cause number 23-33508. Christopher Kudlicek, are you on the line?
Wait, hold on. What did that say? I'm so sorry. I missed it.
This is cause number 23-33508.
Motion from Get. Oh, Lord have mercy.
Christopher Kudlicek, are you on the line?
So this must be new, or?
Yes, sir.
Okay, welcome, Mr. Kudlicek.
He's too
and Ms. Knowles, are you
soft-spoken.
on the line today?
Yes, sir.
Okay, welcome to you. And I see that Ms. Corey is present.
There was no stream on the 20th, so I don't know if they had a hearing or not. But if they did, we're back the following
request
week
for a
or something.
change. And so I'll hear from, I believe, Mr. Kudlicek's motion.
It was actually my motion, Your Honor.
Thanks, Ms. Corey. We'll hear from you first then.
In the last visit with the child and Ms. Knowles, there was a physical altercation and an assault. Still unclear whether that's being moved forward with charges or not. However, I have at least 3 police reports where different officers have been called out for physical altercations between Ms. Knowles and the child. And most recently, Judge Warning ordered a UA for Ms. Knowles, which came back positive for marijuana, methamphetamine, and amphetamine use.
Didn't I call it? The scratching. Somebody told me that people that are like that, a person that's like on something, they scratch a lot and like itch themselves or whatever.
Yeah.
And so that would explain the fidget, the constant moving and like her behavior.
Yeah.
And my ask at the time was for this to go to some sort of supervised visitation, which Ms. Knowles disagreed with and refused to do. So Judge Warning then cut visitation for the time being, which is where we're at now. I still believe that supervised visitation is going to be the safest for the child at this point. And I also believe that Ms. Knowles should get a substance abuse evaluation.
All right, thank you, Ms. Corey. We'll hear from Mr. Kulicek and then Ms. Knowles, please.
Yeah, I believe supervised visits will probably be the best way to do it, just for the fact that they seem to not have, they seem to can't get along very well. And I tried to talk to her why, and she doesn't really want to, well, my daughter doesn't really want to talk to me why. She just kind of keeps to herself when it comes to her and her mom, which is kind of okay, but I just want them to be able to be able to send her down there and not have to worry about if the cops are going to get called or, if there's something's going to happen to her, you know what I mean? Other than that, I have no issues with anything like that.
Thank you.
Dad makes a valid point. I mean,
at this point, she's like being forced to go to a home that that's toxic.
Yeah.
But, he's doing it because, in a sense, he doesn't want her to say that, oh, he hasn't given me my child back.
Right.
And then the cops get there and it becomes this whole thing and emotions and, craziness, unnecessary craziness.
Ms. Knowles?
Yeah, I want my visits back, and it's not me assaulting my child. It's Aza assaulting me. The first time, she gave me a black eye ring.
See, Ms. Knowles, it looks like your audio kicked off or stopped.
In the face.
So, Ms. Knowles, go ahead and start again.
I didn't hear you. What?
Your audio cut out, and so I wasn't able to hear what you were saying, so I was inviting you to start again.
Oh, sorry. No, what I'm saying is that it's not me assaulting Aza. It's Aza assaulting me. The first time she gave me a black eye, she ran away. This last time she shoved me down 27 stairs and she punched her little brother in the face because she was asked to take her dogs out. She's been being aggressive. I've reached out to try to get her help with her aggression for over a year. That's why she's on a deferred disposition from her first assault when she assaulted me in June. I don't agree with having supervised visits because I don't have the money to pay for supervised visits. It's Aza getting mad and her being told that she can use her safety plan, and if she doesn't want to do something at my house, that's what she says. She's using her safety plan and she turns aggressive each time she has. And I also don't agree with our court being posted on Facebook, and in our court order it says that Chris is not supposed to be speaking with Aza about the court case when he's showing her videos and she's messaging me, telling me that Chris is showing her videos of our court.
Designed with water repellent and insulated technology for both fan and player. The new era NFL sideline.
We assuming the kid can't look it up herself?
I mean,
I didn't know those were on there. I was showing those the other day.
Stop doing what the judge said not to.
So I invite the parties not to crosstalk, just speak directly to me. And so Knowles, you have the floor.
Well, I do not agree with someone leaking. I don't know who it is because I've filed paperwork. Someone has leaked this whole court case on TikTok, and Chris is showing our daughter. And I have the messages from her about what he's saying, and it's not okay. When he is fighting against it, he's putting that barrier, saying, oh, your mom's doing this, your mom's doing this. When I'm not, when it's getting posted online, I don't even social media. And just the fact that this all started because Aza assaulted me and the judge told her that she needed to she got consequences to her actions and she didn't want to do it and she ran away. And this is how this all started, from her putting her hands on me and going to jail.
All right, thank you. So here there's concerns related to the visitation and the time that mother and daughter have together that has resulted in at least 3 police contacts. Certainly it takes 2 to tango. One is an adult, one is a child. So there's a responsibility. So Ms. Knowles, I'm giving my ruling and I encourage you not to crosstalk each other and I encourage you not to crosstalk me. Is that understood?
Yes, sir.
Thanks. So with an adult, there's a greater responsibility to safeguard and promote relationships and protect the child. And I tend to find that illicit substances and mind-altering substances diminish an adult's ability to care for a child and work through relationship difficulties. I find also that when persons are spending money on illicit substances or mind-altering substances, those monies could have been spent elsewhere. For example, on supervised visitation.
Oh,
so I think here that there's significant enough concern related to the physical safety of the daughter, combined with information that there's the window was potentially screwed shut, so she couldn't get out. And I can understand why a parent might do that, but certainly that raises a safety concern if there were to be a fire or a need to get out of the house quickly.
CBS saw it.
So Ms. Knowles, do you remember what we talked about before and that you agreed to and that you said you understood that you wouldn't interrupt and crosstalk?
Yes, sir.
So sometimes if you can't remember that, just hit mute and then I won't have to hear you when you're interrupting me as I've instructed you not to do. So there's an indication also that Ms. Knowles' significant other potentially has a substance use disorder or addiction that's active and not treated currently. So I am going to grant the motion related to the professional visitation professional supervision of visits for Ms. Knowles. So that'll occur 1 time per week, up to 2 hours. Ms. Knowles will be responsible for paying that. Video visits can occur 1 time a week, separate from that, up to 30 minutes. If the parties can't agree, that'll be at a Wednesday at 7 p.m. for the video visit and up to 30 minutes. And that Ms. Knowles will need to get a mental health evaluation with a parental risk assessment and also get a domestic violence evaluation. If there's any recommended treatment, fulfill and complete that treatment. So that will be the court's order. Any questions?
No, Your Honor.
Ms. Knowles, any questions?
Yes, what can I do about my court being posted online about him going against the order, telling Aza all this court stuff?
Yeah, that's concerning, Ms. Knowles. I agree with you. It's very concerning that obviously involving a child in the court proceedings is not healthy for the child because there's an alliance that they feel toward each parent. So encourage the parties to not expose the child to the court proceedings and let the adults deal with it. So that'll be Wednesdays, supervised visits, 1 time a week, up to 2 hours. And that's effective immediately. And then the domestic violence evaluation and then a mental health evaluation required for mother.
So chat, how's everybody doing? Oh, you want to see a day in my life? Say less. Let's go.
All right.
Your Honor.
Yes.
Sorry, I apologize. Did you intend to include a substance use evaluation also?
And if I failed to state that, that's, definitely. So in addition, Ms. Knowles will need to get a substance use disorder evaluation, follow up with any recommended treatment. Those things, those evaluations.
That dude looks like a zombie.
To expanding your visitation time with your daughter. I'll conclude today's hearing. I'll draft.
I have a question, Your Honor.
Oh, that looks so creepy.
Mr. Kudlicek, you had a question, then we'll hear from Ms. Knowles.
Yes, is there what time on Wednesday do we do visitations and like where at and anything like that?
So Wednesday, it'll be via video visits. So FaceTime or other means. So, and then the supervised visits will need to be professionally supervised, and the professional supervisor can help establish that.
Okay.
All right, that'll conclude the hearing. Thank you.
Thanks, sir.
You just said.
Oh, Ms. Knowles, I forgot you had a question or you wanted to say something. Go ahead.
Yes, like, how do I, can you repeat what you said needs to be done, and what is our next court date next month? Is that what's going on? Like,
Sure, I can definitely repeat that for you. So,
and I'd also like if I can get the school information, like I was supposed to be told, and I still haven't been told nothing for school.
So related to your first request, you'll need to get a substance use disorder evaluation and do any recommended treatment. You'll need to get a mental health evaluation with a parenting risk assessment included. You'll need to get a domestic violence evaluation and follow up with any recommended treatment. You'll have professionally supervised visitation one time a week for up to 2 hours. If the parties can't agree on a date and time, Saturday at noon. And then there'll be a video visit during the week, midweek, for 30 minutes. And if the parties can't agree, it'll be Wednesday at 7 p.m.
Okay, so all this, the stuff that you just said that I had to do, Chris was also judged or ordered by judge to do this and was never done too. So can we get that done going for him as well too? Because Oregon, the state of Oregon, put all that same exact stuff in for him when we had our case back then, and it was not done.
Okay. So my focus today is on the current order. Other issues such as that, it would need to be the subject of a further motion. So that'll be the conclusion of today's hearing. Thank you.
Your Honor.
Yes.
I apologize again. So my final review is supposed to be the 25th of this month with these orders that you've asked of Ms. Knowles. Would you like to push that out?
No.
I don't see any reason to hold a hearing that's so close in time to today's hearing, because if Ms. Knowles gets an evaluation set up within the next week or so, generally those evaluations are not turned around in a single week. So if the hearing is set for that future date, you said, what date did you say?
Actually, the final GAL review is supposed to be the 25th of January. Oh, excuse me, the 24th.
24th. Okay. So we're about 3 weeks out from that date. And I don't think it's reasonable to have a hearing on that date with
I do. I would like to see my daughter for her birthday.
Well, the issue is we're talking about the next court date. So I'm going to strike the 24th and let's move that out a month. So we'll move it out to February 28th at 9 o'clock in the morning. We'll make sure that works for everybody. February 28th at 9 a.m.
Yes, sir.
Yes.
Okay, what about Chris?
Will that work for you? Ms. Knowles, February 28th, will that work for you?
I'm looking at a calendar right now.
Okay.
Sounds like she's banging shit instead.
Wednesday at 9 a.m. Okay, so I heard an affirmative that will work. And Ms. Corey, does that work for you?
Yes.
Okay, we'll see everybody on February 28th. Thank you for raising that issue.
All right, thank you, Your Honor.
All right,
Thank you, Your Honor.
Chloe Fisher and Sean Fisher is on today for.
Oh man. I was kind of hoping it would like go back to the other like.
Next, I have the matter of Christopher Kudlicek and Rebecca Knowles, cause number 23-33508. I see Ms. Corey is present, guardian ad litem. Mr. Kudlicek, are you on the line?
Yes.
Okay, welcome to you, sir. And Ms. Knowles, are you on the line?
Yes.
Okay, welcome to you, Ms. Knowles. We're here today for a review. So this is, I didn't see any updates filed by Ms. Corey. So let me just maybe start with Ms. Corey and tell me where we're at.
Thank you, Your Honor. I've had some difficulty in this case being in contact with Ms. Knowles. I have tried very hard to reach her, and she hasn't responded or has responded in a way that's very difficult to understand. I was hoping that to hear that she had complied with some of the orders from the last hearing and be able to include those things in my report. I received no response back from her. And I do have some newer information that I wanted to include in my report, and would like to respectfully ask for a 2 to 3 more weeks on this.
I need her to like to stop making like noise intentionally, because you know that's intentional.
Okay. All right. Thank you. Let me touch base with Ms. Knowles. Ms. Knowles, it looks like on January 3rd, the court ordered you to get several evaluations, including domestic violence, mental health, and substance use disorder. Where do you stand with that order?
My doctor has put in a referral, and I had one last week, and I'm waiting for the rest. I haven't reached out because I have no working phone. I work graveyards, and my life's, I reached the people for supervised visits. No one has reached back to me. Asa doesn't answer me. I mean, I'm doing what it's asked, but I'm still, it's a battle still.
Which evaluation did you complete?
I think the domestic violence or substance. I can't exactly remember which one it is. Once I hope I can email you or let Ms. Corey know, because I'm currently not at home.
Okay. And as far as the mental health evaluation with the parental risk assessment, where do you stand on that?
I'm just waiting for my appointment.
Okay. When's that set for?
I think it's the 17th of March.
Okay. And then the other evaluation, the SUD, substance use disorder?
I think I did 2 and 1. That one might have been completed as well.
Okay. And have you received any the results of those evaluations with any recommendations?
No, I haven't received no paperwork or anything yet.
Okay. All right. Thank you. Okay. So Ms. Corey had indicated that she has some new information that she'd like the case continued for roughly 2 to 3 weeks so that she can update the court with new information that she has. Mr. Kudlicek, do you have any input at this point?
No, Your Honor.
Okay. All right. Thank you. Ms. Knowles, any further input as far as the request from Ms. Corey to continue the matter 2 to 3 weeks so she can submit a report and everybody can look at it and talk about it?
I mean, I have no issue, but I would like to get my visits.
Okay. Yeah, the residential time from the court order of January 3rd, Ms. Knowles has 2 hours for 1 time a week, and that's supervised, and also a midweek video visit for 30 minutes. So if you're having difficulty with the supervisor, I would encourage you to contact them again and maybe touch base with Ms. Corey. She may have some suggestions on how to better get that going.
He doesn't want to talk to the guardian ad litem.
So with that said, let's come back.
That's pretty obvious.
March 20th, we'll come back to review specifically the guardian ad litem updated information report.
Well, while we're all here, can Ms. Corey give me the information as well for a supervised visit center that she knows? Because I've contacted one in Kalama, one in Woodland, and one in Kelso, but no one has reached back to me.
Yeah, I'll encourage the parties, you can communicate offline, once we're not.
Didn't you say you didn't have a
So the parties
working
can certainly
phone?
Do that. So we'll come back on March 20th, and hopefully Ms. Knowles can get those visits arranged so she can have a residential time with the child.
So will I be having my visits on Wednesday and the weekend?
The court order is from January 3rd, says 2 hours for one time a week supervised, and then a midweek video call for 30 minutes.
Well, is there any possibility to change that so she can go, like, have visitation with her brother as well?
So if you want to change a residential time order, you'd need to bring a motion and write it and submit it, and then Mr. Kudlicek would have an opportunity to respond to it, and then we'd have a hearing on it. So if you want to change that order, certainly you could bring a motion to change that, but you'd have to first file the motion, then serve a copy to Mr. Kudlicek.
Why can't her son see his sister on her 2-hour visitation?
So we'll be back on March 20th at 9 a.m.
Thank you.
That'll conclude the hearing. Thank you.
At least she's sober today, maybe. Or was sober that day.
Next, I'd like to call, if we could, please, the Christopher Kudlicek and Rebecca Knowles matter.
He is wearing
Christopher Kudlicek is on the line.
a bow tie.
Yes. Yes, Your Honor.
Good morning. And Rebecca Knowles, are you on the line?
Yes, Your Honor.
At least she shows up.
And I see that Ms. Corey is on the line also.
Yes, Your Honor.
Great. So we're here today related to the guardian ad litem report. I read that and reviewed that. I'll double check to see. Did you receive a copy of that?
Yes, Your Honor.
Okay, very good. And Ms. Knowles, did you receive a copy of the guardian ad litem report?
Yes, sir.
Okay. I'll hear from Ms. Corey if you have any highlights that you'd like to address about your report, and then I'll hear from the parties.
I don't believe I have anything additional to my report.
Hair regrowth has never looked like this before. Meet the Minoxidil plus Biotin gummy from Hers.
I feel like she's a minimalist. She doesn't really want to talk.
At this time, Isa seems to be quite comfortable with her dad right now. I am asking that the court require maybe some family counseling for them as they settle into this new routine.
So when you say family counseling, is that different than the recommendation for the father to get counseling, the reconciliation counseling, or is that the reconciliation?
So I would see this going as dad and Isa participating in family counseling to build their relationship, and later on, mom participating with Isa doing the reconciliation counseling.
Okay.
Does that make
I
sense?
think so. I think what you're saying is that for father, your recommendation is for father to have counseling in support of the child, and then as the child is being guided through that reconciliation process, to bring mother in, and then have the therapist. Okay, why don't you explain it a little better for me?
So I see those as two different things. Okay. So Isa is integrating into her father's family right now. And it's been a little bumpy for her and for dad, because dad has not been a full-time parent for some time. So I think it would benefit both of them to get some family counseling around those issues. And then when mom is ready to have visitation reintegrated, then I believe, because of the violence in the past and the history between mom and daughter, that reconciliation counseling is going to be really a must for those two. So two separate things.
Much more clear. Thank you for the explanation. Okay, I'll hear from Mr. Kudlicek as the petitioner. Now, anything you'd like me to know about your thoughts related to the guardian ad litem recommendations in the parenting plan?
No, Your Honor.
Okay, all right, thank you. Ms. Knowles, anything you'd like me to be aware of or know or related to?
Yes, Your Honor. So everything that Twyla put in the report that Chris is doing such a good job, that is stuff that I already had Aza in, the counseling, the everything. Aza never missed a day of school when she was with me. She's gotten suspended, expelled for drug use, for fighting. I mean, this is stuff that I was concerned about from the beginning, and I brought it up to everybody's attention. And I mean, she got expelled for doing drugs, Your Honor, at school.
But you're the drug user.
As well as they're saying, Twyla's saying the physical assault. My daughter was arrested and charged on December 22nd.
Nothing about that doesn't change the fact that you have been repeatedly violent towards her. My whole thing is, you're the one who's testing positive for drugs.
Yeah.
So, what is the surprise if your child is susceptible to being on drugs too?
Yeah, possible.
And she keeps bringing it up, and they keep telling her that there's like a right way to bring up that concern. You know that she's said something to the gal, and the gal hasn't done anything. So, I mean, what's the problem?
Right.
The gal, that's what the gal is there for. If she's not seeing that there's any issue, then it's what's coming one-sided. It's coming from one person.
Right.
For shoving me down the stairs and assaulting me.
Nobody cares if your daughter beat you up.
It is what it is.
I don't know if she should be bragging about or talking about how much her daughter beats her up.
No, sir, I still have not got, I've been calling the places for the supervised visits. I'm getting no reach back. I've asked for information. I haven't received it yet, so.
Okay. Thank you. All right, so I appreciate the input from all of the parties. I appreciate Ms. Corey's input in her written report. So this case is challenging in that there's been physical violence and there's been runaways and the like, and where the child is struggling and is now living at dad's house primarily. And
he looks like Bill Nye, the science guy.
As he's learning how to parent a child after a long absence, and so taking that into consideration and the review of the file, we've addressed this case a number of times. I will nominate the father as the primary custodian of the child. The mother has indicated, she mentioned that she's been having some difficulty getting in contact with the supervisor. That professional supervisor is required, and that can be up to 2 hours per week. Video visits are allowed at reasonable times and reasonable duration, and mom will be in charge of initiating that video call. Ms. Knowles will need to get a domestic violence evaluation and a substance use disorder evaluation and a mental health evaluation, and then submit those evaluations under seal to the court and provide copies.
I'm sure she's going to be thrilled about all those evaluations.
Engage in that treatment and follow through and complete it.
No.
So both parties are required, when they're communicating, to use the Our Family Wizard app. It's a subscription-based app.
Excuse me, Your Honor?
Yes.
I got a new phone because I just got a recently new job for working for the Washington.
For the ones who get it done, the most important part is the one you need now.
Wait, she got a government or state job or county job?
Wildlife. And it is not compatible with my phone. I cannot download it. Can we do it by email or maybe another way besides the Only Wizard app?
Yeah, I would agree with that if I could, because I'm struggling trying to get that to work on my government phone. It just keeps messing it up.
Yeah, it's an issue.
Okay. Do you have ideas of how to communicate? Ms. Corey, do you have an idea?
Government phone, for those that need to know.
There are dozens of other
Government phone, or Lifeline, as they like to call it, is available for every person on low income. That is what we're talking about.
Yeah, but those type of phones are not, first of all, they're not the latest iPhone, they're not the latest Android, and they are, for their purpose is more of what a phone is supposed to be, which is to make phone calls. You can text, but your text may not come through as fast as if you had a regular account. Like it's not it's for convenience. It's not for luxury.
No, not at all. You get free as though it's available for you, but
yeah. But see, here's the problem. They want to communicate by email, and unless you put that gal on the chain, there's no control over, like, you can alter an email and print it out. Like, I wouldn't put that past anybody. I don't know. They're better off they're better off using Discord and only communicate inside of a channel. Right? So that everybody can see what's being said.
Yeah.
But they wouldn't be able to download Discord either. But there's got to be some other method to keep track.
Parenting apps, any of which would be acceptable. If you, one of you guys just want to Google co-parenting app and come up with one, as long as the other person agrees, I'm sure that would be fine.
I'm okay with us communicating over the phone.
Could you repeat again, Ms. Knowles?
I said I'm okay with us communicating over the phone because when I FaceTime Asa, Chris is there. There's no issue.
Okay. I agree with that.
So, Mr. Kulicek, when you say you agree with that, tell me what you're agreeing to.
I'm agreeing with phone calls or text messages as long as we're both agreeing. We'll keep it cordial. I'm okay with that.
Did you have a conditional statement there, as long as if there's cordiality? Did I hear that?
Yes.
So that's been something that's been an issue in the past, and where the co-parenting apps provide a recorded third-party recording and holding on to records, and that usually helps people, not always, helps people stay on their best behavior. And if it's simply text, I think sometimes there's a
Sir, but neither one of us can access it.
Go south fairly quickly. Ms. Knowles, did you have a comment?
Yeah, neither Chris nor I cannot access our Family Wizard. It's been about 4 months since neither one of us have been able to access it.
Right. Yeah, it's like our Family Wizard may not be a good choice. What I'd encourage
maybe you should, since you have a job, get a new phone.
Require that there would be a third-party parenting communication app used by the parties. And you don't have to use our Family Wizard, but you have to find one that'll be compatible with your particular phones. And it may not be like this multi-functionality one like our Family Wizard, but there needs to be some recording of the communications between the parties. I'm not going to leave that to chance, so that'll be required. Also be aware in the parenting plan that if Mr. Kulicek requests a urinalysis or a UA of Ms. Knowles, she'll need to do that within 6 hours.
Oh shit!
And then I think this is particularly important that the parties don't speak poorly of the other parent in earshot of the child, and then you're also to control others within your family from doing the same. And just let me just emphasize that, because when one parent speaks poorly of the other parent and the child hears that, that's a direct attack on that child, because they're half of that other parent. And so when you say parent X is this, this, and this, the child internalizes that, and they may not do it consciously, but internally and subconsciously, it's a direct hit to their stability and their emotional well-being. So both parties are prohibited from disparaging or speaking.
Okay, so when we say that the mother's toxic and cray-cray,
good to say them don't say anything at all. So that'll be part of the order. The child will need to be in counseling and stay in counseling according to the recommendations of the counselor. I'll adopt that kind of amended or maybe clarified for me requirement as far as the father being in counseling, and then also integrating that with the child. So working with the child's counselor and then working with the father and having kind of that joint counseling so that he can be supportive of the child's needs and interests. Also, then once Ms. Knowles is in a position, and well, when the child is in a position for that reconciliation, then there'll be a reconciliation counselor that will help mother and child to reconcile to the degree that they can. And then I think it is wise for the father, Mr. Knowles, Mr. Kudlicek, to complete a parenting class, an age appropriate or developmental level where your child's at, and take that class. I think that would aid, because we could all use a little bit of help in parenting a little bit better. So I will draft that order up and circulate it amongst the parties. And I should have that by the end of this week, if not sooner. So let me ask if any party has any questions. Ms. Corey, we'll start with you.
No questions, Your Honor.
Okay, and Mr. Knowles, do you have any questions?
He's so cute,
Nessa.
That's Mr. Kudlicek. I miss Knowles.
I know, sorry I messed that up. Mr. Kudlicek, do you have any questions?
No, Your Honor.
If he didn't correct him, why did she?
Yeah, I just want to know, are there any other outlets that I can call for my supervised visits? Because it's going on almost 4 months. I've called every single place, not getting a call back. I went in person.
Okay. I would encourage you to check with Ms. Corey. She may have some insight into that. My experience has been that they tend to call back, and if not, then there may be reason for that. But check with Ms. Corey.
She's aggressive in her message.
As far as I know, Reconnecting Families and Parents Place are the only two in Cowlitz County that do supervised visits. There are some also in the Vancouver area, if you're willing to go that far.
Okay.
So I have a question, Your Honor.
Go ahead.
If I have someone that's state approved to already do my visits when it comes in regards to my son, could that person also as well supervise my visits for my daughter?
Supervisor your son now too?
All I'm requiring.
That's probably better.
Yes, sir.
Okay.
Okay, so for professional, does it have, so she's approved through the state, did all the stuff I guess she's just not a professional? I don't know what's considered professional or not.
They charge you money.
What'd you say?
They charge money they charge a fee for their service. They're licensed. Generally they have insurance and the like, so it has to be a professional supervisor. And Ms. Corey mentioned that there's two locally, so I'd encourage you to reach out to them again. All right.
Yep, okay, thank you.
Okay, so I'll get that parenting plan out to the parties. Thanks.
Thank you, Your Honor.
I can't believe there's another here. Oh, this is the bonus. Rebecca pretends to be deaf during her eviction. Oh. So now we have like 9 minutes of eviction stuff. Okay. Wonder how this is gonna go. Oh. Okay, weird commercial.
Okay.
Kind of how we all feel, though.
Oh my God, she's scary. Why does she look like that?
All right, good morning. We're here for unlawful detainer docket. I'm Commissioner Jill Carmy. It looks like I have a message from Ms. Winkles. Columbia River Properties will be a set over, so let me just call that case quickly.
What the hell is wrong with his face? Oh my God. Did you see his face? Game, tell me you saw this man's face.
No.
Please. Huh?
What are you talking about?
Look at this man's face. Hold on.
Carmy. It looks like I have a message from Ms. Winkles.
Look at his face. I swear. And this is better than what I saw before. Because what I saw before, I thought was I thought it was Nightmare Before Christmas. You know, when they have the skeleton face, or like the like Cinco de Mayo, like.
I'm gonna say it. Ready? That's what drugs do to you. There.
I'm just no, like you know how in the cartoons or like the scary zombie movie. You don't watch. He don't like scary movies, y'all. He don't like anything scary.
I'm a coward.
But
I'll
when you have these type of movies and they have like the skeleton, like it's.
Nope, I get afraid.
I swear the angle.
I get nightmares. So.
No, the way that I saw this man's, I paused it at a really good spot, but what I originally saw, I swear to God, I thought it was just bones. I didn't see any skin. It literally looked like the skeleton of Black Eye socket thing. Like, oh my God. Okay. My bad. I'm sorry. It scared the hell out of me. Like, alright, just pay attention to this part of the. I'm pointing at the screen. Pay attention to this part of his. I'm sorry. I'm crying. Okay. It's nice to see that the eviction judges use the same courtrooms as the family court stuff. Too, by the way. Is that the landlord? Oh. What is... Oh, never mind. Okay, anyway. Okay, I'm sorry.
Columbia River Properties will be a set over, so let me just call that case quickly.
Didn't see it.
Number 15 on our docket, 23201.
Look, it's the attorney Winkles. Do you see her? Wait, who does she rep?
It's not.
Oh, that was the other case. Oh yeah, I know. It's the other case, but no, that's Winkles.
Mm-mm.
That's the lady that represented the person from the last case we watched.
No.
Yes, Erin Winkles. She represented the mother with the father, with the son.
I mean, it might be, but I don't
The
think
one.
so.
No, it is her. I'm telling you. We just watched this video for 4 hours. That's her name. That was the attorney that stood in for Jocelyn, and then was replaced by the man for one court hearing. I am sorry.
On 09408. Is there 1 week or 2 weeks?
Let's do a 2 week at this point. I keep getting sicker rather than better, so I'm gonna do a 2 week.
Okay, and then I think we have Ms. Knowles. This is your case, and I see you on there. Dion Rardon and Rebecca Knowles. Are you able to hear the court? We can't hear you.
Oh my God. Okay. Well, he doesn't look this bad face to face.
You might need to hit *6 to unmute if you're on a phone. I know, we don't hear you, ma'am. That's what I'm telling you. We cannot hear you. I can see you.
Oh my God. Unmuting Zoom on a phone is not that difficult. She didn't have this kind of trouble during her other cases.
Okay, hold on. I'm reading something from you, Ms. Knowles.
Maybe she's on a government phone. That'll be her excuse.
Ms. Knowles, I can't hear you, but I read what you've written. You're indicating, can you, ma'am, I can read your lips. I understand that you're using swear words. Please don't do that in court. Does Mr. Rardon, is he able to, can one of you give me a thumbs up if you can hear the court?
They can't hear either.
So Ms. Winkles, the response that I'm getting from Ms. Knowles in her typed statement is that she wears hearing aids and it doesn't work well with Zoom.
Oh, bullshit.
Dental implants hadn't even crossed my mind. I thought I was going to end up with dentures, you know?
Bull pucky. Since when? 2 seconds ago, this was about your sound not connecting, and all of a sudden you're deaf.
So she's asking for in person.
There is a transcription available, closed captioning available for Zoom. In person is bad with me considering I have pneumonia at this point.
Yeah.
I'm not sure in person would ever be a possibility for me given that I get sick more than I don't get sick. But there is closed captioning. Additionally, she has the option of always coming to court since these are open. So I'm not sure why that would stop anything.
Yeah, last time I was here.
Okay. Okay. Here's what I'm going to do. And Ms. Winkles, you said 2 weeks?
Yes.
Okay. I am going to set this matter over 2 weeks to December 15.
She has never had any issues hearing in her family law case before this eviction and after.
Let's see if we have contact information for Ms. Knowles on her.
You can hit AI companion at the bottom and it will allow her to see the transcription, and also show captions will allow her to see the transcript of the hearing as it goes on. So she can hit that.
It says that we've enabled closed captioning. Ms. Knowles, can you give me a thumbs up if you're able to read what we are saying? Okay. We are going to set your case to December 15th. That's 2 weeks from today at 9 a.m. You can come to court in person, but we won't have this type of transcriptionist available that you have on Zoom. So it may
he doesn't have a hearing problem.
You're on Zoom to read the closed captioning.
Yeah.
Your Honor, would you mind if I jumped in as a friend of the court here?
Please do.
Ms. Winkles, any objection?
No.
I don't know if you can read this, but Ms. Knowles, I am a free eviction defense attorney. If you come into my office, we have devices that can, we have deaf translators available for you so we can communicate. I understand that calling into the line may be challenging for you. So if you could stop by my address, which I will put in the note, or which I will put in the chat, we can get you set up with an attorney, okay?
Okay.
I feel like I'm taking crazy pills watching this woman act like she's stone cold deaf. Her Zoom sound doesn't work, and she turns that into being deaf.
I mean,
actually, what I'm more amused about is the eviction attorney ambulance chaser.
Oh yeah.
Like, ooh, opportunity, right?
Yeah.
Like, dude, let's not solicit people when you don't even know what the fuck they're there for. You know, an accident is a little bit different, right? But she might be getting evicted for a good reason.
True.
Oh, Lord have mercy.
Ms. Knowles, I will put the address into the chat again. Please stop by. We have deaf interpreters.
That's why.
She's not deaf.
Okay. Thank you, Mr. Kiernan. We will see the parties back on December 15th.
All right. Thank you, Your Honor. I don't think I have any other today. That's it, correct?
Oh, let me just take a double. Yep, that is it.
All right. Thank you, Your Honor.
Feel better. Okay, I'll turn it over to the parties now. Are there any other requests for strikes or setovers? And we'll take care of those matters first.
Your Honor, I have a couple of.
He's not going to get any more help.
I need to take a case that's in the courtroom. We have some hearing accommodations, and Mr. Kiernan needs to take this case so then he can get back to his office for other cases. So Mr. Kiernan,
So she
let's
could
go
have
ahead
deaf
and take number
accommodation.
4.
Okay. So
I believe that's with
the
Ms.
court-
Winkles. Is she present?
So who does
Or maybe Mr.
Winkles?
Nelson is covering today?
I am. Miss Winkles is ill, and so we're asking for a 2-week set over if that can be done.
Mr. Kiernan, what would be your position?
I guess I would not object to a 2-week set over. I was under the impression that they were going to be striking this hearing. As long as, that means that Miss Knowles still has the right to be in the house. We're okay with that.
Okay. And by
I'm sure it does. So that's so if it can be put over to December 29th, that would be great.
Okay. Do you want to talk to her first?
Yeah, can I talk to her?
Yeah, we're just going to give Mr. Kiernan a minute to talk to his client.
Yeah, fine. Yeah, that's acceptable.
Okay. So we'll have the parties back December 29th, 2023 at 9 a.m. Ms. Knowles, did this accommodation work better for you than Zoom?
Yeah, but these died halfway through it, so I think I'm just being in the room is a lot better.
A lot better, okay.
Can you repeat the date and the time, please?
So yes, Friday, December 29th at 9 a.m.
And that will be in person too as well, right?
Correct.
Okay.
Okay.
All right, great.
So we'll have you back. Anything else on this matter?
She can appear in person if she wants, so I don't
Okay.
know why she
Thank
needs to
you.
turn it into a whole big thing.
Thank you. And then Mr. Kiernan, do you want to?
There was no sign of Rebecca or Ms. Winkles on the December 29th docket. They must have come to some sort of agreement. Yeah.
Stay in the courtroom
she
for your
moved or
other
she got
cases?
kicked
So
out.
I am essentially going to be arguing a continuance on the 2.
Oh. Okay, that wasn't too bad.
There was no more information, I guess.
No, they didn't have anything about her eviction.
Mm-mm.
And I'm guessing they didn't have anything about the dad or the custody. But keep in mind, right, that we don't know the dates of those hearings for her custody stuff.
True.
So Washington eventually went back to, I think they said November 1st.
Yeah, they went back to.
I think of 2024. They went back to in person. So they would have to like actively look for the case information to figure that out.
Yep.
So all right, so give me I think based on the time that's going to be it for you.
Yep, this is gonna be it for me today. I'll catch you guys all Monday, actually. So I will be back on Monday. Ta-ta.